Good morning, everyone. I call to order this regular meeting of Council for Tuesday, July 8th, 2025. I would just, first of all, like to turn my attention to the land that we're on. I had the privilege of riding in the Canada Day Parade with a couple of Stoney Nakoda elders, Henry Holloway and Jackson Wesley, and we had a great time going along the route. It was actually their first time ever in a parade, and to be near the front there was quite something, and I got to learn about how Elder Holloway used to ride bucking broncos in the rodeo, and was a calf roping specialist as well, and hear about those parts that you just wouldn't get an opportunity to hear about. And it's so important to remember that there have been people on this land for thousands and thousands of years. And so in the spirit of truth and reconciliation, I acknowledge that we are gathered in the heart of Treaty 7 territory of southern Alberta. This land is home to the Blackfoot Confederacy, consisting of the Siksika, Kainai, and Pekanai First Nations, also the Tsuut'ina First Nation, and our most adjacent Indigenous neighbors, the Stoney Nakoda, comprised of the Bearspaw, Goodstoney, and Chiniki First Nations. Further, we are located within the Rocky View Métis District within the Battle River Territory, District 4. The town of Canmore is committed to work to live in right relations and to advance truth and reconciliation as we acknowledge the many Indigenous peoples whose footsteps have marked these lands for generations. I'm grateful for the traditional knowledge keepers and elders who are still with us today and those who have gone before us. As we are all treaty people, we each have ongoing responsibilities to protect and honor all life. Turning now to the agenda, there is one change, and that is a postponement of item H2, letter of intent for conservation easement. That will be put over to a future meeting. Any other changes? All right, so with that amendment, I will move that we approve the agenda for Tuesday, July 8th, 2025 as amended. All those in favor? Carried unanimously. Okay, we'll now get into our public hearings. Let's see here. Okay, the first one is with respect to, I'll call to order the public hearing for Bylaw 2025-22. The purpose of this bylaw is to amend Council's vital homes policy. The public hearing will proceed as follows. After I provide this introduction, administration will provide a summary of the matter under consideration to set a context for the hearing. Council will have opportunity to ask questions of administration after their presentation. Then I will invite members of the public to speak. There will be an opportunity for Council to ask questions of clarification after each speaker presents. Once anyone present who wishes to speak has done so, the municipal clerk will provide the names of those who have provided written submissions. Then Council will again have the opportunity to ask questions of administration before the public hearing is closed. And so with that, Ms. Smithers, let's have the administration presentation. I know it's just a brief one.
Thank you very much, and good morning, Mayor and members of Council. I'm just here to give a quick overview on the key changes to the land use bylaw that are related to the public hearing today on the regulation in the bylaw relating to perpetually affordable housing, or vital homes in our more colloquial naming. The key changes in the bylaw that are in front of you today relate to renaming Section 12 from density bonusing to perpetually affordable housing regulations, just reflecting that that section deals wholly with PAH and not density bonusing on a more global level. The changes allow for provision of cash in lieu units by removing the bylaw statement that does not allow for cash in lieu. We work towards a consistent definition of perpetually affordable housing. So currently, PAH is defined in both sections 12, which relates to the the PAH regulations and Section 13, the definitions. So we're just going to use it once in the definitions, Section 13 of the land use bylaw. The changes give precedence or recognize the precedence of statutory plans that have unique bonusing provisions for PAH outside of the land use bylaw. And we've also reorganized it for readability. So those are the key changes you're looking at. And that is the end of my presentation.
Great, thanks. And I know that you'll be having a further presentation before we consider the second reading of this matter as well, because you'll then address the other policy change. All right, so are there any questions of administration before I move to seeking speakers? No, thank you very much. All right, then, so this brings us to the public verbal submissions. Just checking to see if there's anyone here that wishes to present or speak to this matter. Seeing none, I will then close that portion of our public hearing and turn to the clerk's office to determine, are there any written submissions?
We didn't receive any written submissions for this item.
Okay, no written submissions. So with that being the case, no speakers, no written submissions, I close this public hearing. I'm now going to move or call to order the public hearing for Bylaw 2025-21. The purpose of this bylaw is to amend the land use bylaw with respect to tourist home enforcement. As I have just spoken to with the previous hearing, after this introduction, administration will provide a summary, council will have an opportunity to ask questions, then I'll invite members of the public to speak. Once anyone present who wishes to speak has done so, the municipal clerk will provide the names of those who provided written submissions, and then council will have an opportunity to ask questions before the public hearing is closed. And so with that, Ms. Miller, welcome, and over to you for the administration's presentation.
Thank you. I will also be brief. So just a reminder that the key changes that will be made with this amendment to the land use bylaw will be around updated contraventions as to what constitutes a contravention, including advertising of a tourist home without a development permit, updated fine amounts, and the removal of it being tied to a calendar year. Oh. Sorry.
There we
There we
go.
go. And updated characteristics as to what constitutes a tourist home and being far more prescriptive within that definition.
Great. Thank you very much. Before you sit down, just looking to see if council has any questions. Seeing none, thank you very much. Before I go through my introduction to public submissions, is there anyone here that wishes to speak to this public matter? Mr. Clerk, I know that we had a couple people registered. Have you heard from them at all?
I have not, no.
Okay.
They're told to come to my 9, but I haven't seen
Okay. All right. And they were to be in person? Okay. All right. Well, seeing that there is, Councillor Faubert?
The agenda does say 9:35 for the public hearing for this matter. So if people were trying to arrive, but I don't think that matters. I just wanted to point it out that if
Yeah.
the meeting starts at 9 and the timelines on the agenda are
Yeah, I
not.
believe they were told directly to be
Yeah.
here for 9, though.
Okay, perfect.
And, yeah, so I'm seeing nods from administration that in fact they were told directly. As we all know, and thank you for bringing it up, the times in the agenda are simply potential guidelines. All right. All right, well, seeing that there's nobody here then, I will ask if there are any written submissions.
we didn't receive any written submissions for this item either.
Okay. You know, out of an abundance of fairness, I'm just going to bounce an idea off the clerk's office and the CAO. Just in case people showed up at 9:30 or 9:35, despite being told 9 o'clock. What I think I would like to do is I would like to what's the proper wording that I would use? Would I adjourn temporarily? No.
I think you can just leave it open.
Yeah.
Go ahead. Thank you.
Ms. Hyde?
Thank you.
I'm thinking of taking a break now, continuing the rest of the agenda, and then at about 9:40, whether somebody's shown up or not, we can move back to this matter and conclude it.
I think you just don't have to close the hearing until you're satisfied that you've heard from everybody.
Okay, so basically, I'm going to call a break to the hearing so that it can be noted in the minutes.
Yep.
And then we will, and if, I'm just looking to council to see if there are any objections with me proceeding this way. I want people to have the opportunity to speak if they are wanting to do so. So we're going to take a break from the second public hearing. We're now going to move back to our agenda matters and proceed for the next 30 minutes. And then we will conclude the public hearing at that time. All right, so we'll move on to item D, approval of minutes. And this is the, first of all, the minutes of May 6, 2025. It's been amended, as noted. Are there any other errors or omissions that people note? Seeing none, I will move move approval of the minutes of May 6, 2025, regular meeting of council as amended. All those in favor? Carried unanimously. We'll now move to the minutes of May 27th, 2025, special meeting of council. Any errors or omissions? Seeing none, I move approval of the minutes of May 27th, 2025, special meeting of council as circulated. All those in favor? Carried unanimously. And finally, the minutes of June 3rd. Any errors or omissions? I will then move approval of the minutes of June 3rd, 2025, regular meeting of council as circulated. All those in favor? Carried unanimously. Thank you. Okay, we'll move on to unfinished business. Item F1, Silvertip Block 9 residential development. And welcome back, and the floor is yours.
Good morning, Mr. Mayor and members of council.
Feel free to move the microphone down, pointing directly to your mouth.
I need a stool.
Yeah, you can. It bends. It bends. There we go.
I just did want to confirm whether or not there was a need for a presentation, if you'd like a presentation.
I don't think there's a need, but I would like to open it up for questions. Councillor Faubert, you have a question.
I do have a question. Thank you, Your Worship. I have a question around a previous development in the Silvertip subdivision area that is a similar characteristic potentially to the ones that would be allowed under these changes. And I believe it was called the Pinnacle. Do you recall that development permit? Is there any information you can share with council around that building's design and height?
Yes, thank you for the question, Councillor Faubert. I did look into that development permit application. The file isn't too hefty on that one. It does not appear that it is at the same height, but it is similar in character. 1 story short was what would be maximum allowed by this height change.
Great, thank you. Any other question? No? Any other questions of council? Councillor McCallum.
Thank you. Thank you, Jenica, or, sorry, Ms. Collette.
Ms. Collette.
That was rude and out of character for me. Thank you for, I watched the presentation after the fact at the last, when we tabled this, or you guys tabled this. So my question that I wanted to confirm is that with this change, there is no increase in doors, like number of units area of units, square footage, that basically the proponents are essentially looking to take this development and build up instead of out.
Through the chair to Councillor McCallum, that is correct. The density in terms of units for this particular area, which is Block 9, is determined by the Silvertip Area Structure Plan. So that includes the particular parcel that we're looking at and across from Mountain Tranquility Gate. So the total number of units is determined by that, and there's no change to that under the Land Use Bylaw Amendment. So it is just
So
a change to
it's
the
just
structure.
about the way it's shaped as opposed to how it's shaped.
Correct.
Right. Thank you so much.
Thank you, Councillor. Just a quick question of the clerk's office. Is there any chance, is there a volume that we could just turn up the volume from the mic? I don't know if you have that ability or not. Yeah. Just straightening a little bit. Thank you. Okay. Any other questions? Seeing none, thank you very much, Ms. Klett. Okay, so I'll move that council give second reading to revised land use bylaw amendment 2024-20, Silvertip Block 9 residential development. Following as per the questions asked, this is a development in which there's no change in density or types of usage. We're really talking about change in the built form to allow a variance to allow it to be taller instead of broader. I believe that this is fitting with the character of the area. There have been another example, but there's also, quite the variety of high-end product up on the hill. I know that there was a concern about sight lines. I don't believe that the sight lines of those up slope from this development will be adversely impacted. Also, there was concern about possibly being able to see this development more. I live on Moraine Road, and I get a wonderful view every day as I'm coming downtown of the southern side of the valley. You can see a lot of it. You can, in fact, see all of it. You see the peaks, you see where the new development's going, you see the golf courses, you see everything. That's what happens with development. Something gets built and you see it. What I like about this is that it's actually going to disturb less of the ground. And so I think that there's a positive in that regard, while not changing any of the other key elements such as usage and density. So I will support this second reading. Would any member of council wish to speak to this motion? Councillor McCallum.
Thank you, Your Worship. Considering I was the one that was missing, I think I'm the only one that hasn't spoken. So I will be supporting second reading. My biggest worry was whether we were expanding the square footage or the number of doors or anything like that on this, but we are not. It is just building up as opposed to out. And in terms of the wild spaces that are around there, I think that it's a much better to not disturb land and have a smaller footprint than what was proposed originally through the ASP. So I will be supporting second reading. I will say, though, having watched the last meeting,
Because I was concerned that it would be a 3-3 tie, and when you're dealing with a quasi-judicial process in which people's land rights are involved, I thought it best to give it best opportunity to actually hear, and if it's going to be defeated through having a majority of council opposed to it, as opposed to it being tied. That was the decision of council at the time, and it was supported at the time. So I appreciate your perspective, but of course that was and appropriate procedure.
But it also, who's your
Councillor
honor? I don't know
McCallum.
who that guy
Yeah,
is.
Councillor McCallum.
He hasn't been here for a long time. But I would still say that democracy, even through the process, we have a process that was democratically put together, that we approve, that is within the MGA and so on and so forth. And even that is still a democratic process because it's within the process that's approved. So either both are democratic, but I think it was just, in terms of trust, icky.
Okay, well, thank you very much for that. I think that that's speaking against the decision of council last time, but you weren't here to speak to it, so now you have. Would anybody else like to speak to the matter at hand here of second reading? Seeing none, I'll call the question. All those in favor? All those opposed? The motion is carried with councillors Graham, Mera, and Ma opposed. I'll now move that council give third reading to revised land use bylaw amendment 2024-20, Silvertip Block 9 residential development. Would anybody like to speak to the motion? Seeing none, I'll call the question. All those in favor? All those opposed? The motion is carried with councillors Graham, Mera, and Ma opposed. Okay, it's not yet 9:40, so we will move on to item G1. This is the Vital Homes Amendments, revised land use bylaw and council policy. Ms. Smithers, welcome back to the podium. And now you have a larger presentation for us to bring in the policy elements of the Vital Homes changes.
Yes, I do. Hello again, members of council. So I'm here now to talk about both the revised land use bylaw and the council policy amendments that are in front of you today. This is a longer but still somewhat brief presentation, as I gave a more fulsome presentation last month when we introduced the bylaw for first reading, so I'll just recap that, and then I'm happy to answer any questions if needed. So just as an overview, council policies are reviewed once at least every 4 years. In reviewing the Vital Homes policy of council, we realized that some of the upgrades and changes we wanted to make required amendments to the land use bylaw. The policy upgrades also reflect the creation of a new CCH bonusing policy so that Canmore Community Housing has more direction over the developer-initiated units. And this was a very collaborative process of reviewing the council policy, the bylaw, and the creation of the CCH policy with both development industry and CCH representatives. And I also want to note that many of the development industry representatives are former CCH board members, and I personally really appreciated the contributions that they were able to make to the discussions. So the objectives of both the land use bylaw and the policy review were to put the policy in the policy, so take policy statements out of the land use bylaw and move them into the Vital Homes policy, to give authority to the most suitable decision maker, and just acknowledge when some of the decisions around provision of developer-initiated units are best led through CCH. We wanted to ensure reasonable benefit and flexibility for the Vital Homes program, both for CCH and for developers. So this led us to, for example, including cash in lieu instead of provision of units, if that meant that CCH could get, for example, a 3-bedroom unit that would have caused a developer to reformat a whole floor plan because they were only providing 2-bedroom units. It just allows more flexibility. We also had an objective to ensure reasonable bonus pricing structure for CCH and industry, and then develop standardized, clear processes and agreements with CCH, and also consider additional incentives for the industry provision of units. So the key changes to the land use bylaw I went over just a few moments ago, so I won't do so now, but they're repeated here on the screen for you. Key changes to the policy include the addition of a bonus unit guidelines section. So that's where we took the bonus unit provisions out of the land use bylaw because they were more suited to being in a policy document, and we've moved them into the council policy. We made a change that gives the authority for determining the build rate prices for Vital Homes to Canmore Community Housing. As I spoke to last month, they're in the business of building housing, and they have a better sense of the cost of housing, so they're better suited to have that authority for determining the build price rate. And then another key change is separate from the council policy, but CCH has created a Vital Homes acceptance of developer-initiated units policy that has been approved by their board, and it guides the integration of those kind of bonus units through the land use bylaw into the CCH portfolio. So with that more comprehensive review of the Vital Homes policy and then the related changes to the land use bylaw and the creation of the CCH policy, the recommendations in front of council today are to give second and third reading to revised land use bylaw amendment 2025-22 Vital Homes, and that council approve Vital Homes policy PD 008 as presented. And I'm happy to answer any questions.
And they're already lining up. Well, Councillor Graham is. So Councillor Graham, you have a question.
Thank you, Your Worship. Ms. Smith, just to close the loop on the question I asked last meeting, and you and I have talked about this prior to this, but just to close the loop for the public, my concern around median incomes being determined for pricing for CCH. I wonder if you could just talk to that a little bit for the public.
Sure, and thank you for raising that. So the question put to me in June was, really came down to a concern that there could be a higher proportion of households at the low income range of household income, and then a higher proportion at the higher range of household income. So there'd be a bit of a valley in the middle, and if we were taking the median, are we focused in that valley? So I went back into our community monitoring report and also had a conversation with Chris Mathieu, the ED at Canmore Community Housing. And the profile is kind of that bell curve that you would tend to see for distribution of household incomes in the community based on the latest available StatsCan data. I think the median household income is currently around $130,000.
Yeah.
Yeah.
Thank you for addressing that. I really appreciate it.
Yeah, no problem.
Okay, any other questions? All right, thank you very much.
Okay, thank you.
So I will move that council give second reading to revised land use bylaw amendment 2025-22 Vital Homes. In speaking in support of this motion, I would like to first of all give appreciation for the process that was used between collaboration between CCH administration and with input from interest holders such as BODA, and I believe that the changes are really have a really good rationale to them, and takes the organization of these policies and this bylaw to the next level. Would anybody else like to speak to the motion? Councillor Ma.
Thank you, Your Worship. I just wanted to say thank you as well. I think the collaborative process between BODA and CCH and administration was really helpful, and hopefully setting a framework for future collaboration down the road. And at the end of the day, we have a much better process now, and hopefully we can monetize or get more units in a more ready way. So we're happy to support. Thank you.
Thank you, Councillor. Councillor McCallum.
Thank you, Your Worship. I'll be supporting a second reading of this. I did have an opportunity with Mr. Mathieu to attend one of the stakeholder or interest holder meetings, and I found it, and believe it or not, I kept my mouth shut. But it was really interesting to see all these people that have been involved in, as developers, been involved in PAH in some way, and some of them had very different sort of perspectives as to how it should run, but it was very respectful, it was all solution focused, and I really believe that this new policy has an opportunity to be responsive to how different developers might create different kinds of product. and how that product may or may not align with our program in terms of what our waiting list clients need. And so I am, again, happy to support second reading and look forward to seeing the market respond to this, because it will respond to it. Thank you.
Thank you, Councillor. Anyone else wishing to speak to this motion? Seeing none, I'll call the question. All those in favor? Carried unanimously. I'll now move that council give third reading to revised land use bylaw amendment 2025-22, vital homes. Would anybody like to speak to this motion? Seeing none, I'll call the question. All those in favor? Carried unanimously. I'll now move that council approve vital homes policy PD-008 as presented. Would anybody like to speak to this motion? Seeing none, I'll call the question. All those in favor? Carried unanimously. Okay. We're going to keep going forward. I have been advised that the two registered speakers for the public hearing are on their way. And so we will continue with that public hearing after they arrive. So we'll move on to item G2, which is revised land use bylaw amendment 2025-21 tourist home enforcement. By the way, I will note, what's that? That's the public hearing. We can't do that. Oh, yeah, that's right. I'm sorry. And I do not want to get into the Connect Downtown just yet. In that case, we are going to take a break. Let's take it for 10 minutes, and I expect that they will arrive by then. So we'll come back at 10:42 or 9:42. Clerk's office, let me know where we're streaming again. Okay. All right. We are back. Okay, we're going to now return to our public hearing, the second one of this morning with regards to revised land use bylaw amendment 2025-21, tourist home enforcement. This is item B2. Before we took a break, there was an administration very brief summary, and now we are going to move forward with the public submissions. Council would like to hear from everyone who wishes to speak today. In that spirit, we'll be enforcing a 5-minute time limit on presentations, not including time for questions from council. We'll use a countdown timer to help us stay on track. If you plan to speak, you should be aware that you will appear on the live web stream of this hearing, and the recording of this web stream is published online. While you are speaking, we ask that you direct your comments to council and limit your comments to the subject of the public hearing. Council will be given an opportunity to ask questions of clarification after each presenter has finished speaking. We ask that speakers and members of the gallery join council in supporting the rights of everyone to be treated with dignity, fairness, and respect. That includes not responding with either cheering or admonishing, as such will impact the feeling of safety of others who may wish to speak for or against. As chair, I will intervene if necessary to uphold these principles. Now I will open the floor to speakers. We have 2 registered speakers. Mr. Tomlinson, welcome, and whenever you're ready, the microphone is yours.
Thank you, Mr. Mayor and Council and Administration for letting me speak today. My name is Sean Tomlinson. I'm a resident of Canmore since 2002, which is 23 years. In 2011, I actively participated in public hearings, speaking out against illegal tourist homes. I support the town's council effort to draft a bylaw to address this issue. Fast forward to September 2023, I found myself wrongly accused of operating an illegal tourist home. What I quickly discovered was a system with limited recourse. No arbitration, no straightforward way to contest a ticket. My options were stark: either pay a $10,000 fine or go to court. I knew I was innocent and I wasn't running an illegal vacation home, so I chose to fight the ticket. Incurring a $5,000 legal fee, I even refused a settlement offering what would have required me to plead guilty because I was innocent. So I chose not to take it. After a year and a half, we won our case. Not only that, but the judge issued a written decision declaring the town of Canmore's bylaw to be ambiguous. Today, we are reviewing the updated bylaw, and its implications are deeply concerning to all Canmore residents. I have some scenarios to put into perspective. One of the bylaw is tourist home means a dwelling unit operated as a temporary place to stay with or without compensation. Have you ever had a friend or family visit you in Canmore and stay in your spare room? Perhaps you've shown them your favorite hike. Under these definitions, you could face a $10,000 fine for running a tourist home. Another scenario, bylaw, the occupants of the dwelling unit intend to stay or do stay in the dwelling unit for vacation purposes rather than residential purposes. Here's the scenario. What if you're going on vacation and your brother's family is coming to town, so you let them use your home? That's another potential $10,000 fine, even though you are a true resident and your family's coming for vacation. And then the last one is the bylaw. The dwelling unit has the potential to or is generating income for a registered owner or agent. Under this most extreme interpretation, simply owning a home in Canmore could lead you to a $10,000 fine because your property has the potential to make money. You can rent it long-term, that's potential to make money. You can rent out your driveway or your garage to another resident, that's potential to make money. Every house has potential to make money. These new definitions are not just flawed, they're actively harming all Canmore residents. While town council and administration may claim this isn't their intent, the reality is that every new person who works for the town will interpret these ambiguous bylaws differently, leading to arbitrary fines and undue stress for homeowners. Town council must vote against this bylaw. They need to direct administration to draft a bylaw that clearly defined and does not penalize the residents it is meant to serve. Recommendations. I would suggest setting up an appeal process instead of incurring legal costs for the town and using my taxpayers' money to fund that legal fight. We actually already have a committee called the Enforcement Appeal Review Committee, which reviews every 30 days after submission. So I suggest that before going to court, actually have a third-party arbitrators to look at it and see if it's even worthy to go to court. And if it is, then you can go to court. Thank you.
Thank you, Mr. Tomlinson.
Yes.
I'm just taking a look here. Thank you very much for your
Yep.
presentation.
Thank you so much.
Any questions? No. Okay, thank you very much. Ms. Sharp. Welcome, and whenever you're ready, the microphone is yours.
My name is Charla. I became a landlord. I moved to Canmore in 2002 and became a landlord in 2005. In 2011, I started writing emails to the town of Canmore. That was 2011, 14 years ago. I started writing letters to council and administration for tourist home enforcement, as the writing was on the wall as to what a lack of enforcement would result in for this community. Over those years, that meant that I attended public hearings. I attended the SDAB committee hearings. In addition, I attended meetings with Mayor Sean Krausert, who was councillor at the time, and then Mayor John Boroman. It was interesting to me that Sean Krausert recently mentioned that meeting at one of your council meetings because he did remember it. I was the local home operator that brought this up back then. I've been concerned about this issue for quite some time. You might be surprised to know that I wrote the copy on the tourist home website at the town of Canmore because at the time the planning committee stated that they didn't have enough time to write a general guideline, not a bylaw, but a general guideline. So I said that I would write it. The copy that exists on your website today are my words. I also attended every session of the court hearing that led to this public hearing, including all witness testimony, and I was there for the judge's interpretation of the town of Canmore's bylaw. I also testified as a witness. Unfortunately, no representative from the town of Canmore was present for the full proceedings, aside from 2 witnesses who were only present for their own witness testimony. It's disappointing to me today to see that no members of our community are here. But this issue remains to be important to me. In reviewing the first draft of the bylaw, it seems to me that the town has misinterpreted elements of the court's written decision. As a result, the first draft of this bylaw serves only to further complicate and obscure this issue, as well as create significant issues for residents, tenants, and specifically immigrants. I will get to that in a moment. Wrong page. The court found that the previous bylaw was ambiguous, specifically in how the town defined what makes a property a tourist home. The Crown Attorney, on behalf of the town, had argued that if any one of the several listed activities occurred, the property met that definition, and the judge disagreed. In this first draft of the bylaw, the town of Canmore has now split each of those definitions into a separate line item, saying that any one of those could result in a fine, but that is not what the judge indicated in court. In response, for example, one line states that a property is a tourist home if the owner accepts electronic payments, but it's 2025 and almost all tenants pay for rent via e-transfer, apps like Wise and Venmo. Under this bylaw, a landlord using these common tools would face a $10,000 fine. That opens the door for disgruntled tenants to weaponize the bylaw, triggering investigations based solely on the rent is paid, how the rent is paid. Another line item indicates that all rental websites are banned, including Facebook. That is a problem. That is where local residents are finding homes. And when we hard code, meaning we write it actually into the bylaw, a list of websites that are not allowed, it would mean, I think, that your bylaw has to just be rewritten constantly. Websites come up so quickly that you couldn't possibly write a bylaw that would list all of those websites. Sorry, I'm totally going to run out of time. I have a number of recommendations, and I've had those recommendations for years, and I'm going to fast forward to the part where I say, please consider these. The town of Canmore has recently made that all tourist homes have to have a business license. We do. As well as a development permit if you're a tourist home, not visitor accommodation. My recommendation would be that that wording needs to appear on all written ads, regardless of what website they are on, so that when someone tries to enforce this bylaw, they can quickly see on the ad whether this property is registered or is not registered. I would further propose that in the case of a residential property, which clearly wouldn't have a business license or a development permit, that a specific wording indicated by town council and administration be included in those ads as well, so that you can trace anything that you deem to be an illegal tourist home as an illegal tourist home. I am absolutely going to run out of time to explain to you why this specific bylaw would really harm immigrants, and I do hope that after this that you might consider those comments. I realize that I only have 5 minutes to speak. Okay. Okay, thank you. Here's the thing about Airbnb. I recognize that everyone in this room believes that Airbnb is only a website for short-term rentals. I actually predate Airbnb. That makes me pretty old. When Airbnb started, it was absolutely a company that focused on short-term rentals. Since that time, it has expanded into providing monthly rentals. That's not the only thing they expanded into. They also expanded into providing experience and connections for other people. This is the expanding into the experiences thing is actually only within the last 3 months. Here's what I'm concerned about for immigrants. I did ask several local immigrants to come and speak, but unfortunately, they have to work, aren't comfortable speaking to council. There's a number of reasons why they're not able to be here. I'm going to try and do my best to speak on their behalf. Our company rents short-term, mid-term, and long-term rentals. We do it all. We have seen an absolute increase in complaints, specifically from immigrants, with regards to rental fraud. Now, I'm going to go ahead and assume that everyone here maybe owns their own home, so they haven't had to deal with this. What's happening for the people that come here, specifically the young people, and the reason I say immigrants is that they don't speak English as their first language, they're here without a support system, and they're not familiar with Canada's laws. They need a place to live once they're granted a work permit in Canada, which forces them to look online. When they look online, their only choice is to find someone that will happily arrange for their apartment if you send them money in advance. This is where Airbnb can help those people. I am certainly not suggesting that the town of Canmore open up the doors to have every property be a tourist home. We saw this firsthand this summer when a couple, proper residents with work permits, with job offers in town, came to town. They rented one of our short-term rentals for the 5 days between their plane landing and their new lease starting. In that time period, they started asking us for extensions. We didn't understand why until we asked them. The answer, they showed up for that long-term tenancy and that place did not exist. Their money was gone. That is just one story. We have hundreds. We do our best to help these people, but the reality is we simply don't have enough time. If town council first would consider actually writing finally a concrete, not ambiguous bylaw that both protects the residents, the actual tenants of this town, as well as municipal enforcement, who I'm sure is not enjoying having to enforce a bylaw that's really loosely written. The reason why I mention Airbnb, you cannot rent a property on Airbnb and have it be fraud, because Airbnb holds the money in trust between the day that you pay it and the day that you show up and say that property actually exists. This is why people have been doing it for monthly rentals, because it presents a secure marketplace. When Town of Canmore puts in their bylaw that absolutely no property can be advertised on Airbnb, what it unfortunately ends up meaning is that everyone is pushed to this underground market, which allows for that fraud to continue. The previous 2 versions ago of this bylaw, there was what was known as the 28-day rule, which went away a while ago. I understand why the Town of Canmore took it out, because people were abusing it. But if you can find a way to very clearly write a bylaw that says, if your home is on Airbnb, maybe it needs to be registered with the town so municipal enforcement knows what's going on. They have a registry of the people who have legitimate homes in town that they legitimately rent to local residents. It reduces the opportunity for that fraud and also somewhat helps your affordable housing issue. I know that that's a stretch, but the people that are coming to this town to work predominantly in hospitality jobs, frontline workers, lower paid positions, they need a bit of protection. And unfortunately, under this bylaw, the way it's written currently, you are going to remove every possibility that a legitimate landlord has to legitimately advertise their place on a rental site. Once you do that, you increase the opportunity for fraud because everyone has to get pushed to any other rental website. And I believe as the bylaw is written right now, I'm saying it from memory, there's a line item that says any rental website. Was it the town of Canmore's intention that Rent Faster would have been excluded because that's a rental website? These are some of the concerns that I have with that bylaw. So I certainly hope, thank you for allowing me a few more minutes. The first draft of this bylaw, although I absolutely support tourist home enforcement, but the first draft of this bylaw has missed the mark.
Thank you, Ms. Sharp. Looking to see if there are any questions of council. Councillor Graham.
Thank you. Are there, I've been out of that market for a while now. You know, I just recently rented a room out for a few months. I put it up on Facebook Marketplace, and I had some lady from Toronto wanting desperately to rent it, happy to send me money. You know, we see this scenario happen all the time. Are there any other tools right now to have money put in trust before, like I think this is a great feature of Airbnb. I don't know that it's the place that I would do it.
And that I agree with. I mean, this is a matter of public record and I rely on Airbnb for my income. Let's hope they don't find this. I would love for Airbnb to not be a company. However, this is the place right now. Do I know of any other place where you can put money in trust? So with a property manager, but then that limits, right? Under Real Estate Act, a property manager holds money in trust for someone else. However, if you were renting a room, you were not hiring a local property manager probably not. And that would be one avenue. Off the top of my head, I cannot think of another one. And I'm open to suggestions because we would like to educate people when they contact us about rental properties because we end up with the what happens when they get into trouble already. Mm-hmm. And so we've been trying to be more proactive to be like, don't get yourself into trouble. We have a page on our website that directs people to the town of Canmore where you can find a business license, federal website where you can find someone's GST number. We do all of that. But in direct answer to your question, to the best of my knowledge, the only other place is VRBO, but I didn't suggest them because vacation rentals is literally in the title of their company name.
Maybe, are we still using Happy Pad? Is that still, no?
Let's
Thanks.
stick to questions that the attendee can answer. Councillor McCallum.
Thank you for your presentation, Ms. Sharp. I was wondering, and I'm not a landlord in Canmore, I am in BC. Do you require a business license to be a landlord? Not in terms of living in your home, but like renting out the whole home?
To the best of my knowledge, no. And I've never seen, even outside of Canmore, I've never seen a jurisdiction that requires that. Personally, I think it's a great idea. Because what would be nice is if we had a registry of these are the legitimate places where someone has shown up to town council, filled out a form, presented ID, and taken some action. I personally would love to see that. I recognize that the public hearing is for tourist homes, but it's always been my understanding the tourist homes were identified as an issue because it affects affordable housing. And so the two do kind of roll hand in hand. I'd really like to see some better bylaws for what you've just suggested. It would mean that people could go to the Town of Canmore website and look up their landlord's name and see whether or not they're at least registered.
Yeah, because that's all it would do is
That's all it would do.
It's a legit name.
But when we look at the situations where people are coming from other countries where they have no way to verify,
Yeah.
right? Even a Canadian, I mean, But it takes some level of sophistication to know that you could, for $10, you could go search the title of a house, right? Most Canadians don't know that, let alone a visitor to our country. So I think your suggestion is a good one. Business licenses for everyone
that's
that's.
possible. I just was curious. I don't know.
I don't
You
know
and
if
I have
it's
been talking
possible
about
either,
this since
but I love the suggestion.
Early, mid-2010. So I appreciate you coming to council today. Thank you.
Councillor Ma?
Thank you, Your Worship, and thank you, Ms. Sharp, for presenting. You brought up some interesting points and some thought-provoking pieces. At one point, you mentioned that you've seen the situations where people have been taken advantage of hundreds of times. Was that hyperbole, or is that, like, in your honest experience, really what you're seeing? Because that's a magnitude of seriousness that totally gives me pause to think about.
In my honest experience, it is hundreds of times, and we don't seek out those stories. What has happened as a side effect of my involvement with land use bylaws and my knowledge of the Real Estate Act, it meant that local people knew to email Charla. That's how I know about them. No, we're talking about hundreds of times. If you had a public hearing to hear from immigrants who are dealing with housing issues, if they were able to get the time off work, I would hope that they would show up and tell their real story. But yes, it's hundreds of times a year, to clarify. Like, it's not like hundreds of times over the 20 years I've lived here.
Right. Okay,
It's
thank you.
annually.
That's super helpful to know. And I guess with regards to Airbnb, because I don't really like list anything on Airbnb, are there provisions on that where people list solely under certain timeframes, such as like X number of weeks or long term? I'm just trying to understand how people are using that platform, because I'm not super familiar with it in the same context you are.
I thank you for your comments, and I'm happy to reply. In Airbnb, a host, which would be a homeowner, maybe a property manager, they are required to list a minimum stay. Now, obviously, if it's truly what we know as a vacation rental or a tourist home, their minimum stay might be as minimal as one night. Yeah. That minimum stay can be set to anything that the host wants it to be, and that might be driven by town council. We see that in other jurisdictions. There are some jurisdictions that have it set at 28 days, some at 30 days, some at 60 days. In my perfect world, then yes, those properties would be allowed to be managed on Airbnb, and that local municipal enforcement would absolutely either issue a fine or a warning the moment they find the listing that says otherwise. That means that users, meaning people who need rental accommodation, can search on Airbnb for their 30, 60, 90-day stay, while we're still continuing to make sure that those homes are not also being used for illegal purposes, for an illegal short-term rental or an illegal tourist home, as we call it here. But yes, the user absolutely limits what the length of the stay is. In addition, on Airbnb, when you go into Airbnb, there's a section for short-term rentals, there's a section for monthly rentals. They have an entire section on their website that the monthly rentals are designated. They are required to have specific features of them, like the needs of a 5-night stay and the needs of a 30+ night stay. Those are different, and so there's certain things that the host can designate that this specific home is suitable for actually living here. Does that answer your question?
I think that's helpful. Thank you.
Thank you.
Okay, so I just want to clarify, and thank you very much. I don't think that there's any other questions. I just want to clarify, and it does change the interpretation that's been presented here. Everything in the definition falls under tourist home means a dwelling unit operated or advertised as a temporary place to stay. So operated does not mean that allowing your brother-in-law to come stay while you're on vacation. It also does not mean that, it also means it does not apply to anything that's more than a short-term temporary place to stay. So long-term rentals are not caught by this. And so with respect, and I certainly appreciate the passion, particularly, Ms. Sharp, your passion over the many years speaking to this issue and being a champion for it. I actually believe that the characterization that's being put forward is actually a little misleading in that it does not actually fit with the interpretation. I will be asking administration to speak to that during the questions.
May I respond to that with regards to what the judge actually ruled?
Well, actually, that's not relevant here because we're looking at this bylaw.
I understand that, but, okay. The judge specifically said that the term operating in the bylaw, it's in his written decision. The town of Canmore needed to define operating.
Okay, well, that's for
I do see your
consideration by
point,
the lawyer.
and I agree. I don't think that secretly the town of Canmore administrators are waiting for someone's brother-in-law to
Yeah,
visit.
and
I don't believe that.
Yeah, so I'm not
What my
I'm not going
concern
to debate
is-
with you, but the specificity, and I butchered
So
that.
my concern is specifically
excuse
with
me.
regards to farther down. Sorry,
Yeah,
can you
excuse me.
scroll down?
Yeah.
I'm sorry, I apologize.
Yeah. The specific items that it couldn't be, that it could, whether it could be interpreted as the whole or the few has been rectified. And that's the specific definition of operating, because that then provides the specific definition. In any event, it's not, I appreciate you coming. I'm very glad that we waited to hear your input. And given that there's no other questions, I will now move on to ask the clerk to let us know if there's any written submissions.
We did not receive any written submissions for this item.
Great, thank you. I do have a question of administration based on the concerns that were raised by our speakers. I was wondering if you had some comments with respect to those concerns.
Which one specifically?
Well, there was concerns that somebody could be caught by this if they're allowing their family to stay while they're away, that they are renting out their driveway, that long-term rentals could be caught by this and thereby prohibited if they don't have a business license, those sorts of concerns.
I was going to address this in my presentation for the item.
Sure. It can
but-
wait to then if you prefer, because I know it's been a
Yes,
short time.
then I can go through what is a lawful tourist home and what constitutes a contravention of operating a tourist home.
Okay. Well, then let's save it for then. Before you sit down, though, are there any other questions of council for administration? Okay, seeing none. Thank you very much. I will then close this public hearing. We will resume in 5 minutes. Do you need longer than that? Okay. We'll resume in 5 minutes at 10:16. Okay, looking to the clerk's office to advise when we're streaming again. Okay, we're back. And we are now moving on to item G2, Revised Land Use Bylaw Amendment 2025-21, Tourist Home Enforcement. Ms. Miller, microphone is yours.
Thank you, Mayor and Council, for having me. I'm Caitlin Miller, the Manager of Protective Services. So this will be another brief presentation. We have discussed it at a previous council meeting. There are many places in town that you are allowed to have a tourist home that are zoned for those tourist homes. To operate a lawful tourist home, though, you do require the issuance of a development permit and a valid business license. The business license must be posted both online and in a place visible by the public at the unit. Now, this piece of regulation is coming into play right now as the transition with the new requirements under the business registry bylaw are being put in place, and we've been following up with all tourist home operators to make sure that they have business license for each individual unit. With the recommended land use bylaw amendments, we are hoping to accomplish three things. The first is to have greater clarity as to what constitutes a contravention of the land use bylaw in relation to operating a tourist home. This will provide clarity not only for administration, but for communication with the public about what is or is not a tourist home and where you can or cannot advertise rental units. It also provides greater clarity around fines related to offenses of operating a tourist home. And lastly, it updates the characteristics of a tourist home for greater clarity. Now, the actual bylaw contravention includes wording that goes beyond just saying a tourist home requires a valid development permit. It's clear that in a prosecution for operating or allowing a tourist home to be operated without a development permit, proof that a tourist home has been advertised as such is sufficient evidence to establish the contravention. And I will just say that it's that a tourist home has been advertised as a tourist home. The fines have been updated to add clarity and increase the fine amount for the third offense to a minimum penalty of $10,000. We've also removed the time limit of the offense occurring within a calendar year. This helps with the enforcement so that if the first offense happens near the end of the year and the second offense occurs shortly after that, but in a new year, so using the example of one offense being in December, one being in January, we're not bound to restarting the clock and can still enforce as a second offense. Peace officers will continue to use their judgment and discretion when considering something as a second or third offense. This is something they do regularly with other bylaws and consider things like time, change in ownership, etc. when issuing the fine. The most significant changes to the land use bylaw are the characteristics of a tourist home. The definition that we had before was flexible and allowed for greater interpretation as to what actually constituted a tourist home. The recommended amendments try to balance the need to provide greater clarity while still having some flexibility to address unique circumstances. And the recommended amendments will help in educating and ensuring compliance with the land use bylaw. I want to be clear that these are what constitutes a tourist home. So anything that we're defining in here is what is a tourist home. It's not what is a residence, which would be a long-term rental perhaps, or someone's home. So just to go through what these changes are, the occupants of a dwelling unit intend to stay or do stay in the dwelling unit for vacation purposes rather than residential purposes. So if there are legitimate reasons that someone may need to use a short-term rental, such as doctors on locum, people needing a place to stay when they come into town for a short-term residence before they move into a long-term residence, there are valid purposes, which also makes me hesitate to add in a timeline as to what constitutes a tourist home, because then we start to regulate how long somebody can stay potentially in a short-term rental for residential purposes rather than those vacation purposes. So it's really going back, we're going to the vacation purposes of that dwelling unit. The dwelling unit has the potential to or is generating income for the registered owner or their agent. The dwelling unit is being advertised as a tourist home, vacation property, vacation rental, short-term rental, getaway, or similar use. So all the terminology that we're using there is we're looking at an advertisement, and it is advertising as a tourist home, as a vacation property, vacation rental, short-term rental, getaway, experience, etc. The dwelling unit is being managed by a third party as a tourist home, vacation property, vacation rental, short-term rental, getaway, or similar use. And the operation of the dwelling unit is commercial in nature. The operation of the dwelling unit uses a system of reservations, deposits, credit cards, or other form of electronic payment, and the operation of the dwelling unit provides for nightly or weekly booking rates. The operation of the dwelling unit provides for cancellation fees and or terms and conditions of cancellation, and such other characteristics that the town deems to be representative of operating a tourist home. So for this, there needs to be some clarity, but there also needs to be room for interpretation. There's a lot of discretion that is required when we are enforcing a tourist home, and some of these items might be ticked, but we're looking at the property as a whole and the dwelling unit as a whole. It might not, one of these things doesn't necessarily constitute the full characteristic of a tourist home, but they may help define what the tourist home is. And I go back to it's being used for vacation purposes, for a getaway. It's not being used for residential use. So again, we want to maintain some of the flexibility and discretion to adjust to changing circumstances so that we can quickly adapt to any loopholes that might be found in having very strict and I guess less ambiguous, like if we tie it right down to very specific things and they all must have, then there's not the flexibility to offer the legitimate reasons for short-term rental, but there's also then ability to get around it and there's a lot of people that come to town for over 28 days on vacation, right? So we just need to be mindful of that. Really, when it comes down to it, with a lot of the bylaws, the contravention is when you're contravening the spirit and intent of the bylaw. So in this case, the tourist home definition is around allowing people to use the dwelling unit that's not zoned for a tourist home and it's zoned for residential purposes as a vacation property. Again, for greater clarity, we recommend amending the bylaw to be specific in what it means to advertise a dwelling unit as a tourist home, including posting on websites such as Facebook, Airbnb, VRBO, Home2Go, or other rental or social media platforms. This doesn't mean you can't advertise a long-term rental on Facebook. It does not mean that you can't advertise on Rent Faster because you're not advertising a tourist home and you're not using those characteristics to notify the public that it's a tourist home. And again, going back to what those definitions are and those characteristics of a getaway, an experience, not a home, a residence. And so if there's no further questions, that we'll go to the recommendations.
Just to clarify, every single one of those characteristics has to be read within the context as a temporary place to stay, because that's the very first part of the definition.
Yeah.
Right? And so it has the potential of generating income, but it has to be a temporary place of stay. It's not about generating income as a long-term rental or providing some storage to somebody for a vehicle or otherwise. There's reservations, deposits, credit cards, or other forms of electronic payment, but it has to be a temporary place to stay, not for any other purpose that those things may exist. Okay, thank you. Councillor Faubert.
Thank you, Your Worship, and thank you, Ms. Miller, for your presentation. So I think I need help understanding the difference between defining the characteristics of something and the fact that the violation tag is for operating a tourist home. So the violation tag isn't for having characteristics of a tourist zone. It's for operating it.
Or advertising.
Well, in E1, I think in E1 we're covered. I think E1 is the solution. I think the decision the judge speaks directly to, if you just make advertising illegal, you're covered. E1, I'm good with, but E, and this is where I'm understanding the concerns that were expressed during the public hearing, because the judge did speak to operating. And while in the definition includes things that are operational, that doesn't define operating per se. So when it comes to issuing a violation tag under E, how does the definitions or the characteristics in the definitions relate to being able to enforce that? 'Cause I'm having a problem understanding how they're connected.
Yeah. So in order to have a valid tourist home, you do need a development permit, right? So if you were doing things, going back to this, where you are advertising the tourist home, like that in itself is what we are saying is enough to indicate that you are operating the tourist home. If you have a property that is being advertised as a getaway, a vacation home, that is enough to say that you are operating a tourist home.
Okay, and then, and that's it. Like, we don't need anything else to establish operational proof, right? Because, like, the characteristics, I think, really speak to what is a tourist home. But what we're talking about is enforcement of trying to enforce rules on people who aren't following them. Mm-hmm. And so then it becomes, what does operating mean? To me, a characteristic is not operational.
Yeah.
Like, right, one is an aspect and one is a verb.
Yeah. And that's why going back to this, like the advertisement is enough to prove that there's the operation of the tourist home.
Okay, perfect. And then we're okay with the fact that the definition includes without compensation?
So that allows us, if there's compensation generally means in monetary form, but there are other home exchanges and items like that where we would like to maintain the flexibility as we're moving through our housing crisis and affordability challenges. Those are also places that could be used for residents to stay, and people are generally coming for a vacation purpose when they're doing the home exchange. So it just allows us that bit of extra flexibility to manage that.
Perfect. And and I had temporary place to stay highlighted as part of part of what sticks out as the difference between a residential use and a long-term residential. It's tough because I feel like there's some gray zone in all of this. There's some, like, when are you living here? And when are you visiting here? And what is the edge of that? What's the threshold of those definitions? And I think it's tough for us as legislators and for administration, especially enforcement, because some of these things can be quite loose in terms of how they're used in the real world. So I'm really grateful for all the hard work you've put into updating this to help us enforce these rules. Thank you.
Thank you, Councillor. Councillor Graham.
Thank you, Mayor Crozer. I wonder if you could speak to the concern around, my buddy's coming from Calgary and he's staying overnight. Or my mom's coming for the week and she's staying in my spare room.
Yeah.
What does that look like?
We're not regulating when your family visits you and stays with you. It's like, that's not the advertising piece, right? Like, you didn't advertise to the public that you can come and stay in your room for a place to stay. If you start doing that and charging people, then you're operating a tourist.
Totally.
Yeah.
But, having your friend over for the weekend
Yeah, it's okay.
doesn't fall under this at all.
No, it's not operating a tourist home.
Right. Thank you.
Thank you, Councillor. Councillor Hillstead.
Actually, I think Councillor Maw had his hand up before I did. So
All right.
him first.
All right, thank you. That's very courteous of you. Councillor Maw? You're on.
Thank you so much, Councillor Hillstead, and thank you, Your Worship. Ms. Miller, I know this is like a lot of stuff that we're trying to figure out here. And in some ways, it feels like what we're trying to create is something that is descriptive as opposed to prescriptive, but then sometimes it feels the other way. And say with respect to the situation where that was brought up in the public hearing, with someone who had like an Airbnb listing and they're trying to use it as a situation for people that are newcomers to the community and trying to land here, how would that all shake out? Because I'm hearing one version from the public hearing, and I'm trying to understand, is it the sort of thing where they would trigger an enforcement situation, then we have to go in and everyone has to prove otherwise? Just elaborate on that. I'm trying to figure out what's going on here.
If that residence was online and operating and advertising and saying that they were a vacation rental, then that's the contravention. It's not who uses it. There might be valid reasons that people are using it, but then there's other valid ways to advertise for those rental opportunities. Unless I am unclear as to how someone would advertise as a vacation rental and then not expect people or not accept those people who are coming for vacation if that's what they're advertising. So I go back to, it's very much about operating a tourist home. You're advertising as such. It's not about the short-term rental piece of it. It's about you've offered your dwelling unit as a place to stay for vacation. How people use that place, that dwelling unit afterwards, that's almost irrelevant to you've advertised it as a vacation unit. You've put it out there that people can come and stay there for vacation purposes. They can have this experience. It's not being advertised as something that is going to be a residence for a short-term place to stay. It's not that landing pad. It's not that place that is a reasonable and valid reason to have the short-term rental. It's still being advertised as the vacation unit.
Thank you.
Thank you, Councillor. Councillor Hillstead.
Thank you. Can you get into the reasons why, so like what happens if a violation tag is issued? How does the appeal process work? Is there an appeal process? And
Yeah. So our general process is that we first issue a municipal tag, and if that municipal tag is not paid, a provincial violation ticket is then issued. So with the municipal tag, there is no mechanism of appeal. They could go to the enforcement appeal, but we generally take that tag away. And then there's the opportunity to appeal the ticket in court. So going to court is the mechanism of appeal. And it's a very similar process, but it is through the provincial court instead of through the municipal tag. We have very similar processes for many of our other bylaws where provincial tickets are issued and the opportunity to appeal that ticket is in court. We generally save the Enforcement Appeal Committee, which I think you're referring to, for orders and such.
thank you.
Thank you. Councillor McCallum.
Can I take his question a step further? So you tagged somebody and then is there any opportunity for, like, similar to, and it's the same but completely different, soup to nuts? You know, when we do our assessment appeal, right? Assessments go out, members of the public have the opportunity to speak to the assessor about, oh, well, like, where did you find this and da-da-da-da-da, and make peace before it has to go to ARB or figure it out before, is there any opportunity for that within the process?
So generally when we conduct enforcement, we try to do a really good job of gathering our evidence and everything ahead of time. And there's very rare occasions that we feel like it would be, we would overturn that decision without it going to court to prove the bylaw, because there's a lot that is being done within the bylaw. So in these cases as well, like with the investigations that happen, it's generally like the peace officer may have the discretion to remove the ticket, or it's very circumstantial, and we could go down a rabbit hole here, so I'm cautious not to do that. But each kind of case is kind of taken for what it is and what that process is. But the general process is that if the municipal tag is issued, then there was deemed to be enough evidence to backstop that tag. If it's not paid, then we go to court. And, or we issue a provincial violation ticket, which then still gives you the opportunity to appeal that ticket. So
there's no email to the homeowner, there's no, like, if they say, well, hey, I was actually just, you know, using it to rent it out to an immigrant or whatever, there's no space for that, it goes straight to court?
I don't want to speak in absolutes because I think there's always
In general,
discretion.
does it go
and
straight to court?
I would not say it in general goes straight to court either. It goes to a municipal tag. If the municipal tag is not paid, then a provincial violation ticket is issued. If the provincial violation ticket is not paid, then it does go to court.
Okay, thank you.
Thank you, Councillor Mera.
Thank you. This is a clarification. You may have answered this already. When it comes pre-enforcement, are we reliant on complaint-based information, or what are we doing to sort of locate or find or?
Yeah, so we were doing complaint-based enforcement previously. So with the complaint-based enforcement, we were gathering information. It was usually somebody complained that someone was operating an illegal tourist home. We would then start an investigation where we'd gather evidence and are currently gathering evidence on what the bylaw says today. When we go through that, we generally make contact, or if we have enough evidence that there is a violation, then we go with the tag. When there's enforcement, an investigation does take place. Now we're doing more proactive enforcement, so we're using software, right? So we can gather all of that information and still have that conversation. But every case is kind of different, right? So same general processes, yeah.
Thank you.
And we've just received that grant that
Yes.
is to develop a more robust system with regards to short-term,
Yeah.
illegal short-term rentals.
Yeah, so we're
enforcement.
really able to refine some of our processes and do best practices, review what's working, what isn't working. These recommended changes are, like, we have additional budget for legal fees at the moment. We're able to spend some of that on making sure that these bylaw recommendations will hold up with our litigators. So there's been a lot of work done behind the scenes to make sure that we're moving forward with efficient processes, fair processes, and fairly robust processes as well.
Thank you.
Thank you, Councillor. Any other questions? Councillor Graham.
Thank you. I guess I'm going to circle back to the appeal process piece for me. And why not have an appeal process before it gets to court?
Well, we have so there's a few different ways that we go through. Because this is a land use bylaw, there's two different tracks that we can take. So we can actually issue a stop order, and then that would go through SDAB, which would be that appeal process, or we can do the bylaw contravention with issuing the violation tag. We first issue the municipal tag, and then it would go. So we would have to adjust some of our other bylaws to address that, because the Enforcement Appeal Committee doesn't speak to this type of bylaw infraction and response. So as I kind of mentioned earlier, every case is different. But generally the process is municipal tag. If it's not paid within a certain time frame, goes to a provincial violation ticket, and then you can appeal that in court, right? Like, that's your opportunity to argue it instead of arguing it to the Enforcement Appeal Committee or to the SDAB. So one thing that we have started doing is writing a stop order with the municipal tag at the same time, and then we can pursue both avenues, but we would continue to pursue both avenues at the same time.
Thank you, Ms. Miller.
Thank you. Dr. Cottle.
I'm just wondering if I might be able to assist to clarify, but I'm going to look to you to correct me if I'm wrong here. I think part of what's a little bit unsaid is that we don't just quickly issue tickets. A ticket is almost always a last resort in municipal enforcement. And so there's a significant vetting that happens before that municipal tag is issued. So part of the question about appeal, I think is time, and really that the court is the best place for that because we're testing language and learning about the bylaw. And we do look at individual circumstances before tags are issued. Does that mean we're always 100% correct? Of course not, but it's not a quick to write a ticket process.
Yeah, there's lots of things that we consider, including like previous infractions, whether warnings were issued. We look at the whole case, what the evidence is, right? And it's at that point where we would make that decision as to whether or not we felt comfortable proceeding to court or not as well.
Councilor Graham, do you have anything further? No, thank you. Okay, any other questions? I see none. Thank you. Okay, I will move that council give second reading to revised land use bylaw amendment 2025-21, tourist home enforcement. And speaking in support of the motion, I appreciate that the advertising component has been reinserted into our land use bylaw, and that that we are being responsive, obviously, to with legal counsel advice as well, to the decisions that are made by the court to ensure that our bylaws are always improving so that we can best give enforcement where enforcement is needed, or education, of course. Councillor McCallum.
Thank you, Your Worship. I would agree that we are learning and evolving with regards to this bylaw over time and around the enforcement of tourist homes in general. And so at this time, I won't be able to support second reading. I would like to make a motion to defer this. And I sent an amendment to the clerk to postpone second and third reading of the revised land use bylaw amendment, tourist home enforcement, to the August 19th regular meeting, to provide opportunity for council and administration to digest the complete recommendations provided through the public hearing. I would love to be able to get those full recommendations from the Tomlinsons, because I know that this is something that Ms. Tomlinson and I have talked about many, many times, and I know that she's spoken with other politicians at this dais over the last 15 years about this item, as well as understand the judge's decision on Town of Canmore v. Tomlinson. I don't have a copy of the judge's decision. I would love to receive a copy of it. And so this is my postponing motion, and I look for your support.
So there's a postponing motion on the table, and I don't think it's unreasonable. I do have a question, though, just to CAO. Any concerns around delay for any reason?
I'll defer the answer
Okay,
to Ms. Miller.
The only concern that we would have would just be time is of the essence, and we are in peak season for tourists in the area. So providing greater clarity as we're in peak season would help with future enforcement.
Okay, thank you. Councillor Faubert, speaking to the postponing motion.
I had a question. Would enforcement still be able to collect evidence even if the bylaw hasn't been passed?
Yeah, so we're still enforcing. That hasn't stopped. Our challenge is that if we do go to court and the only evidence that we have is the advertisement with the Town of Canmore v. Tomlinson ruling, where they did say that in that ruling they added that it is within the municipal ability to add that advertisement is an offense itself. It just means that it would take longer for investigations. There's not that clarity. So we wanted to have robust enforcement, and we'll still continue on with that track. It just may be harder to, if we do go to court at that point.
Well, I think the timelines wouldn't see you in court. Like the timelines between us.
The
adjourning-
bylaw today would be the bylaw that we're arguing against.
Yeah, like, are there any court dates currently set?
No.
No, okay. And then I feel like I want to clarify my question. Would you be able to gather evidence of advertising now and then use it after the bylaw is passed in the future?
The evidence that's gathered would have to be against the bylaw that we have in place.
Okay, thank you. I'm sorry that that took me an extra second, but it helped me. Thank you so
That's
much.
fine. Councillor Merrill.
was speaking in, I'm happy to support Councillor McCallum's motion.
Okay. Councillor Graham speaking to the postponement.
Yeah, I would rather get this right and wrap my brain around this one a little bit more. I understand that time is of the essence, but I think getting it right is more appropriate than getting it done.
Okay. Councillor Mong.
Thank you, Worship. I would be able to support Councillor McCallum's amending motion. I feel, as some of the other councillors said, this has been coming a little more layered than I expected, and I do think there's some further information here and some scenarios I did not really have a chance to fully put my mind towards that got brought up today. And I'd just like a little more time to, as Councillor Graham said, let's try and get the best thing possible. And I do understand to Ms. Miller's commentary that time is of the essence. I'm hoping just the couple extra weeks for this summer will let us get to something more robust in the end. Thank you.
Okay. Speaking to the motion, well, I think I already did. It's not an unreasonable motion at all, and so I'm willing to support it. Anyone else? Okay, I'll call the question. All those in favor of the postponing motion? Carried unanimously. All right. I'm just taking a quick look. How are people doing before we get into Connect Downtown? Well, it's a larger piece, so do you need a quick break now, or are we good to get into it? All right, let's take 5 minutes. We'll return at 10:55, and then we will move on with item G3. Okay, we are back, and now we are turning to item G3, Connect Downtown, Planning a Vibrant Town Center. And I believe Mr. Cairns is joining us. There he is on screen. Welcome, Mr. Cairns. And the microphone is yours whenever you're ready.
Thank you, Mayor and Council. I'm happy to be here today for introducing the Town Center ARP again for second and third reading. And I'm joined by a few colleagues as well in person in case there's any questions from Council that require clarification. I'll start us off with a very quick contextual presentation, just recapping what we had done since we last convened May 27th, and then we'll turn it over to Council. So this project started, just as the really quick refresher, back through a budget approval in 2021 by Council, directing administration to create an area redevelopment plan for the town center or downtown area, and then charting out a pathway for the future of Main Street. That work kicked off in 2023 and then ultimately concluded with Connect Downtown, which is the town center area redevelopment plan. So this area redevelopment plan, or ARP for short, is a vision that is going to guide the continued evolution of downtown over the next 25 years. It'll regulate development in the area and also chart a pathway for town investments and actions. And a quick refresher on just the area it applies to. So it does extend to some natural boundaries, including the Bow River on the west. It extends to the Spur Line multi-use trail to the north, Railway Avenue to the east, and then jogs around Lawrence Grassy Middle School to the south and follows 5th Avenue and 5th Street. So we looked at the area beyond that, but the policies within the plan apply to the area within the boundary. And then, of course, as a key part of this work, we updated and did new area-specific technical studies to inform the policy. So that included an environmental impact statement, a transportation impact assessment to make sure the network can function and what improvements have to be made. We assessed the viability of expanding the transit terminal, stormwater management, servicing, and also conducted architectural test fit studies to make sure that whatever we did is something that can actually be landed on the ground. And as we've touched base on in the previous readings, this was a plan that was largely driven by community input. So over the 18 months of the project, we engaged the community in a variety of ways and innovative methods, and that resulted in a super successful project with over 4,600 pieces of input from the community helping shape it. So jumping into the progression of the bylaws, we brought the ARP to Council for first reading on April 1st. That was referred to a public hearing that took place on May 6th. And when we came back on May 27th at a special meeting of Council, Council decided to postpone second and third readings to July 8th. And with that, they directed administration to draft a series of revisions for Council's consideration. So that's what brings us here today, is consideration of those amendments and then administration's recommendation of second and third readings of the bylaw. So on May 27th, at that special meeting of Council, several revisions were asked of administration to prepare. This is paraphrasing, of course, for brevity, but generally it included allowing or permitting single detached dwellings in an area that is covered by a restrictive covenant, replace mandatory language referencing the full pedestrianization of Main Street, acknowledging that that is something that would be determined in the future and through additional processes. Removing some of the changes to Riverside Park in the plan, changing the classification of Eckloff Park for purposes of preservation, limiting heights to 2.5 stories on Main and 10th Street, ensuring that we will offset reductions in public parking downtown with additions of new public parking facilities, and then other general minor clarifications around wording, clarifying council authority and things like that. And so our request for decision offers our analysis on all of these. For the purpose of the presentation, though, most of those amendments are quite straightforward and don't pose any significant issues. So I'm only going to provide additional information in the presentation on 3 of those. So the question around the detached dwellings in the restrictive covenant area, changing classification of Eckloff Park, and then finally limiting heights to 2.5 stories on Main and 10th Street. So first we'll start off with the restrictive covenant area. And to recap or provide a summary of the direction from Council at the May 27th meeting, it was directing administration to identify the restrictive covenant area in the plan and allow single-family residential uses. And so the one thing I'll just touch on here is administration has offered previous guidance on this and what this would look like. This map is taken from the ARP, and it generally shows the time or the context for when the restrictive covenant in the northwest area of the plan was registered. So 1968 was the year it was registered. And at that time, restrictive covenants were a fairly common tool used by municipalities. In this case, it was only just after we had really incorporated as a town. And they were done in place of zoning, and they've been superseded since then by zoning as the way that we regulate land uses. In this case, with this covenant as well, as we've advised previously, this one was actually registered by the town in the 60s, and it was when the town owned all the land. And it implies that the town was merely looking to control the very initial bare land development that it had planned to transfer. So basically, it was going to transfer the land to private parties, and it wanted to make sure that it was going to develop in a very specific way that now would be regulated by zoning. And building off that, as we've advised previously, for that reason, restrictive covenants do not limit a council's ability to make zoning changes. We can make zoning changes that would supersede and replace the guidance under the restrictive covenant. So in this area, with this context in mind, whereas we can see today, the planning context that we're working with around affordable housing is very different than it was when this restrictive covenant was registered. So for that reason, we had previously advised against any amendments that would reflect the RC area. And when you see it on the map to the left, you can kind of see it takes out most of the change from this plan as it applies to a large number of parcels. So as I mentioned, it was registered by the town in the 60s to regulate development, and it's no longer an appropriate way to regulate land use in that area. And it is highly restrictive. So for example, it's more limiting than even what is permitted under existing R1 zoning. It would also limit our ability to pay for some of the public benefits identified in the plan and finance the infrastructure improvements needed in the area. And worth keeping in mind as well that public engagement indicated very broad community support for the land use plan, which had included more diverse housing forms in that area. And then finally, one last piece for awareness is that restricting new housing forms in this area would not be in alignment with some of the policy directions in the municipal development plan, which we touch on in the council report, as well as our desire to provide more affordable housing. So with that administration's analysis and advice in mind, we have taken council's direction, of course, nonetheless, and we have prepared revisions to align with that direction, should council still wish to proceed. And those changes really summarized are: one, we've identified the restrictive covenant area as requested, so a new map has been inserted. That map is, of course, just for informational purposes, as the RC over time would dictate the areas and properties that are subject to it. And second, we've added new policy to indicate that despite the residential areas being identified as appropriate for other housing forms, properties that are subject to the restrictive covenant may retain their existing R1 zoning, which is single family residential dwellings at this time. Two, so Eckloff Park, I'll touch on that one quickly. At the May 27th meeting, council had directed administration to prepare amendments that would change Eckloff Park from municipal reserve to a classification that results in permanent protection of the green space. We have come back with no change, and I'll provide a little bit of information as to why. So the Municipal Government Act defines what designations exist and what can be used and registered on title. One of those is the municipal reserve designation. That is the one that the ARP identifies as being used today and can be retained moving forward. And the Municipal Government Act defines the municipal reserve as the designation that would involve public park or public recreation areas, which Eckloff Park would fall under. Retaining that designation would also be not only be consistent with the Municipal Government Act, but it would also be consistent with council's intent for that area, and also consistent with town practice. So for example, because of these definitions in the MGA, Lions Park, as an example, is designated as municipal reserve. Veterans Park is designated as municipal reserve. And when you review the definitions, there's really no alternative designation that would be applicable to Eckloff. And then just flagging as a note, some councilors touched on it at the May 27th meeting, but it is just a reminder that these designations reflect a moment in time. It is land that the town regulates, and designations can change with council approval, but that does require a public hearing and requirements under the MGA to discharge that designation. So administration's response for those reasons is that no change to the ARP is necessary, and no other designation could really be used, and it does already fully align with council's direction and their intent for that site. And finally, I'll touch base on limiting heights on Main and 10th Street. So at the special meeting, council directed administration to prepare amendments that would limit heights on the Main and 10th Street frontages by stating that buildings shall not exceed 2.5 stories. We took this one away and did a bit of analysis, and there are some issues that could arise with this wording. A few that come to top are that half stories, so 2.5, so half stories are defined in our land use bylaw, and they're defined very specifically. And ultimately what is going to end up happening is, rather than fulfilling council's intent of limiting building heights and minimizing shadowing, it's going to force all developments to have to adopt a specific roof type, like a gabled or a hip roof. What that does is it might compromise the character of the area, the appeal, and the visual aesthetic of the area, without even necessarily minimizing shadows, because you can still have a gabled roof that goes up to a full 11 meters. Further, a strict 2.5 story limit would also have a lot of unintended consequences. So for example, we have regulations in the land use bylaw that are for the retention and preservation and enhancement of historic resources. And it allows the town to issue variances to developments in order to protect those important sites, or come up with better designs, better developments that can more enhance or visually complement those sites. If we impose a strict 2.5 story limit, we're essentially moving away from good built form guidance around building massing, building step backs, reducing the appearance of the third story. And we're basically forcing a very specific development design that might compromise on a lot of different fronts. And then the final point I'll just highlight is, this is an excerpt, the image there, from our land use bylaw, and specifically the town center district, which is the zoning district that regulates properties on Main and 10th Street. So as you can see, there's already parameters built into this zone that minimizes shadowing and impacts on views by requiring significant step backs to the third story. This already generally achieves that same intent of 2.5 stories, but it ultimately allows a little bit more design flexibility and ensures that we're actually minimizing impacts on shadows and views. When we shift to a regulation around 2.5 stories, it gets to be very challenging, and we're going to end up with a very different form than this. Further, the ARP also has policies in it really focusing around preservation of views, solar exposure, minimizing massing of upper stories, and things of that nature, especially on Main and 10th Street. So administration is confident that the ARP already aligns with council's intent. What we can advise is an effective measure would be, as part of implementation, when we're preparing land use bylaw amendments, we can conduct a review of these regulations in the town center district and specifically reassess that third story step back and see if that is actually still appropriate and if that would meet the intent of minimizing shadowing and views on public spaces. So in closing, we have prepared revisions, but what we are recommending is wording that would discourage forms that exceed the appearance of 2.5 stories, but also clarifying that additional heights may still be considered where it would preserve or enhance a historic resource. So to generally fulfilling council's intent, but the wording is slightly tweaked just to make sure we're not forcing a very specific roof and building design that might actually work against some of our objectives around shadowing. And then finally, as I mentioned, we can also reassess those step back requirements in the land use bylaw during implementation.
Mr. Cairns, just before you move on.
Yep.
On that, I just need some clarity.
Sure.
You indicated that if we don't make the change as set out, that striking the shall not exceed 11 meter building heights and should reduce massing of the third story through step backs or other design measures, and in substitute shall not exceed the 11 meters and should generally not exceed 2.5 stories on Main Street and 10th Street frontages. Without making that change that appears in the red line, we can actually already achieve that without those changes and avoid the unintended consequences?
Exactly. So we already have the town center district, which has those regulations in place that get into those very specific details around how much does the third floor have to be stepped back from the building frontage, as an example. The ARP layers on additional policy guidance that would clarify some of those principles further around how should we reduce massing, the preservation of views, and things of that nature. One important clarification too is in the definitions or interpretation section of the ARP, which is in the first chapter, should is still generally interpreted as a mandatory requirement, but it does acknowledge that there might be unforeseen circumstances or situations that could arise where we might need to be able to exercise some discretion. So by using the word should, we would still intend to try to hold developments to that 2.5-story design, but it gives us some interpretation around what that could look like so that we can make sure we are not forcing a very specific or unnecessary roof design and making sure that we can actually have the best overall outcome in terms of minimizing shadowing, if that makes sense.
Great. And just to confirm, the original wording that you proposed, so before the red line, that pretty much carries forward with the current zoning?
Generally, yes. The main change that we've highlighted, there's basically two amendments in response to council's direction. So the one is we are proceeding or recommending the addition of the 2.5 stories into policy, but defining that as should instead of shall, because there are circumstances where that is not going to be viable, especially around historic resources.
Yeah.
And then second, adding an additional policy item earlier in that same chapter, clarifying that additional height may be considered where it would preserve or enhance a historic resource. So it is trying to get around and address that while we are reinforcing that strict 11-meter height limit, there's still going to be select circumstances where that is not going to be viable.
Okay, and so just so I'm clear, because I may propose an amendment to this amending motion that reverts to the original wording for that section 7, that would still reduce the massing of the third story through step backs or other design measures, and it does not change the fact that the addition that was put in with regards to historic resource, right? Because that's not in that section, that's elsewhere.
Yeah, so yeah, our recommendation would still be to proceed with the addition around
the historic,
flagging that historic resources and sites that are preserving those or enhancing them may be permitted to exceed that height limit.
Right, and that's in land use section 4
Exactly.
or it was 4.1.1.5.
That's
so
correct.
Retain that one, but if your recommendation is to not proceed with the red line wording in section 7 and revert to the original wording. Okay, I understand that now. I have Councillor Graham, then I'll go to Councillor Mong. And I had interrupted just on this. I know that there's still more of the presentation.
There is a couple of
questions
additional
specifically
slides, so
about this?
if it works for council, I can close that off because it does provide a bit of context around some of the historic pieces as well.
Sure, okay, well, why don't we do that and then we'll go to the questions. Okay, thank you.
So this is quite quick. It's clarifying that staff is actually recommending one additional amending motion that kind of arose more recently in our review of these revisions and potential council direction, including the 2.5 stories. And that has to do with the Canmore Hotel site. So a little bit of quick context. In 2015, council adopted the Canmore Hotel Direct Control District. So that's Bylaw 2015. And at that time, the Canmore Hotel was not a protected historic resource. And so in conversations with the landowners in the preparation of this district, what essentially happened was an agreement that additional height could be granted on a small portion of the site that was undeveloped. And by allowing that small additional height increase over 11 meters, it would support the restoration of the Canmore Hotel and also result in its voluntary designation as a municipal heritage resource. So that's just clarifying that piece further. We are also recommending some additional policy direction to be very explicit on that point and are recommending that council amend the ERP accordingly. And that would be inserting the addition in the commercial core section stating that developments occurring under the Canmore Hotel Direct Control District shall be governed by the height regulations established in the applicable direct control district, which may exceed the height limits identified in that plan. So this is just being quite clear in this very specific scenario that these past commitments have been made by the town and need to be respected in the ARP.
Thank you for that. And just to note, I have made note of that amending motion that will come as part of the process, and then it can be considered by council at that time. So thank you for your presentation, and now I'll open it up to questions. Let's go first to Councillor Graham, and then Councillor Ma, then Councillor Faubert.
Thank you, Your Worship. Thank you, Mr. Cairns. I guess if a development like Settler's Cabin was to come forward within this ARP, could it or would it be approved with this regulation?
Yeah, thank you, Councillor. And it's a good question, as I know that one has been of some concern or conversation in the community. With the ARP, there's policy guidance in there indicating that a development like that would not be supported.
Thank you, sir.
Okay. Councillor Ma.
Thank you, Your Worship, and thank you, Mr. Cairns, for all these thoughtful commentary on the various amendments we proposed. Just tying it back to the public, once again, there's no floor bonusing for Main Street in the ARP.
That is correct. It scales that back from the land use bylaw and would basically ensure that it would not apply to those properties.
Okay. And with regards to historic resource, I understand that with the Canmore Hotel, we need to honor that prior commitment. Are there any other historic resources on Main Street that you could potentially see that we need to address? I'm not exactly sure in Canmore what even constitutes a historic resource. Things seem to change so quickly.
Yeah, thank you, Councillor Mala. Good question. There is one that comes to mind with some underdeveloped sites next to it, for example, would be the Ralph Connor Memorial United Church. So there is provisions in the land use bylaw around properties that are adjacent to these historic resources. And basically, we might want flexibility on these sites to ensure that appropriate developments can respond to them. What that means is we might want to require a higher level design. We might want to require larger setbacks than we would otherwise see on these properties to not compromise that historic resource. And that means there might need to be a little bit of give and pull around some of the other parameters like heights or setbacks on other property lines, so to speak.
Ms. Smithers,
Okay, that's super.
Ms. Smithers, did you want to add something? I saw your microphone went on.
Yes, thank you. Just a bit of an added nuance on that Canmore Hotel DC district. In the review of the analysis that was done at the time of second and third reading for that district, it was essentially transferring development rights and density within the site, right? So at the same time that there is an increase on that available parcel, the owners accepted a decrease in allowable height on the Canmore, where the current Canmore Hotel is. So it was just acknowledging the nuance, I guess, of that arrangement, which would be unique from other potential resources. We might take a similar approach for those other resources, but I just wanted, with that specific site, that's partly why we want to capture it differently, to recognize that there was effectively a density transfer within the site on that parcel.
Great, thank you. Councillor Ma, do you have further questions? No, you're good? Okay, Councillor Faubert.
Thank you, Your Worship. Thank you, Mr. Cairns, for your presentation. With respect to the issue of shadowing, and you kind of spoke to a bit around how you might approach looking at that into the future. And I'm wondering, are you just looking at that from a perspective of eliminating shadowing, or are you also considering that there are other times of the year and temperatures where shade and shadows might be beneficial to a public space?
Yeah, thank you, Councillor. When we developed the ARP, we did do some testing of shadowing and solar exposure, and that is ultimately why we had landed on reaffirming the existing height limits and number of stories on Main and 10th Street. While there is always from any development going to be some shadow cast on a public space, as avoiding that entirely is impossible with any built structure, we can craft the land use bylaw in a way that makes sure that that is minimized. And the existing town center district did do that. So that's why in that bylaw, there's a requirement that basically there needs to be a 40-degree angular step back from the second floor to the third floor, and that is based on solar exposure and shadowing at a certain time of year. But when we prepare the land use bylaw amendments, we can reassess that and understand, one, from a development viability perspective, can changes be made or should they be made? And then two, reassessing different times a year and the performance of those buildings and deciding, is that step back requirement still appropriate? Or, for example, does it need to be increased based on some objectives we might have around making this a great winter space, for example, right? So we will reassess those things, and it would not be a simple calculation of only looking at summer solstice. We'd look at all times of year, including winter solstice, where shadows are greatest.
I really look forward to that work continuing. I find it quite fascinating. Thank you so much.
Thank you, Councillor. Looking to see if there are any other questions, Mr. Cairns. All right. Thank you very much, Mr. Cairns. I really appreciate you zooming in to provide this presentation and to answer these questions. Excellent work. Thank you.
Thank you.
All right. So just to give an overview of the way that we'll be proceeding here. The situation that we have today is that we had postponed second reading, and we gave direction to administration to come back with some proposed wording to meet certain concerns on certain issues. We have to start with the wording that was passed at first reading, and so I will be proposing that we give second reading, and that will refer to that which was passed at first reading. Then I'll be putting forward a very large motion, amending motion that captures the changes that responded to Council's direction previously. There will be an opportunity at that point for councillors to make motions to amend that amending motion. Once we go through all of those, we will then vote on the the amending motion as revised if there are any amendments that are approved. Following that, I will move the amending motion with regards to the Canmore Hotel Historic Site. Following that, I will open it up if there are any further amendments that Council would like to propose that have not been previously dealt with in the amending motions I've already discussed. Following that, we will then have the vote on second reading as amended. And then we'll move to third reading. And then after that, we will deal with the revised land use bylaw amendment 2025-13. Anybody have any questions about the process? Okay, so we will proceed in that manner. I move the council give second reading to Town Centre Area Redevelopment Plan Bylaw 2025-05. It does say in our agenda as amended, but it's not amended yet. So I'm not adding that wording yet. The amending motion that I'm going to be putting forward here, I'm not going to read the whole thing, but I will describe it for accessibility purposes. First of all, it captures all of the red line changes as found in attachment 2 in the agenda package. So if anybody wants to know what these changes are, that's what it pertains to. In summary, it's going up on the screen, but in summary, in section 1, there's a slight revision with regarding council approval for if there's conflicts. In section 3, there's an amendment to the vision to ensure that it includes parking and parking structures. Section 4, there's a number of changes with regards to the historic sites, the ones we were talking about in section 7 about building heights on the street frontages on Main Street and 10th, and then with regards to the restrictive covenant. Then there's changes with regards to parks and open spaces, removing some elements for Riverside Park. Section 8, transportation mobility. There's a number of changes there that speak to the pedestrianization, ensuring that they're seasonal going forward, but moving it to a potential instead of a certainty with regards to the full year. And some changes to, strike out a proposed parking spot outside of the town center area. And that's basically all of those changes. So I move the council amend the Town Center Area Redevelopment Plan Bylaw 2025-05 as follows, and it's going to be incorporating all of those changes as written out. Now, with that amending motion, Dr. Cottle, did you have something you wanted to add?
Well, I'm just concerned because we've lost Councillor Ma on the screen, and we need to see him for the voting. So I'm not sure what's going on, but I'm wondering, it seems important that we have him.
Okay, so
I can still see you guys.
We need to see you, though. There,
Yep.
you're back.
I know.
Okay, so now we see
Can
you.
you leave it that way? Sorry. Will it stay that way? Okay.
I didn't change
Okay.
anything.
Excellent.
It's on our end. We're
I'm
just
glad-
making sure.
I'm glad that you're still there, and now we see you. Thank you, Dr. Cottle, for pointing that out, because it is important that we see the councillor joining by Zoom. So we have a very large amending motion on the table now that captures all of the red line that was provided in response to council's previous direction. I will now open it up to anyone that wishes to put forward an amendment to that amending motion. And I know that there were a few. Councillor Faubert, where would you like to start?
I do have one. And it's in the Section 8, Transportation and Mobility. There's 3 changes. I don't know if the best process is, okay, I'll back it up. If the first one doesn't pass, it doesn't matter that we go to the second one, right? Because if the first one, if people aren't on board with my idea and the first motion amendment doesn't pass, then it doesn't, the second and the third don't matter. I wouldn't put them forward to begin with, so we can just start with the first one.
Sure.
And the intent of these motions is to take from that it may be a permanent pedestrian Main Street to that to take that off the table and say that our Main Street moving into the future will have a seasonal pedestrian zone, and for the rest of the year not, and that is the decision moving forward. There is not. The reason for this is because I believe we do need to make this decision now as a council. I know that at the last time this was in front of us, I voted for this amendment, and when I looked at it and I took time to understand it, what I found is that it didn't actually put forward what it was that I was trying to put forward myself in terms of the changes that we were all individually considering. And the change I want to make to this plan is to say that we are not going to pursue a permanent year-round pedestrianization of our Main Street. I think that a seasonal pedestrian zone permanently designed onto our Main Street is already a big, audacious, and bold idea. I think that it starts us moving in the direction of creating or taking our Main Street from what it is now, which is a special place, to a more special place. But I think a permanent pedestrianization goes too far. I think a year-round closure on this road only will take away the things that make it. Three Sisters Village will be entirely designed for visitors. Silvertip's Village will be designed for visitors, and these will be pedestrian spaces. Our Main Street still has the ability to be that classic Main Street. And I think the brilliance in going into a seasonal design for a pedestrian zone is that we can keep some of that traditional small town, Western Canadian, coal mine, railroad town, Main Street aspects, but also move into the future and create space that is walkable and accessible, and businesses thrive. and that our residents of our community, 12 months of the year, feel like their downtown is also theirs too. And so I think that to me, that's the decision that I think that we're tasked to make. And the motions that I have here would put it into the ARP. I don't think any of the objectives change. I think all of the objectives, whether it's a seasonal pedestrian zone or a permanent one, are still very much in line and are there for us to achieve. I feel, having lived in this town my entire life, having actually had my dad live on Main Street, having seen our downtown go from what it was in the early 80s to what it is now in 2025, there is, like, we need to maintain some of these special things that we have organically created in our community, but also prepare us for the future. And I don't think of a year-round pedestrian zone is my vision of the future. And so I apologize for going on a little bit.
No need to apologize.
But,
You're speaking to your motion.
But that's kind of where I went with this. And I appreciate all my colleagues' thoughts, because I know that in the process of trying to come up with an amendment to address or to a vision for the future pedestrian zone, we all were working together to create an amendment. And I appreciate being able to amend the amendment or put forward the amendment for consideration. Thank you so much.
Yeah, so just a question of clarification, and this may be, I mean, it's obvious, but the essence of the change for here and the ones that follow is removing the potential of a full-time pedestrianization from the document and focusing on a permanent seasonal
Yes.
pedestrianization.
Yeah, so removing the potential for a year-round pedestrianization and entirely focusing on only a seasonal one into the future.
Okay, and of course, what's decided here is decided here. There's always a potential that a future council, when it comes to 2035 and there's a ripping up of the Main Street to change the underground infrastructure, that the council at that time may be looking at something else, but they would have to then initiate a process to move towards a full-time pedestrianization and have that discussion this time, but you're suggesting we just remove it from this document and allow that to happen if it's going to happen, but don't set it up here.
If we go through the process and that it changes, and part of the reason why I want to solidify this decision now is that it means that all of our planning processes moving forward can focus on an actual outcome, which is a seasonal pedestrian zone. If we pass the bylaw with it may be a year round, all of our planning doesn't have an actual target, because it could be or it could not be. Right? And so if we actually, we need to have, I believe that this is our, if we don't want to make this decision now, then perhaps we could consider a plebiscite as part of the municipal election. Because that would be another consideration for me, because like this is a huge decision marker for our community. And it's one that I could see going to a plebiscite to help inform a council decision if we don't feel that we have what we need to say, yes, we want a full year-round, potential of a full year-round pedestrianization or not. I feel I have what I need to make this decision now.
Right.
But I think that Banff went to a vote of the electorate through a different process. But to me, because of the fact that it is their main street and it's a vital part of their identity.
So thank you, Councillor. So there's an amending motion on the table to the amendment. It deals specifically in the amendment under Section 8, under the first sub-bullet, where it says by adding redesigned and potentially. Your motion is to strike out and potentially and substituting and seasonally. All right, speaking to the motion, would any council member like to do so? Councillor Mara.
Thank you, and thank you, Councillor Faubert, for bringing this forward. I too feel the same way, and most of what Councillor Faubert has said. And then I stated before that I don't think we're ready yet for a complete closure of Main Street permanently, but that's for future councils that could bring it forward. So thank you for bringing this forward, and I will support this motion.
Okay. Councillor McCallum.
Thank you, Your Worship. Unfortunately, I will not be able to support this. And I appreciate the feelings that you have, Councillor Faubert, with regards to this. I actually feel that Main Street is more mine when it's closed. I explore shops more during the good weather, those 6 months, than I do in the winter, to be honest. And I feel that I see, anytime you can hand over the street to the people, especially the kids, like, that's fantastic. I don't think a Main Street has to operate to cars or be open to cars for it to function as a true Main Street. But I also think that it's taken us 5 or 6 years to get to this space where we're actually embracing a seasonal closure. And so I think that the decision on whether or not a future council or the community would like to embrace a year-round closure is something best done into the future. And I feel that by putting in this amendment, we are actually making it tougher for a future council to make that decision. So I won't be able to support this. I appreciate the passion. I think that some of our planning will go towards this, but not all of our planning. I think that's an absolute that's not true. But I think that in the meantime, administration can keep our seasonal closure, making it the best that it can be, and then allowing the public to imagine what full closure would be like and whether they want that or not in a future year, in about 10 years actually, which is, I think, an appropriate amount of time for our community to decide whether that's something that's attractive to them. They might decide that none of it is attractive and fully close it to people and open it to cars only. But I think that I don't want to close that possibility off. And right now I'm happy to see a partial closure for the year, and I look forward to see what happens in 10 years when a future council has to decide as to whether they want an annual closure or not. Thank you.
Thank you, Councillor. Councillor Ma.
Thank you, Worship. I wanted to also say thank you for speaking so passionately there, Councillor Faubert, and speaking from the heart as a long-term resident. Unfortunately, I won't be able to support the motion. I'm hesitant and leery to lock out the potential for a full-time pedestrianization zone. I think where we're going as the amendments are currently written, we still have the flexibility. When I look towards my family, I look at my kids, they eagerly look forward to having the Main Street closed, and this is actually a formative time for them growing up in the community. And who's to say it's not necessarily a bad thing that they would enjoy more pedestrianization down the road. So locking out the potential opportunity, especially in light of potential infrastructure that has to come within the next 5 to 7 years, I feel it's kind of dangerous to set up a precedent where we are really not allowing the option, whereas right now we still have flexibility. So thank you.
Thank you, Councillor. Councillor Graham.
Thank you, Your Worship. The wording of this originally came as, we are going to do this. We are going to close it to a permanent, full-time, year-round pedestrianization. And I think for the same reason I was nervous about that, I'm nervous about this. I like the flexibility of being able to determine in the future what this may or may not look like. Prescribing to a future council, this will be this way, is much harder to undo. I think about all of the community feedback and all of the process that we've done to get to this moment. And I know that there are some people that don't appreciate the pedestrianization at all of Main Street. And I know that there's a lot of people that do. So for that flexibility in the future and that ability for our community to make that decision as a whole, when that time comes, I won't be able to support your motion.
Councillor Hillstead.
Thank you, thank you, Councillor Faubert, for bringing this forward. I could go either way on this one. Right now, I'm more leaning towards what the current motion has and not your amendment, just because, again, as Councillor Graham just stated, we went from being full guaranteed pedestrianization to now it's a potential. We will still have the seasonal, but basically that will get determined in the future. And we have really great staff and they can figure out how to work with what we're giving right now. And you can design a street for seasonally, you can design it for the permanent, you can actually design it in such a way probably that you could do either or. It can either stay seasonally forever, or it could go revert back to just normal Main Street, or be a full closure. You can design a street in such a way that any three of those options is possible. So I don't think this motion, as currently stated, would hinder those plans. It might tweak it a little bit, but you can see places all over the world that have a street that can be both. So I have complete faith that admin can figure out a street design in the future when this actually comes up, because again, it's a ways off. I like the current wording, so I'm going to stick with our last meeting's wording, and I'm not going to be able to support your motion.
Thank you, Councillor. And thank you to Councillor Faubert for bringing this up. I actually don't see how this prohibits, this amendment would prohibit a future discussion. I think it provides greater certainty within this document of what is being planned with this document. I think that those conversations can still go ahead at a future date. I am not convinced yet of full year pedestrianization. Anytime I've talked to people about it, they think, oh, remember how we close off Main Street in winter for this, that, or the other thing. But it was a very specific moment. And it wasn't an everyday, always type of thing. And so I would rather that this come forward to council at a time in the future with some sort of a plan and how it's done, rather than just leaving it open-ended as something. So I would actually, I think it will be for naught, but I will support your amending motion. I'll then, Councillor Faubert, did you have anything you wanted to say in closing?
I do.
Please
Thank you,
proceed.
Your Worship. This is one of the things that I think is our job. Our job as a council is to set direction and make decisions. And I believe that what the motions that I put forward do is set that direction now. Future councils can take the direction we've set and amend it. But by having an area redevelopment plan for our downtown that says we may permanently, it doesn't plan for the future for me enough. It doesn't set enough direction. And that's our job. And I think that we should do it now and not leave it to a future council to say what the future planning and work effort that goes into our Main Street should be pursuing. And that is not a year-round, at this point, a year-round pedestrian zone. I think that part of the challenge too around this is wrapping your head around the idea that a redesigned seasonal pedestrian zone, what does that actually look like in winter? I don't know. But I think that it can be something that still works with vehicle access in winter, but it's not this, it wouldn't be the street that we have now. And when this draft ARP came to us and we passed first reading and we put it out to public hearing, It contained a direction to have a permanent year-round pedestrian zone. We put that question to our community in a public hearing. We asked them, what is your feedback on doing this? And from the feedback I heard, I felt that it would be appropriate for us to set that direction now and to move into the future in a more focused way. It doesn't preclude the ability of someday achieving a winter closure, but it maintains some of the things that I think are really important that a full year-round closure would not maintain, and that's access to local services. My dentist, my chiropractor, my eye doctor, right? So I'm trying to find like a hybrid of the future where community and visitation, we have the sweet spot of downtown is amazing for everyone. And so that's my close, and I don't think it was very good, but I really appreciated the debate of my colleagues. Thank you so much.
Thank you, Councillor. I'm now going to call a question on Councillor Faubert's amending motion, proposed amendment to the amending motion. All those in favor? All those opposed? The motion is defeated with Mayor Krauser, Councillor Faubert, and Councillor Mera in favor. So then that makes your following motion moot, okay? Did you have any, do you have one that's to the amending motion?
I wrote it to the amending motion.
Okay. Let's do that while
Okay.
it's on your materials that the clerk has.
So it amends section 4, land use and urban design as follows. So it would add this motion to the amending motion by adding a convention center between event space or recreation facility. So part of the public hearing, we heard from Tourism Canmore Kananaskis, and one of the suggestions was that we consider a convention center as a potential use in the civic corridor space. I think
just one second. Is this part of the amending motion, the red line? This is a change to the red line?
No, it would add to the amending
So
motion.
let's just save that.
Okay.
Let's save that to
Thank you.
a further amendment to the actual document. Okay. We're going to come back to that at a different section. Does anybody have then? I think Councillor McCallum, did you have some amendments to the proposed red line? Okay, so please, I'm going to turn it over to you then to present the changes to the amendments that contain the red line.
Okay, God help us all. As you know, I'm struggling with my Mac. See, that didn't go on. So good grief. I had two amendments. One was, let me see.
So I see the first one is under section 4.1, the wording around the restrictive covenants.
Yes.
And you're wanting to change despite the above?
Yes,
Okay.
so on page, yes, on, of the, page 42, I believe, under residential, 4.1, where it says despite the following. Now I gotta remember what I sent. Oh, I'm not even looking up. In addition to the above, in 4.0, like the magic that you make, Ben. Property subject to restrictive covenant registered. There was a motion made by the mayor to permit the RC properties to stay as R1, which is interesting because the R1 that's on the restrictive covenant and the rules around that are not at all in line with our current R1 rules. So I don't know if anybody's actually looked at the restrictive covenant. So none of the homes in that area are supposed to be more than 7.5 meters tall. And there's certainly some new homes that have been built that are taller than 7.5 meters. In addition to setback rules, as well as rules around siding. So all things involved in the restrictive covenant, which really speaks to me that the RC is, that's what planning looked like in the 60s. So anyways, I would like to see those properties have the ability to retain their R1 status should they want to redevelop. But if they don't, to be able to align with the neighborhood that is embedded in the policy with regards to R4. That is my amendment.
So once again, just to clarify, it's to allow both to happen?
Yes.
Okay, so to allow the R4 and to allow the restrictive covenant.
So that means that anybody that has an R1 won't be considered legal nonconforming. And if they choose to discharge the RC or not, there is modern ways of dealing with restrictive covenants in neighborhoods that were planned this way in the 60s.
Thank you for that clarification. Speaking to this amendment to the amending motion, Councillor Faubert? Oh, I'm sorry, did you have yours on?
I think that was an old.
Oh, that's a legacy? Okay. No, sorry. You know, I'm going to speak against this amending motion based on what I said previously. I don't think it's an advance to create a number of condos in the downtown area that will sell for millions of dollars. There is the potential of some affordable housing. It's a matter of the cost benefit based on what we achieve through the changes. So I actually prefer the wording that was proffered from administration in response to council's previous direction. Would anybody else like to speak to the motion? Councillor Ma.
Thank you, Your Worship. I just was looking at the restricted covenant, and I'm just trying to understand it. Perhaps this is a question for administration, where it speaks to how the government shall not be discharged unless 60% of the total number of lots agree otherwise. So I'm trying to understand if we were to execute Councillor McCallum's amendment, if there was someone that wanted to take advantage of the R4 situation, would they also need to step through the hoops of the covenant and get 60% compliance? I'm trying to understand that. So if anyone could help me, that'd be really great.
Looking to Mr. Drydzek, who's coming forward, so just bear with us.
Thank you.
Sure, I can help you with that. So the restrictive covenant and the bylaws, including the land use bylaw and the ARP are separate. They're different instruments. So whether the ARP directs R1 in the land use bylaw or R4 or something else, how a restrictive covenant stays on title or gets discharged is a separate question. So say someone wanted to have the restrictive covenant removed, they would go through, presumably, that process of trying to gather consents and getting that requisite 60% consent, and then coming forward to town council to get a decision on discharge. And if someone wanted that off their property, they'd be in the position of needing to do that regardless of what the ARP directs for zoning of that property. But I think that the other thing you want to think about here is what the proposed amendment here is doing is directing that a property that has a RC on it should keep the R1 zoning. And if you don't like that, you might say, well, we don't support that motion. We want the ARP to direct R4 zoning. But in either case, this motion isn't causing the RC to become the land use bylaw. Okay, it's yeah.
It wouldn't be for the town to enforce in either event. It's for somebody, let's say a neighbor, they see a development permit notice or something. It's up to them then to enforce the restrictive covenant, and they may do that through the courts or otherwise. It wouldn't be through the town.
That's right. Restrictive covenants are enforceable by the properties that have the restrictive covenant on it against the properties that have it on it. And in this case, for this restrictive covenant, the properties that are restricted and the properties that can enforce will be the same ones, and that enforcement would take place through the courts. But the municipal planning and development authorities would still look to the ARP and the land use bylaw for their guidance. So you have two regimes going on here at the same time. One, private landowners may choose to attempt enforcement of the RC in court against others, and then municipal administration looking at the plans and bylaws.
Great, thank you. So while we are debating a motion, Councillor Ma did seek clarity, and so I am going to, I'm speaking. And so I am going to also open up the floor to Mr. Cairns, who would like to add to that clarity, I presume.
Yeah, thank you, Mayor. Maybe a little bit from the planning perspective. So just to clarify further to Adam's point, the ARP, of course, is not the land use bylaw, and land use bylaw changes would be part of implementation. As we had advised, I think in our previous reports, especially I believe it was the May 27th meeting, we have a little bit of a lengthy write-up on the question of the RCs. And I think the clear takeaway, though, in response to Councillor Ma's question is just that the presence of an RC does not limit council's ability to make zoning changes in the same way that we have, new R1 builds in the restrictive covenant area where we issue permits based on the R1 zoning and the regulations in it. And there's precedence that the zoning bylaws, if they conflict, that it can take precedence. And that's why, as we advised previously, RCs may linger on title for decades or even over centuries, even though they're no longer in effect because zoning has started to supersede them or the regulations may no longer apply.
Thank you for that. Councillor Maud, did you want to speak to the motion?
I just want to make sure I understand Mr. Dryzik's perspective. So even if we were to go to, say, like R4, there could potentially still be a high threshold for a property owner to do what it is that they wanted to do.
Well,
would that be a correct assessment?
The property owner in doing what they wanted to do would have to consider the fact that the RC is still there. When they go to apply for development permits, the town will need to screen the development permit applications under the land use bylaw. If something's a permitted use under the land use bylaw, then they're entitled to a development permit if their application complies with the regulations. And that's the case whether it's R1 or R4 or anything. But that landowner is still going to think about the fact they have a restrictive covenant on title and what that might mean between them and other people who could enforce it. Does that answer your question?
Yeah, I think I'm getting to understand it. It's still quite a layered process regardless.
It's a layered process. The restrictive covenant isn't getting turned into the land use bylaw here. It includes different standards than the land use bylaw regardless of what that would be.
Okay. Thank you.
All right.
Thank you. Thank you. Councillor Maud, did you want to speak to the proposed amendment to the amending motion put forth by Councillor McCallum?
I'm still pondering all the pieces at the moment. I'd just like to hear if there are other councillors have opinions as well.
Okay.
Thank you.
Councillor Hillstad?
Thank you. I actually have a question of clarification as well. I'm just wondering if this change actually changes anything, just because after the ... it's registered by way of covenant 141 kg, figure 4.10, may retain their existing. So there's already a may in there, so I don't know if this change actually changes anything, because despite the above or in addition to the above, doesn't change the fact that there's a may, and the may speaks to the fact that they may retain their R1 or they may not. So just some clarity on that, because this may just become moot.
Okay, so you're seeking some clarification as to whether that
If this change actually
changes anything. Yeah. Mr. Cairns, do you have any thoughts on whether this change would change this section?
Thank you, Mayor. I believe whatever the wording is, I believe the outcome or impact is probably minor. The policy direction as written clearly, I think, articulates that the property subject to the RC may retain and be governed by R1, but it does not prohibit R4 from ever applying to those properties. So if a property owner wanted to come forward and apply to rezone their property to R4, council could consider it at that time, and it would not outright conflict with the policy. The ARP would not need to be amended in that circumstance as it's currently written. It would just be a decision of council at that time. With that said, I think with the proposed amendment wording, I think it's also fine and amenable as well. Although the way administration has prepared it probably provides a little bit more policy clarity. But yeah, I don't think there's any major implications either way.
Great, thank you. Councillor Hillstead, did you have anything you wanted to add?
No, again, to me, it's either or can work, so I don't currently have a preference for either one, so yeah, I gotta now think a little bit more too.
Okay. Anyone else wishing to speak to the motion? Councillor Graham?
I think you should call it Hillstad's fencing instead of Hillstad's roofing. Yeah, you know, when this issue was originally brought up, you know, I had this idea in my mind that restricted covenants were a little more sacred than other things, but after learning more about them and understanding them more, and reading the existing one that is currently on there, I am comfortable having this as an R4 neighborhood with this restrictive covenant sitting there, so that neighborhood can decide. I know that there are buildings in there that would not comply with this restrictive covenant. I find that just curious.
Once again, that's not the town issue.
Right, it's not a town issue. You know, the people who live in that neighborhood, it's up to them to act on that.
Okay, thank you for that. Councillor Faubert?
This one was really confusing for me because it felt like just a language preference change, but I'm going to stick with the original language because despite is a word that implies an exception or a contradiction, and we are giving an exception to the R1s. And
Yeah.
so that's why I was so confused as to your position, Your Worship, but now I understand it, and so I'm not in support of this, but not because I don't, it in essence is the same, but legally not. So.
Yeah, I maybe should have clarified. My most preferred word for there would have been notwithstanding, but to put it in plain language, notwithstanding is usually despite or regardless or even though, you know, so that's why I preferred the original wording. Anyone else wishing to speak to this motion by Councillor McCallum? Councillor McCallum, did you have anything you wanted to add in closing?
Yeah, thank you. So I agree and recognize that the restrictive covenant is separate from the town. I think it was interesting that the town lawyer told us that 60% of the neighborhood has to agree to a change from the restrictive covenant, but they're that clearly hasn't happened in recent years, because there are homes that have been rebuilt in the recent years that clearly exceed the criteria and rules outlined in the restrictive covenant. So that being said, you know, I understand some people's concerns that by permitting an R4 in those areas, that you're going to get more expensive homes. Well, the homes that are there are already like $4.5 million for a single-family home. I would, you know, personally prefer to see that broken up into smaller increments of payments for homes. And so if you could get, it is actually more affordable to buy a $1.2 million with a suite, say, than a $4.5 million home to house two people. And that is what we are seeing occur in that neighborhood. So I guess it's like the lesser of the evils to a certain extent, and I would prefer to see a higher level of density, because that density allows more abilities to put in suites, which therefore works as mortgage helpers, which therefore feeds into the idea of providing a range of housing, both market and non. So, yeah, that's my argument. Thank you.
Thank you. I'll call the question then. All those in favor of the amendment proposed by Councillor McCallum? All those opposed? The motion is carried with Mayor Krauser, Councillor Faubert, and Councillor Mera opposed. Okay, so that change is made. Councillor McCallum, did you have any changes, other changes to the red line?
Yes, so the only other change I had was, let me scroll through. Oh, sorry. My assistant. I should just take you with me into the next job.
Somehow it keeps getting turned off, but okay.
So at the end, at 8.2.1, sub 2, admin has provided some clarity on, and I am adding on to the back of that. So we have to assume that you're going to accept what's in between. The bottom bun, the black line is the top bun, and then the red line that admin has put in is the meat. But basically it's to, when reading the policy, it was a bit confusing, and it was interesting because I had put it towards two different members of admin and got opposite but same answers. It's sort of strange. So I just wanted to create some clarity so that a future council doesn't find themselves backed into a corner, and that's that the timing and delivery of public parking facilities will be sequenced subject to planning and budgeting considerations. So the way that it originally read was that basically, short of like firebombing an entire swath of downtown, there's no way you're actually going to be able to replace the parking, because it all has to happen within the footprint of downtown. And this just clarifies that there's actually sequencing involved. That's all.
Okay, I'm just looking here at the red line. So it's right after any reduction in off-street parking?
Yes.
Okay, so that is sub 2. So we're looking on page 98. This is under 8.2.1. It's under sub 2. There was a red line portion added that any reduction in off-street parking facilities, and Councillor McCallum is proposing extending that red line to add the timing and delivery of public parking facilities will be sequenced, subject to planning and budgeting considerations. Right? Am I accurate in that, Councillor McCallum?
Yes, and my intent is that it happens like immediately after, but it can't happen at the same time.
Yes.
It's
There's
not physically possible.
Likely an interim transitional period.
Yes,
All right.
and I just didn't want a future council to be backed into a corner by accident.
Okay. The amendment to the amending motions on the table. Would anyone like to speak to it? Seeing none, I'm just going to call the vote. All those in favor? Carried unanimously. Councillor McCallum, did you have any other changes to the red line?
I'm done talking. Bless you all.
Okay, I am going to propose so that we can have the discussion. I didn't forward this because it just came up during the discussion or presentation by Mr. Cairns. With regards to Main Street, there is some proposed red line to section 7. And so in attachment 2, let me just see where this is. Right. Just gonna pull up the red line just a sec. There we go. Just one sec. 239 you said? Or 39? No.
What, 239 total package or 38?
There we go.
Right.
Okay, so okay, I'm sorry. I'm trying to pull up the red line that has this wording. Oh, right here. Page 38 of the package, but page 239 showing the red line. Under building design, there's a section 7 that the red line is to remove the original wording and then insert shall not exceed 11 meters and should generally not exceed 2.5 stories. My motion is simply to delete the amendment and revert to the original wording in that section. So this is within the amending motion. This is the section that pertains to section 7. It's under section 4, land use and urban design, and then under the bullet point, second bullet point, commercial core, section 7. It's to strike out that amendment, that bullet point, that amendment, which will then allow it to revert to original wording. What I heard was that there will be some potential unforeseen and unintended consequences by making the change, and in fact, the concerns that were raised can already be met with the original wording. And so as such, I have decided I prefer the original wording and would like to avoid those unforeseen and or unintended consequences. And I would like to open it up to hear what people think. So Councillor Hillstad.
I will support this. If you didn't bring it forward, I was going to. So I spoke to this at the original meeting that, you know, how it was originally worded, I thought was fine. So I'm happy to go back to the original wording because I think it achieves what we're wanting to achieve, and let's leave it at that.
Okay, just looking at the wording up there, and I'll leave it to the clerks to decide if that's ultimately the right way. It's essentially getting rid of the amendment, and that would automatically revert it. So it's not inserting, that would automatically revert it to the original wording.
Yeah.
Yeah.
That's the second bullet point.
Okay, so Councillor Faubert speaking to the motion.
Oh, yeah, I was going to mention that we didn't need to insert anything because it reverted back to the original. If we strike out the amendment in the amending motion. I'm in favor of this. Thank you for bringing it forward. I think it's really important that as we move into the future of our downtown and the fact that redevelopment is something that will and should happen, we have to work with our local economy to build success and prosperity for our community together. And if we were to limit how the heights of buildings from what they are today, there would be unintended consequences that would prohibit us in delivering on our mandate and fulfilling our roles as elected officials in our community. So I'm really grateful for this. I think that over time, the gradual redevelopment of downtown will allow people to adjust to the fact that a 3-story building is what's allowed today everywhere, even though when you look around, it is not the majority of our built structures that are meeting what's allowed. So these changes are going to be uncomfortable for us, but the MGA and all of the legislation protects the property rights of the people who own those properties as well. So that's important. Thank you.
Thank you, Councillor. Anyone else wishing to speak to this proposed amendment to the amending motion? Seeing none, I'll call the question. All those, oh, Councillor Graham. Gotta go quicker, man.
No. Are you planning on taking a lunch break after this motion? What's your plan?
Well, I believe that we'll be able to then vote on this amending motion. There are a couple of other amendments. My preference would be to get through the section. I don't think it's going to be long after this.
Okay. Thank you, sir.
All right. Okay. So I am going to call the vote on my proposed amendment to the amending motion. All those in favor? Carried unanimously. All right, so then I do not believe there's any further changes to the red line. Just double checking. No, there's going to be further amendments, but just to this amending motion. We've got the amending motion on the table now that's as amended that captures all the red line. We are then I'm going to go to the historical amendment for Canmore Hotel, and then I'm going to open up to any other amendments, which will come back to the one that you had put forward. Okay. So, I'm now going to call the vote on the amending motion as amended. All those in favor? Carried unanimously. Okay, so now I will put on the table with respect to the, I just need to pull it up here. Mr. Karen sent me some wording here yesterday. So this is with regards to the Canmore Hotel Direct Control District, and the resolution I'm putting forward is that council amend motion, and it should be 2025-05, by amending Schedule A, Connect Downtown Area Redevelopment Plan, by adding the following section after Section 7 of the Land Use and Urban Design Commercial Core, and renumbering subsequent sections accordingly. And that is 8, and this is the addition, developments occurring under the Canmore Hotel Direct Control District 2015-15 shall be governed by the height regulations established in the applicable direct control district, which may exceed the height limits identified in this plan. In speaking to the motion, I believe that this is a good catch by administration to make sure that we are respecting that which was arranged previously. There was some give and take. I recall in 2015, Councillor McCallum and I were on council at that time when this was put forward, and in order to retain the historic element of the Canmore Hotel, there was also some allowances for the neighboring property. And so this respects that agreement that was reached at that time. Would anybody else like to speak to the motion? Seeing none, I'll call the question. All those in favor? Carried unanimously. Now I will open it up, and going first to Councillor Faubert. You have that other amendment that you wish to, and now if you could identify the page number. Yes. Thank you.
I lost my page.
So the Civics Center corridor, that's under section 4, right?
Yeah. I don't know why I had it up on my page and now it won't show. Sometimes when I go too fast, my PDF stays on the same page.
So I believe you're looking at page 38 of the report, and it's section 2, and that you wanted to add oh, maybe it's the wrong.
Okay, I'm in, I know what's happening,
Okay.
I was in the red line.
Ah, okay.
Of course, I can't find the page. 151?
Okay.
Yes, that's it. Thank you. Thank you. Clearly, it's lunchtime. I did not write my motion, I think, well, because I wrote it as an amendment to the amendment, but similar to the, so I don't know if it's, and maybe if the
I
clerk's.
think you're just simply going to insert a word, right?
Yeah. So
Okay.
it's under uses, section 2, uses that support year-round demand and interest should be encouraged, such as an indoor market hall, event space, or recreation facility.
Yeah.
I wanted to add a convention center in there. It was brought up by Tourism Canmore Kananaskis during the public hearing.
Yeah.
I debated this because I feel event space could already qualify, right? But when I also looked at the uses for where the old fire hall is, a convention center is listed there. And so I think that the potential in the civic corridor for that use aligning with other uses and the amount of space available makes it an appropriate use to consider here. And I wanted to bring it forward and see if that would get support. If not, that's okay, because I feel event space already gives some opportunity to have those conversations into the future. Thank you.
Thank you. I'm prepared to support this motion. It just adds another potential opportunity. Doesn't mean that it will come to fruition. It just means that it's a possibility and it can be explored if there's an application brought forward. Anyone else wishing to speak to the motion? Seeing none, I'll call the question. All those in favor? Opposed? Okay, so the motion is carried with Councillors Graham and McCallum opposed. Okay, any other changes, further amendments to this document that anybody would like to propose? Seeing none, we're back to the original motion as amended. So now the motion on the table is that Council gives second reading to Town Centre Area Redevelopment Plan 2025-05 as amended. Anyone wishing to speak to the motion? Councillor Faubert.
We're at second reading.
Second reading.
As amended. I would have liked to see a stronger direction on the pedestrian zone. However, that aside, I mean, we have a plan to make a plan for that, so that's good. Everything else that I think that we've accomplished in Connect Downtown, I think is really solid. And I think that the changes that we have made is really responsive to the feedback we got from our community. And part of the magic of this process is that we have administration, we have planners, we have experts, and they do the work of trying to take our ideas and put it into a plan that works within the legal framework that we have to operate in. And then we put it out to the community, and the community kicks the tires and tells us what they think, whether or not it aligns with their vision of the future. And then it comes to us, and then it's our job to take all of that information and put it all together and come up with a vision, something that delivers into the future for our community. And I think we've done a really good job. I really like the fact that we've dealt with so well with Riverside Park. I like that we've been extremely responsive and strategic and visionary around, I think, the future of parking, which is a lot more complicated. And there's all sorts of stuff that I don't even know if we know yet. Increased, in terms of infill density, I know that there was a desire to see increased density in some of the residential areas, and there is that restrictive covenant. I'm torn on this one because I'm not sure that the downtown ARP is the right place or time for us to have the full conversation around infill density for the Valley Bottom that we need to have as a community. And that includes Larch. It's the whole Valley Bottom. We need to be having an infill discussion. And so I'm all right with this plan putting that aside. To me, this plan doesn't guarantee those R1s into the future. To me, this plan just says it's not the time for us to have this discussion yet. So that, to me, is a future discussion I'm going to want to have. So stay tuned, residents of that area. I don't think that's over. I also think that the discussion we had around roof heights was really important and educational, and just like a learning opportunity for everyone to just kind of wrap our heads around what do we get to say about what our future looks like, and what don't we get to say what our future looks like. And there are rules that we have to fit within as well, so that's important. And then I'm really thankful for the opportunity to bring forward some amendments, to be part of all the discussions. And this has been a really long process, and I know that there's still more to come on the discussion on Main Street and a pedestrian zone, and I look forward to being part of that. Thank you. I will vote in support. Thanks.
Thank you, Councillor Colbert. Councillor Ma.
Thank you, Worship. I'll keep this pretty short. I remember we were talking about this all the way back in 2021 and even before then. So here we are 4 years later, and we actually have what I think is a pretty solid plan. I wanted to commend administration and Josh Cairns for stick handling us through this entire process. I think some huge highs were hit on engagement. I think we've also gone through a lot of back and forth with the community. I think we tamped down some unnecessary fears about stuff, and we were also responsive as well. So to my fellow colleagues, administration, particularly Josh Cairns and communications team, thank you so much. I'll be voting in support.
Thank you, Councillor. I'll also be voting in support. I sat on the Downtown Business Improvement Association from roughly 2012 to 2017. And during those 5 years, there was a real desire for the downtown planning to be updated. And for financial reasons, it was, and perhaps different priorities, it was kicked down the road. And here we are in 2025. And I'm very happy that this is now moving to through its final stages, as it's been needed for a long time and desired for a long time. I believe that the town center AARP, as it's presented, represents a better blending of the surrounding areas and other areas that are in proximity to the center, the town center as we know it. I believe that there's been excellent public engagement, and we had a really excellent public hearing in which we listened, and there were changes made as a result of what we heard. There's been an assurance of the preservation of parking. There's ongoing, now it's not a year-to-year thing, but there will be an ongoing seasonal pedestrianization of Main Street. During the process, there was a lot of concern around Eckloff Park, and that has been preserved. We see an expansion of Riverside Park, which I think is a real positive for the community as a whole. And I could go on and on. I think that this is an excellent document. I really appreciate the process that was used, and I echo comments providing kudos to administration, particularly to the planning department and communications, but it was also supported by so many other departments within the town. Of course, this is a high level, There will be now changes to the land use bylaw to reflect the ARP. There's also, through the budget process, there will be projects that come online over time, and that will be dealt with through our regular project assessment and budget process. So there's still more details to come, but I believe that we've reached a very good place for our area redevelopment plan. Councillor McCallum.
Thank you, Your Worship. So I'm prepared to support second and third reading at this time. This is my last ARP. My first one was the Bow Valley Trail ARP, which, much like this one, was an ARP that involved many, many stakeholders and many landowners. And I feel that this process has been similar in terms of the fact that you get to the public hearing and people have read some or bits or all or none, and they provide you their feedback, and there's a lot of fear in that. And then when you get an opportunity to have conversations with people or actually dig into where the fear really lay, you realize that there's ways around it. So I am happy with all of the aspects that we've put forward. I think that we are setting the stage for a really vibrant downtown. And I look forward to seeing how that unfolds. I could pontificate for days, but I will not. I would like to thank administration, and I would like to thank all the members of the public that came forward during the public hearing. It was a very robust public hearing, and we really got to hear some individual stories from people as to how certain things would specifically affect them, or things that they had vision for that they would like to see moving forward. And I see many of those touchstones within this plan right now. So I'll be, again, prepared to support second and third reading. And thank you for your time.
Thank you, Councillor. Councillor Hillstead.
Thank you. I'm also ready to support second and third reading. Change is always difficult. And you can see just from our discussions today, there was a lot of close votes, one way or the other. So it's not easy. It's not just all, you know, everyone's unanimously agrees with this. There's a lot of aspects of this plan that is going to really resonate with some residents, and there's going to be parts of it that will not resonate with some residents. It's just change is hard, and some people will look at this and think it's amazing. Some will be disappointed. But on the whole, I'm happy with where we got. I think we did a lot of changes from the public hearing, and again, as everyone's already stated, like, thank you, public, for coming out and giving us your feedback and emailing us and just taking the time to let us know how you feel on this. I think we got to a good point. Is it perfect? Well, it just depends on who's looking at the document. That's for them to decide. But I'm quite happy with where we got. It's been a long time coming. I know this has been punted down the road a few times now. It was supposed to happen in last term, and a little thing called COVID kind of kicked it to the can. Yeah, it's been a long time coming, and I'm happy that we've now got a path forward, and yeah, ready to support.
Thank you, Councillor. Councillor Mera.
Thank you. I too would like to thank everyone who's been involved. I was part of the BIA when I first got elected, and I know my first strat plan was with Miss Nicolette when she first came to town also, and there was myself, her, and our ED at that time. Beth Vandervoort? Vandervoort, yes. Just the three of us sat there and went, oh, where is everybody? So it was sort of a shock to us. And I know that this has been a long time coming, and that the down businesses wanted this to come forward. It's bigger than I think everyone thought it was going to be, more expansive. It took in a bigger area of the downtown. And I'm happy with what's come out of this. As it moves forward, I know there'll be some tweaking. I would also like to thank Josh and his admin team. I know they did a lot of the heavy lifting and a lot of the taking of advice or options or solutions, and looked at all the surveys and put everything in and came out with what we came out with. So I'd like to thank everybody for their participation.
Thank you, Councillor. Councillor Graham.
Thank you, Your Worship. You've all spoke very well and very eloquently to this, and I won't belabor this one too much, but I want to thank you all for a robust conversation over a long, lengthy period. Some of the topics that got brought up were not easy. It made us stand up here and think thoughtfully about what we were about to do, and we didn't agree on all of those things all the time, and I think that's actually a good thing. You know, Mayor Krause, your leadership through this and your creativity, getting us to second reading, I really appreciated that a lot. I think that worked really well. Administration, thank you all. This was a big one. This was a huge lift for all of you. To the public, to everybody that came out and spoke to this, I appreciate all of the perspectives and how you showed up, for the most part, was appreciated. I didn't realize how much of a heavy lift this was going to be when we first approved this thing right at the beginning, but live and learn. Thank you all.
Thank you, Councillor. I'll now call the question on second reading as amended. All those in favor? Carried unanimously. I'll now move the council give third reading to Town Centre Area Redevelopment Plan 2025-05. Is there anything anyone wishes to add? Seeing none? Seeing none, I'll call the question. All those in favor? Carried unanimously. And now I will move the council give second reading to revised land use bylaw amendment 2025-13, changes to variance powers. Anyone wish to speak to this motion? I see it as very much a transitional, to support the transitional elements when we adopt a plan. Call the question. All those in favor? Carried unanimously. And now I move that council give third reading to revised land use bylaw amendment 2025-13, changes to variance powers. Anyone wishing to comment? Seeing none, I call the question. All those in favor? Carried unanimously. I'm now going to call a break for lunch. Let's return at 1:45. Mr. Stiver to let me know when we're streaming, please. All right, we are back from our lunch break, and now we're moving on to agenda item G4, Business Registry Bylaw Amendment 2025-24, Visitor Accommodation. Ms. McClett, the microphone is yours whenever you're ready. Welcome.
Good afternoon, Mayor and members of Council. I am here related to Business Registry Bylaw Amendment 2025-24 in relation to visitor accommodations. And I have two motions or two recommendations that I'll be asking to decide on today. One is to give first reading to the Business Registry Bylaw Amendment 2025-24 Visitor Accommodation, and that council schedule a public hearing for Business Registry Bylaw Amendment 2025-24 Visitor Accommodations on September 2nd. What brings us here today is at the previous updates to the Business Registry Bylaw, Council asked us to return with recommended amendments to the Business Registry Bylaw tied to exploring what it would look like to align visitor accommodation business licensing to that of the previously approved tourist home amendments that Council approved at that point of time. And just as a reminder, mainly to public, as Council is well aware of this, is that visitor accommodation refers to the purpose-built short-term rentals as opposed to tourist homes, which are residential properties used for short-term rentals. At present, visitor accommodations may be licensed under a property management company, and so they could have multiple different tax titles, assessed titles, be housed under one license, being the property manager. And as comparison, we have about 1,452 individual tax rolls currently assigned to visitor accommodations that that are currently covered under 389 business licenses. There are a number of benefits assigned to aligning that process. One is there's a consistency, there's clarity, it's one size fits all. You run a business in a location, that location has a license, similar to companies like Beamers or Eclipse that have multiple locations, and each location has a license. It smooths out that process. It's consistent permitting process and helps enforce the rules more efficiently with better public reporting, investigation, and follow-up, so that from the enforcement side, there's an ease in that. It ensures that all operators are treated equally, regardless of property type or ownership model, creating a more level playing field for all. And it streamlines licensing and improves our ability to monitor impact on housing neighborhoods and better provide for planning and compliance tracking, licensing as supported. So licensing for an individual unit, we are recommending at a 150, which is aligned to our basic licensing process in that space. We did do some engagement with both tourism, the Canmore Hotel and Lodging Association, several property managers and internal departments. And there are some potential challenges that were identified in that process. Some of that is tied to concerns, resistance, for example, from current business owners operating a visitor accommodation model. They may see that this proposed change as a threat to their flexibility or competitive edge in the market. Introducing more regulations in the sector may be seen by other governments or levels of governments or external partners as a sign that Canmore is not supportive of tourism as a major driver of our local economy. Additionally, a shift to a unit-based licensing model may increase the administrative workload, or will increase the administrative workload of processing licenses. And there's, of course, town departments that are affected by that workload. More licensing mean more processing, especially for business registry and finance department. Some current owners and investors may push back, especially those who purchased under earlier interpretations of what it would look like to invest in visitor accommodation properties. And units with multiple or fractional ownership models have the potential of a unique challenge, because not all owners may choose to operate their segment or their fractional ownership as a business in that space. Sorry, my notes have disappeared. Okay, I think I got that piece of the interpreted challenges that were identified in that engagement. So we looked at what could we potentially do to mitigate those challenges if we were to move forward with aligning the processes. And so the phase implementation, for example, new developments and newly listed properties would have to comply immediately with the individual licensing requirement, others at date of renewal for existing licenses. So that is not as if council approves this on September 2nd and immediately everybody has to update their licenses. It would be a gradual process in adapting that. We discussed with council at the time of budget that should council approve this process, we would be requesting additional staffing in business registry to accommodate that workload. And currently finance feels that they can manage the impact. However, should that not be the case, they'll come back to council at that time. In discussion with legal, so property management companies identified the desire to have a bulk licensing option. So if their clients continue to want to be managed by them, that they would be able to apply for a business license on behalf of the owners. And in review with legal, that is possible. And so we just need to have systems in place in order to have like multiple different licensing, a different form to do that process. So that's all manageable. And fractional ownership could be treated under the current co-working space. So in a co-working space, you have different businesses, like the co-working kitchen has multiple businesses operating out of that space. They each have their own license. Should they generate less than 30,000 gross revenue, they would qualify for a micro business license. Now, in conversation with most property managers, they don't feel that that is an issue or a challenge. And in all things, education is key in targeting and communicating with people what the new requirements are. So this strikes a balance between accountability and flexibility in addressing what the potential challenges might be that were identified in the engagement. Outside of the updates in the business registry bylaw related to the visitor accommodation, we have some other updates, and that's around the definition of short-term licensing timelines to align with what was updated last time in Schedule A, and removal of "and on or before September 30th, which is clause 26, to simplify the language, again, to align with the 2024 bylaw updates that we missed at that time. So there are some periods and commas in there as well. And the process in bylaw updates is to say, what is the master bylaw that we want to align with? So there's a number of comments of definitions that align with the land use bylaw. Visitor accommodation is that as well. And in the land use bylaw, we speak about units and not rooms. So that has been proposed in Schedule A as the shift and the change and an update to that space, and pricing to be set in alignment to the tourist homes for the individual units. So our recommendation to council is to move forward with aligning the process to tourist home to visitor accommodation to the process we have for tourist homes with the amendments as presented to council. And that's it for my presentation, and I'm open to questions.
Thank you, Ms. McClett. I really appreciate the presentation. I have to say that with respect to the report, I really was impressed with the analysis. both for and against. I honestly didn't know which way administration was going to come down on this, and that you ended up recommending it despite the some of the challenges, and then put out the mitigating efforts. I thought it was excellent. So thank you very much for that work. Looking to council to see if there are any questions. Councillor Faubert.
Thank you, Your Worship, and thank you, Ms. McLeod, for your presentation. When you spoke about property management companies, would that be like a Solera or like a Spring Creek Resorts or both?
So property management companies are like Gleek, Bellstar, companies like that. Solera is the name of the building.
So, so it's not like a company that owns units all over the place. It's more an actual structure, and that structure has a business license as a hotel.
Correct.
Okay.
Yeah.
And then could you, I wasn't sure if I caught everything around bulk licensing options. Is that proposed in this, or what's the option there?
So it's not that's more an administrative process. So it's not a bylaw update, but we have the ability to create a bulk application form by which a property manager could apply on behalf of the clients that they serve. But as in any process, if you have an office building with multiple businesses, each business has their own license, that's essentially the same process.
Okay.
Yeah.
And then would requiring all short-term rentals to display their business license that they have that's valid now on online advertising also provide similar benefits to this option as a way forward?
Yeah, so currently, the proposal in the bylaw is, we had it in there as in print material, which makes it a bit more challenging, specifically as if a property manager advertised, the list could be quite large of who they're managing on behalf of their clients. So we moved it to online, and that is enforceable, and that could be on their online booking platforms, it could be on their personal platforms, that they just have their license numbers registered on there.
So that's part of what we'd be doing if we wanted them individually licensed?
Correct.
But what if instead of individually licensing them, we just have them display the license that they currently have, the 389 business licenses? Why can't they just display that number?
So under the current bylaw, any business that has a license has to have their business license displayed on property in view of the public. That's already a requirement for all properties, and maybe I'm not understanding the question. The challenge in some ways is that we can request a list of a property manager of the businesses that they represent. We don't have a clear view of if that's accurate or not. And speaking with some property managers, they didn't even realize that they had to provide us a list. So my guess is what we have is not accurate to the actual number of visitor accommodation units that are there based on our tax notifications.
I guess what I'm trying to understand is what is the problem we're trying to solve, and is there another way to solve it that doesn't require this amount of additional licensing for businesses and administrative work?
I'm looking at Ms. Miller a little bit because it's on the enforcement side that making sure that a business is a licensed business. So it brings some confidence of customers that are looking to stay in a legal unit, but be it tourist home, be it visitor accommodation, that they know that the business is properly licensed. So having displayed that number is a mechanism to do so. The easiest way from an enforcement side, and I think that has something to do with Granicus, and I think Scott has his micro on mute, can maybe speak to that.
Mr. Mackay?
I think you answered the question, Ms. McLeod, quite well. It's very difficult to determine in an enforcement context whether a given unit is, say, a visitor accommodation unit that has a license or has a bulk license potentially, whether it's individually titled or not, or could be a tourist home, in which case it has a different licensing scheme currently. So we're looking to align those so that enforcement can be done more, I guess, more easily. And I would say it treats like units in a like way as well. So potentially there's an equity piece across what I would suggest is a similar land use type.
Because I feel like it's possible to achieve that without having to require every single unit of visitor accom in this community to get an individual business license. So that's my question, is that a potential alternative? Is there another way?
So we are currently requesting that list is there, that list is available, should we need to pull it. It is not always accurate. But I think more importantly, what in review of this process we looked is what is equitable and what brings alignment. There's a lot of work that goes into identifying, is it a visitor accom, is it a tourist home? Sometimes we have buildings that have both. And a lot of work for our business registry team to identify that. In this case, if somebody calls, do I need a business license? Is it an individually taxed unit? Then the answer is yes. Clear, no more work done, right? So it simplifies the process in which we assign licenses and the work that is on the administrative side to do that by aligning both processes, and it helps with enforceability. Are there other ways? Yes. This has been identified as probably the simplest way for us to do so effectively.
Dr. Cottle, did you have anything you wish to add?
I just thought I'd add to the framing of your very good question. I mean, the problem we're trying to solve was defined by council. So council asked us to look at this, right? So I just think that's also important to understand when we're asking what the problem definition is. It's response to direction from council. And and to Ms. McLeod, I think ended really well that there are a lot of options. But what we've also been hearing from council when asking us to look at this is around certainty, because there's a lot of confusion in the community about what is and is not illegal, and this provides the most certainty. So there are extra steps and a cost to providing that certainty. Otherwise, there are other processes that are less equitable and less certain.
That is the best answer. Thank you so much. That helped my mind expand into the space much better. Thank you.
Thank you. Any other questions from council? Seeing none, thank you very much.
Thank you.
I'll then move the council give first reading to Business Registry Bylaw Amendment 2025-24, Visitor Accommodation. And speaking in support of the motion, I certainly want to hear what members of the public have to say about this. And so I would like to pass this so that we can set down a public hearing. Would anybody else like to speak to the motion? Seeing none, I'll call the question. All those in favor? Carried unanimously. And so I'll move the council schedule a public hearing for Business Registry Bylaw Amendment 2025-24, Visitor Accommodation on September 2nd, 2025. Would anybody like to speak to that motion? Seeing none, I'll call the question. All those in favor? Carried unanimously. Thank you. All right, we will now move on to new business. H1 is the Moustache Lands Development Next Steps. Ms. Smithers.
Well, hello again, council.
Get set up then and welcome, and whenever you're ready, the podium is yours.
All right. Hello again, good afternoon, and I'm here now to talk to you about the Moustache Lands development and our next steps for that project. As you would recall, just last month at Committee of the Whole, we had a pretty in-depth presentation and report accompanying that from the town's consultants, G3 and the cast of thousands in that consortium, as well as YWCA Banff. So I'm not going to get into that in detail today. I'm just going to focus on our next steps and the recommendations and decisions that we're looking to council for. And then once I'm through the presentation, if there are questions, I may ask members of the project team to come up and speak to those questions. So as background, the project team provided an update to council on June 17th at the Committee of the Whole, and that was focused on the feasibility study and the results of the feasibility study, which in summary include 270 affordable units in 4 6-story buildings, with the potential for an additional 60 units in a 5th building. I know there are some questions around affordability and what that looks like, so I've included this chart from the report that looks at that mid-market rental rate, and then shows what we are looking at for the Moustache lands relative to that mid-market rate. So, for example, the mid-market rental rate for a studio would be $1,363 a month. We're aiming for 215 units to be at $853 a month, and the remaining 55 to be at 79% of that mid-market rent, or $1,060. I know also there are some questions about what that could mean or look like against CCH and their perpetually affordable housing, the non-market affordable housing rates. So for example, for a studio apartment with their existing stock, so this would not include 100 Palliser, CCH would have an average rental rate for a studio of about $1,050 a month, 1 bedroom about $1,380 a month, a 2-bedroom $1,840, and a 3-bedroom $2,150 a month. So just for some context there. The project would, in addition to those 270 units and the potential for an additional 60, the project also includes 2,500 square meters of community hub and retail space. So for next steps, administration is recommending that the YWCA Banff be the developer and operator for the Moustache Lands project going forward. As you heard at our last meeting, there is a strong alignment between YWCA Banff and the town of Canmore for the vision and goals for that site. YWCA Banff is an experienced housing provider in the Bow Valley, and they also have demonstrated fundraising capacity to make the dreams that we have at the town a reality. And I'm getting choked up and I'm blaming Sally because we talked about this just before I came up. Next steps for the land agreement, we're recommending that the town enter into a 99-year land agreement with the YWCA Banff. A key piece of this land agreement is that it would support the town in maintaining our eligibility requirements. We also heard quite a bit around the interest in the Moustache Lands development, providing housing for Canmore community members. Damn you, Dr. Cottle. This is a key part. If we maintain that long-term land agreement, it helps us maintain the eligibility requirements to make sure that we're providing housing for people in our community. The land agreement, a long-term land agreement, also supports the YWCA in their fundraising efforts, as it provides some assurances and certainty for the supporters that they will be working with. And of course, that land agreement, once drafted, would come back to council for approval. Next steps for YWCA Banff, if administration's recommendations go forward today, they will launch into design development, relying on the excellent work that's been done to date with the Crown Cube Consortium. They'll work with us on developing and executing that land agreement. They are chomping at the bit to get going on their fundraising and funding scenarios, and they'll also be working on the project phasing. Of course, it's a very large project, so they'll need to be able to work with us and as advisors to kind of break down that project phasing. Next steps for the town of Canmore. One is we would lead on drafting that land agreement that we would bring forward to council for approval. We would advise on the design development work, and that's just largely based on the experience we've had on getting the project to where it is today. Obviously, we would have the development authority role to be reviewing and approving the development permits and building permits. And also we would provide council with regular status updates. Just given the significance of this project in the community and what it means for us as a community, we want to keep council informed of our progress. So the recommendations that are in the report today, first of all, that council approve the YWCA Banff as the housing developer and operator responsible for the fundraising, design, and construction of the Moustache Lands Affordable Housing Project. That council direct administration to draft a 99-year land agreement with the YWCA for the Moustache Lands Site 7, and that administration return to council with the agreement for approval. That the terms of the land agreement include eligibility criteria and prioritization of affordable housing units related to income and/or asset limits, age, and a connection to Canmore through employment and/or residency. And lastly, that council direct administration to work with the YWCA to report back to council by no later than the end of 2025 on the conditions of the land agreement and the project status. And that is all I have for you today, and I'm happy to answer any questions you may have.
Thank you very much, Ms. Smithers, for that presentation. And of course, it builds upon the Committee of the Whole information that we received. Looking to council to see if there are any questions. Councillor Graham.
Thank you, Your Worship. Just curious about the timing of that land agreement coming back for the end of 2025. That's about 5 months from now. And then we're about, was it April we need to be?
Yeah, so we put in no later than the end of 2025. This was a good conversation we had with the project team, just because I don't know when it's going to be back here. If we all could pick a date and hit it, it would probably be tomorrow.
Right.
So we want it to be as soon as possible, but we don't know when it is. So we put in no later than the end of 2025, expecting we'll be back before then, but we don't have enough certainty to pick a council date and say that's it.
Thank you, Ms. Smithers.
Great, thank you, Councillor. Any other questions? Okay, seeing none, thank you very much. Really appreciate the report and all of the work that's gone into this to date. Council, I'm going to combine those middle two recommendations as is set out in the cover agenda. We have those two combined because the 99-year land agreement and the terms of it are intrinsically connected. I don't want to deal with them separately. Does anybody object to that? No. Okay, so then I will start first with the council approved the YWCA Banff as the housing developer and operator responsible, and it should be for fundraising, design, and construction of the Moustache Lands Affordable Housing Project. In speaking in support of this motion, I just want to say a word about my impressions and perspective on the Banff YWCA. It's a real jewel, and it's an asset to the entire Bow Valley. And I mean it with all due respect, and I'm not wanting to say anything negative about the name YWCA Banff, but I actually always think of it as YWCA Bow Valley. And the reason is because the service of your current offerings benefit the entire Bow Valley, at least some of them. You've done incredible work around domestic violence. You are a Valley leader with regards to social enterprise, and you certainly have a proven track record with regards to housing and fundraising. And honestly, I think that you are uniquely positioned to step up into this capacity. We have Canmore Community Housing, and they do great work, but in order to get both the Canmore Community Housing project going and this going concurrently, we need to make sure that we are not stretching any one organization. And I believe that YWCA Banff is an excellent partner for this project, and one that I wholeheartedly endorse. Opening it up now to the rest of council, if anyone would like to speak to this motion. Councillor Ma.
Thank you, Worship. I just want to echo your sentiments there about the YWCA. I think this is a really interesting opportunity, and I wish you guys tailwinds, quick success in your early fundraising projects, get the inertia going. So thank you so much for being so motivated to be a part of this, and we're really glad to have you here. Thank you.
Thank you, Councillor. Councillor Faubert.
Thank you, Your Worship. And while it seems like it took a lot of work to get here, this is just the beginning. And I can think back to some of the stories I wrote with Stephen about higher ground as an idea. And now we're here, and I get to sit here and raise my hand in support of this motion to build housing for our community that we need. And I don't know if people realize it, but there's a specific type of housing we have not been building in this community for the past 30 years, and this will provide it. This is what's missing for the people who are most at risk and most vulnerable in our community, the people who need us as leaders, and people in positions of power and authority to make decisions, to move forward with projects like this and partners like this. So thank you, everyone.
Thank you, Councillor. Councillor McCallum.
Thank you, Your Worship. I am happy to lend my support behind the first motion and all of them, actually, but I just really pleased that this council has been able to move forward so quickly on those lands. Aren't we grateful the Olympics didn't come? Can you imagine trying to build for that in the middle of a pandemic? That end, we wouldn't have this purpose-built vision on the other side of the highway that we have right now, and it's slowly coming together. Yeah, I'm happy to support this. I can't wait to see what the designs look like. I can't wait to see the folks move into it. I feel like I've had the opportunity to sort of repeat this mantra over the last 15 years, and this is one more I get to repeat. So housing is core and key to success. It is what allows a family or an individual to plan for the next year in their life, whether that's having children, partnering up, going back to school, or even changing jobs. And so I see this as sort of as core to people's health, and in particular people that are coming or sort of on the edge of poverty. That housing is, people that are houseless have a 50% less of a lifespan than those with secure housing, and it really speaks to our values as a community that we are willing to put so much energy and hope and hard work in behind this project. So I thank everybody here, and I look forward to seeing it come out of the ground.
Councillor Graham.
Thank you, Your Worship. I remember thinking back when the Y was first proposed and being like, why the Y? And not understanding what the organization really was. Since that time, I've come to know many of you, talked to many of you about your vision and your skills and what you've brought to the table. And it is with that we put our hands in the air with confidence in what you're about to do. To Lee and your team, watching you guys kind of stick handle this one through and understand the things that we needed to have confidence in this. Thank you for that. Appreciate it. Yeah, looking back on this term, this will be one of the highlights of it for me. So thank you.
Thank you, Councillor. Councillor Hillstad.
Thank you. I'm also happy to support all of the motions that are this one and the other ones that will be coming right after. I think everything's already been said, so yeah, just get on it and look really forward to seeing it happen.
Write a check then.
Yeah.
Thank you, Councillor. Councillor Merritt.
I too am happy to support this. I know that since I came on council, I've had a little whisper in my ear from that end of the table here and over. He was on this side before, so I'm happy also. Councillor McCallum has always had a vision for over there also, and you folks there are help us make it come true. So thank you.
Thank you. And just before calling the vote, I'd also like to recognize a person who's not here but on leave that has been instrumental in some of the visioning over the last long while that hopefully will become part of the fruition of this project, and that's Ms. Ebony Rempel. And I know that she has very duly qualified co-CEOs in place, but I just want to make sure that she's recognized as well. Okay, then I will call the vote on the motion. All those in favor? Carried unanimously. I'll now move the next two together. The council direct administration to draft a 99-year land agreement with the YWCA for the Moustache Land Site 7, and that administration return to council with the agreement for approval, and that the terms of the land agreement include eligibility criteria and prioritization of affordable housing units related to income and or asset limits, age, and a connection to Canmore through employment and or residency. That was one of the major, provisos that council has previously raised, that it's very important that this house residents of Canmore that meet certain eligibility requirements. I believe that a nice balance is sought when we are leasing the land for long term, so there's certainty, but it still also allows that connection with the town. So I will support this motion. Would anybody else like to speak to it? Seeing none, I'll call the question. All those in favor? Carried unanimously. And now I'll move the council direct administration to work with the YWCA to report back to council by no later than the end of 2025 on the conditions of the land agreement and project status. Would anybody like to speak to that motion? Seeing none, I'll call the question. All those in favor? Carried unanimously. And so you folks in front of us, you have your marching orders. And so we'll look forward to hearing back from you, and thank you for everyone for the work to date, and I do want to give you a little round of applause. Okay, we're going to take just a 5-minute break till 2:26, and then we will return with item H3. So I'll look to Mr. Stiver to advise when we're streaming again. Okay, we're back from the break, and we're moving on to item H3, 2025 Community Fireguard Capital Projects, Canmore Nordic Center East and West Phase 2 construction. Ms. Miller, welcome back to the microphone. Please proceed whenever you're ready.
Thank you. I also have Ms. Packus here in case there's any questions about Indigenous consultation or interest holder engagement. So before I get into the capital projects, I thought I'd just give a quick overview about what we have completed and where we're going with the next phases. So we've completed harvesting in the Stoneworks Creek, Harvey Heights, and East Park Gates blocks, and are continuing to plan and get ready for the construction in the Canmore Nordic Center blocks. We're also continuing planning for the south boundary and that's the area from the west of the Peaks of Grassy to Dead Man's Flats, and are finalizing details for a future application. As a part of Phase 1, 188 hectares were cleared and 31 hectares have been thinned. All logs have been hauled from the worksite, and remaining hand crew work, so the thinning, pruning, cleaning, in residual patches is scheduled to begin anytime after August 18th. The Stoneworks West portion, that's the area closest to the Silvertip community, has been completed. This is just a really great picture of what the Fireguard looked like a couple of weeks ago, as it's still quite brown, but you can see all the debris piles, those are all the little dots throughout. You can see the retained fur and some of those more ecologically sensitive areas as well. In the Stoneworks West area, we also in the Stoneworks East area, we've already reclaimed the roads, and the roads that remain in the Stoneworks West area are there to complete the remaining work. So here's an example of the road when it was in operation, and then again when it had been reclaimed. So you can see the work that's been done there to return the land. And these are some current pictures of how the construction areas have started to green up. So the landscape has changed, but nature is taking over, making it blend in again. So it's becoming quite green up there. I've even noticed over the past couple of weeks, driving up to the Nordic Center, looking across the valley, you can sure tell the difference as the soil's taken in the nutrients, the rain has really helped, and things are looking pretty green across the valley now. Now going into the projects that we're here to talk about today, FRIA has approved our funding for our next phases of construction in the Canmore Nordic Center East and West areas. The East Block of the Nordic Center will be built to safeguard key infrastructure and residential areas. This work is primarily being done in the Kananaskis Improvement District and the Canmore Nordic Center Provincial Park. The West Block will provide a strategic containment line against wildfires approaching from the west and complements the maintenance work done last fall by Alberta Forestry on the park side of that municipal border. This work is being done within the town of Canmore municipal boundary, but again on Alberta Parks land. Engagement with interest holders is ongoing, as is the consultation with Indigenous communities through the Aboriginal Consultation Office, and there's actually a site visit occurring tomorrow. This phase of the project spans a total of 124.4 hectares, so another significant impact on the landscape. Funding for this project has been, we've been provided by FRIA in 2 grants. One for the Canmore Nordic Center East, totaling $992,000, and the other for Canmore Nordic Center West at $882,620, for a total of $1,874,620. Whew, numbers are hard today. So we're also expecting timber revenue of approximately $82,100 for the Canmore Nordic Center East. We're expecting not to get any revenue for Canmore Nordic Center West just because of the steep grade and the type of harvesting that we need to do there. So we've also learned a lot through the first construction phase of our project, and we've been working with FRIA on our grant applications and numbers as we bring them forward. So we've had quite a number of learnings. As you see today, we're doing another capital budget amendment request. But those learnings, this has been kind of a new project for us with the town, building a fire guard and doing this construction. So we've learned a lot about the actual cost for debris disposal, for hand thinning, cleanup, and we've been better able to inform our applications to FRIA as we go along, but we've been working really closely with them throughout just so that they understand what the work is, and we want to make sure that we're right-sizing and not asking for too much up front, and to make sure that it is for the scope of work that we're needing it for. So the recommendations for, there's 2 recommendations for the Canmore Nordic Centre capital projects. First, that council approve a new 2025 capital project for the Canmore Nordic Centre East Phase 2 Fireguard construction project, funded by the Forest Resource Improvement Association of Alberta grant in the amount of $992,000 plus the timber revenue of $82,100 for a total capital budget of $1,074,100. And the second, that we approve a new capital project for the Canmore Nordic Centre West Phase 2 Fireguard construction project, again funded by FRIA in the amount of $882,620.
Thank you very much for that presentation and this excellent news as this keeps on going forward. Looking to council to see if there are any questions. Councillor Hillstead.
Thank you. As you said, there have been learnings, and the next item will see some of those learnings. With these 2 numbers here, is there kind of a ballpark on how much those learnings contributed to these numbers? Like, if we hadn't had those learnings, would these just be way, way lower? Or how has that whole thing progressed, just out of curiosity?
Yeah, I think that they probably would have been similar because we were also accounting for using air curtain burners, right? So that kind of increased some of the costs that we were seeing in the first place. So at a certain point, we weren't sure if that's where we were going to go. Now that we're going towards the mulching and open pile burning as the preferred method of debris disposal, we're able to kind of nail down those costs a little bit more. The hand thin prune cleaning, so that's all being done by hand. That's why we're calling it hand thin prune cleaning. That takes quite a bit of work and labor as well. So just understanding what that impact is and how important it is to make sure that it's a fulsome fire guard and we're not leaving any debris or hazard out there. So those ecologically sensitive areas or the areas around where we have some retention, it's still important to go and clean up those areas and do the full fuel management. So there's been quite a few learnings through that have helped inform it, some in the actual costs of things, some in deciding what is the preferred method. So, yes.
Thanks.
Great, thank you. Councillor Graham.
Thank you, Your Worship. So I grew up in a logging town, and when logging companies came to town and clear-cut places, they generally made money doing that. And I've had a few people come to me and say, like, why is this costing us anything at all? Can you talk to the difference between maybe a commercial clear-cut and fire smarting, and what the difference between those 2 things is?
Yeah, and that's a great question because a lot of the harvesting that is done is very intentional in clearing the area, but then it's all that extra stuff that I was just talking about with the hand thin prune cleaning, going in and actually doing that little work to remove the hazard. So it's not just about removing viable timber, we're actually going in and removing the hazard afterwards. So there's a lot of wood in there. But with that comes the additional, like there's still mountain pine that we're dealing with. Not all the wood is merchantable timber. We're doing it in a way that's very deliberate around trees, right? So it takes a little bit of extra planning to go around the aspen, around the poplar firs, to have them remaining and standing. That extra care around those ecologically sensitive sites. This isn't normal logging land. Some of it is pretty steep grade and some tougher conditions. So we're not making money in some of those cases where it is such a steep grade and you need specialized equipment to come in.
Thank you, Ms. Miller. I appreciate that answer.
Any other questions? Councillor Ma.
Thank you, Your Worship. I've got 2 questions. First, Ms. Miller, thank you so much for always bringing the good news of successfully gaining these grants. When can we expect phase 2 for this Nordic Centre to kick in?
If the capital projects are approved today, then we can get going as early as August 18th to start the work in the Nordic.
Oh, this year. Wow, okay. And my second question is for Ms. Packus while she's here. Ms. Packus, could you give us a little bit of insight onto the Indigenous consultation piece and what's being brought up?
Ms. Packus, welcome.
Thank you. Yeah, so we did, so the Aboriginal Consultation Office, I don't actually know where to look. The Aboriginal Consultation Office determines the level of consultation that we need to complete as part of this project. So in order for the permits for this project to go through, we have to meet the consultation requirements. So for phase 1 and for upcoming phase 2, it was determined that we would operate at a level 2 consultation. So we've been working with a consultant from McElhaney who specializes in this work to help us mediate some of this consultation. So we begin by sending consultation packages out to all Treaty 7 nations. So this again is directed by the consultation office who receives our consultation packages. And then we follow really strict guidelines for timing. And so the nations are also very well aware of what the timing process looks like. So they have a certain number of days to respond to our initial packages. And then they may request meetings with us, they may request site visits, and then we are under strict timelines to get back to them and to provide the information that they need. So for phase 1, the Siksika and Blood Tribe both expressed interest in doing site visits, so we did that. And then they are coming out again on Thursday this week to do a site visit for phase 2. And so as part of the consultation, nations are entitled to look through the site, look through our maps to ask any questions that they have, and then they are the ones who determine whether or not the consultation has been adequate on their end, and then we submit for adequacy through the consultation office to receive our permissions to move ahead with the permits.
Okay, excellent. And any interesting feedback at all or sentiments that would be helpful for council to know? Or is that all still being gathered?
No, incredible support for the project.
Great.
All of the nations that we've spoken to recognize the importance of doing this work. So there hasn't been any conversation about not doing it. What we found in the last site visit was just the nations were looking for vegetation of cultural significance. It's unlikely to find pieces of archaeological significance given the terrain that we're on in these site areas, but that's always a consideration as well. So it's largely vegetation.
Thank you so much.
You're welcome.
Great, thank you. Any other questions? I see none. I'll then move the council approve a new 2025 capital project for the Canmore Nordic Centre East Phase 2 Fireguard construction project, funded by the Forest Resource Improvement Association of Alberta grant in the amount of $992,000, plus timber revenue of $82,100 for a total capital budget of $1,074,100. Of course, I'll be supporting this very important work. And I appreciate the work of administration and keeping this moving forward very quickly, given its high priority for our community, and express appreciation to the province for their attentiveness and collaboration and support, particularly financial support, in providing the funding for these projects. Would anybody else like to speak to the motion? Seeing none, I'll call the question. All those in favor? Carried unanimously. And I'll move the council approve a new 2025 capital project for the Canmore Nordic Centre West Phase 2 Fireguard construction project, funded by the Forest Resource Improvement Association of Alberta grant in the amount of $882,620. Would anybody like to speak to that motion? Seeing none, I'll call the question. All those in favor? Carried unanimously. Thank you. All right, so now we will move on to item H4. This is capital budget amendment, additional debris disposal funding for CAP 7386. Ms. Miller, back to you.
Perfect. So speaking of those learnings, So administration submitted another application for additional funds through FRIA due to the increased cost of debris disposal and to allow for the delivery of the original project scope to include the thin prune cleaning of areas within the Stoneworks West block. There has been a lot of engagement with FRIA regarding this additional funding, further exploration of alternatives to mulching and open burning of the debris piles, but this was the preferred option, both of the project team and through FRIA. So FRIA accepted the application and has provided the town with an additional $527,549 to complete this work. In addition, administration is looking to amend the capital budget to account for the additional $173,542 of timber revenue received to put this back into the Fireguard project for use. All the timber revenue for this phase of the project has now been accounted for, and the total revenue received for this phase of the project was $531,042. So just to give you a bit of an idea of how big some of these debris piles are, this picture you can kind of see just scale-wise with the equipment and how some of the debris piles do tower over even over the logs. This picture is a little bit older, so all of that timber has been removed now. So that's the debris that we're looking at in that area of cleaning up. And then again, just some of the another example of the mulching that has occurred in these areas. And you can see that we chose mulching in the areas that had a lot of the fir retention as well, just to minimize some of the risks to those trees. We don't necessarily want to burn open piles next to the trees that we're trying to retain and keep. And again, once the cleanup is completed, the road will be reclaimed as it's been reclaimed on the Stoneworks west side as it has been on the Stoneworks east side. And this work is expected to start and continue into the winter of 2026. And then the recommendation, just to increase the capital budget for the additional debris disposal funding, fully funded by the Forest Resource Improvement Association of Alberta, and to account for the additional timber revenue.
Thank you for that presentation. So just to be clear then, there'll be more mulching and more burning?
Yes.
As a result. What steps are going to be taken to keep the burning to a minimum? Because that obviously has air quality impact.
Mm-hmm.
It could be anxiety, a source of anxiety for some people. So yeah, can you talk to that?
Yeah, so burning will only occur when the conditions are appropriate for it, for not only the fire danger levels, but also to make sure we have snow on the ground and to make sure that there's not the opportunity for an inversion. So sometimes when we kind of get socked in a little bit more with some of that smoke, it's because of the different wind cycles that we have in the area, and we just need to really carefully monitor the weather and pick the right time to burn.
Okay,
it might mean that on those days that the weather is good to go for burning, because we're experiencing the impacts of climate change, which increases our wildfire risk, but also shortens our burning season for when fire danger isn't.
Right.
We can't do open air burnings because of fire danger. So it is a shorter season, so there might be times that we have to burn more than what we normally would see at once to make sure that we can get through so that we don't leave the hazard there. The longer we leave the debris, like leaving it this year is good because it'll be drier wood, it'll burn faster. Instead of burning it last spring, it really makes a difference when it's not green wood and has the opportunity to dry out, gets hotter faster, burns really fast. But the challenge is that we only have a short amount of time to do it. So they are bigger piles, so we'll try to get through fast. But the bigger the pile, the hotter it gets as well. So it should burn fairly quickly.
Right. Okay, great. So I appreciate that it's during non-wildfire season, very safe conditions, and keeping it to as minimum as possible while getting the job done. Okay. Any other questions? Councillor Graham?
One for me. So we've learned that this costs more than we thought it was going to cost, and that was budgeted into the last proposal that we just got. So we're probably not looking at another additional one for the Nordic Center side. Correct? That's already budgeted.
Never say never. but we're doing the best we can with the terrain that's out there and what we're expecting expenses to be. It's hard because we can't go to RFP before we come here to get work going, so it's hard to kind of get some of those costs nailed down ahead of time, which is one of the challenges we had in the first, with this project, with this specific capital project, was just going to market and being able to figure out how much the air curtain burner costs was a pretty big learning, but we really wanted to see if we could do it, because getting through Stoneworks east with that and there being a super minimal impact was the preferable option forward. But then as the cost just kept increasing and it wasn't efficient, it was a change that we had to make. So we've taken those learnings, but you never know. Try.
Thank you.
Thank you. Any other questions? Seeing none, thank you very much. I move the council approve a budget increase to capital project CAP 7386 for additional debris disposal funding, fully funded by the Forest Resource Improvement Association of Alberta in the amount of $527,549, plus additional timber revenue of $173,542 for a total increase of $701,091. Would anyone like to speak to this motion? Seeing none, I call the question. All those in favor? Carried unanimously. Thank you. And we will now move to Cougar H5, Cougar Creek Lot Disposition. Ms. Smithers, welcome back to the podium. Whenever you're ready, it's yours.
Hello again, members of council. I'm here now to speak to you on the Cougar Creek. Woo! I'm here today, right now, to talk about the Cougar Creek lot disposition. So just as background, as you would know, after the because of the 2013 flood, there were 2 residences adjacent to Cougar Creek on Grotto Road that suffered significant damage, and those properties were in a high hazard area at the time, so the owners would not have been able to take the houses down and rebuild until the hazard was mitigated. So accordingly, the properties were purchased by the town in 2016. Now with the Cougar Creek flood mitigation completed, they're considered to be within the residual hazard area in the land use bylaw, so those lots are able to be redeveloped as single detached dwellings. So accordingly, administration is recommending the sale of the 2 lots, just because they are in a single detached area. There were some informal conversations with CCH. It's not really a product that they would deliver, and they've got a lot on their plate right now with other developments in the area. So our belief is that the best option for the town is to sell those 2 lots. Council's land transaction policy would govern that sale process, so it would be open to the public, it would be a competitive process, and our driver would be providing maximum value to the town. And our recommendation along with that is that the proceeds would be returned to the General Municipal Capital Reserve. And the reason for that is that General Municipal Capital Reserve is lower than we would like it to be. Its projected ending balance for 2025 is $7.1 million. The years on the bottom of this graph are kind of hard to read, but it's looking at the balance in 2024 out to what we're estimating it to be in 2030. The reason for that is over the 6-year capital plan, the General Municipal Capital Reserve is going to be funding about $5.65 million in projects, but we're only contributing about $4.3 million to it over that same time period. The purpose of the reserve is really to fund unexpected or new initiatives, and we're seeing that capacity for the General Municipal Capital Reserve to do that is eroding over time. So that's the reason for the recommendation. I wanted to draw one thing to your attention. The 2016 council motion to purchase the 2 lots references 476 Grotto Road, and in 2017 that address was changed to 474 Grotto Road. The address increments are in 4s as you go up the road, and this was in 2, so it was an opportunity to fit the cadence of the addressing on the road. Mr. Gravel was saying probably because at that time nobody was receiving mail or anything at that address, so it was a good time to change it. So the town did. So the council motion will reference 474 Grotto Road and not 476. I just wanted to save you guys the minor coronary that I had this morning when I looked at a motion to buy 476, but now we're trying to sell 474. So that is the reason why. So the recommendation in front of you today, there's 2 of them. One is that council direct administration to proceed with the sale of 474 and 478 Grotto Road in accordance with land transaction policy EX007, and that council direct the proceeds from the sale of the lots to the general municipal capital reserve. Thank you, and I'm happy to answer any questions.
Great, thank you, Ms. Smithers. Any questions? Councillor Hillstead.
Thank you. Okay, I'm going with 2 questions here. Was there any buyback options for the original owners when they sold? Like, just, I wasn't around for when this happened, so I'm just curious, like, was there,
Neither was I, but I didn't see anything in the council report from the time or the council direction related to that.
Okay. And then, and for the second motion, that was where the original money was taken out of, right? Was the general municipal capital reserve? So that's another reason to put it back in, is because to buy these houses originally we pulled from that reserve, and now we're basically putting it back.
Correct. It's a really good example of unexpected expenses that come up over time, right? So that was the right reserve to pull that money from, and now we're just saying that that's one of the reasons why it should go back into that reserve.
Perfect. Thank you.
Councillor McCallum.
Thank you, Your Worship. Thank you for your presentation, Ms. Whitney. I am curious, do we have a ballpark as to what we believe will be the net after sunk cost on the purchase afterwards? Is there like a assessment? I should know this, I'm on ARB, but I have no appeals in that area.
I can't recall the assessed value of the 2 lots off the top of my head. We haven't done an appraisal yet. That would be the first step before we advertise the sale of them, though.
Okay.
But I can check on the assessed value and get back to you. I have a feeling that Ms. Gibbons is doing it behind me right now.
I was curious if there had been any thought put into, of course, replacing the dollars in the gen cap, but if there had been any thoughts about splitting the funds and diverting half of the remainder. I don't want to call it profit because it didn't feel very profitable at the time, and it was on the backs of somebody's home, but into another reserve or something like that.
We did have some preliminary discussions around that, just replacing the amount that was taken out of the Gen Cap reserve. Where we landed in discussion with finance was really just given the state of that reserve now. And this was an item that we actually were very mindful of going through the budget deliberations at the end of last year. The reserve is depleted more than we're comfortable with in the long run, so that was where we thought the best course of action in our mind is to put all of the net proceeds into the Gen Cap reserve.
Perfect, thank you.
Okay, we're going to go with Councillor Mera, then Councillor Ma, and then Councillor Hillstead.
Thank you. Part of my question was answered, but can you just sort of tell me what the process is? Do we sell the lot? Who determines the value? Where does it go from there if passed?
So we would contract out the appraisal. We'd use a consultant. We don't have that service in-house. The land transaction policy says it would need to be publicly advertised, I believe, on the town's website and in the local newspaper for a minimum of 2 weeks. So that's really, in terms of the policy and the process that we'd follow, what we would do. I have had a couple of realtors approach me with interest in it, and they've said, you know, they would also share the word through their networks as well. So in internal discussions around it, we thought the first thing we would do is take a look at advertising on the town's website, putting it out there in the local paper, and judging on the uptake, we could choose to go the route of using a realtor to put it on the realtor website, but we don't know that we need to, and that's an expense that we don't know that we need to bear.
Thank you.
Councillor Ma?
Thank you, Your Worship, and thank you, Ms. Smitters, for your presentation. I think Councillor Mara's questions answered most of what I was trying to find out. In terms of providing maximum value, as we go through this process, is it the sort of thing where we just have in our minds a certain price and someone hits that, or are we willing to sort of sit a little bit and see what happens?
Well, as I said, we do an appraisal to have a good sense of on the market what the land is worth. Honestly, and we haven't worked through all the detail yet, but I would imagine it would really be a process of having the window of time open for people to bid on it, open for a certain period of time, and then going with the highest bidder if it meets our expectations against the appraised value.
Okay, great. Thank you.
Okay, Councillor Hillstead, you have another question?
Yes. The other question I have is, there's currently a bus stop in front of both properties. Is that bus stop going to stay, or how's that all going to work? Because like that bus stop, you know, it's quite nice, and but it also kind of looks like part of it. There's a bit of section that kind of goes onto the property. I'm not sure if that's right of way or if that's actual property. So I'm just curious, what's going on with that?
I can double check. Typically, they're wholly within the town right of way. I don't know that that would be any different on this site, but I can certainly check and follow up with council if that's not the case.
Thank you.
Great. Yeah, I mean, that goes to a similar question I was going to ask is, do we anticipate any cost with having to adjust the bus stop or anything like that? But I guess time will tell, and if money's going to the general municipal capital reserve, any cost would probably come from there.
Well, and the intent, I mean, again, I wasn't here either at the time that the town purchased the lots, but my understanding is that the intent always was to release them for sale once the flood mitigation structure was completed.
Absolutely.
So they've always been signed as residential lots, and the bus stop was built knowing that they would eventually be residences.
Yep. Councillor Graham?
Just a follow-up question. If we should happen to select a realtor, how does that, is that a competitive bid process as well? Yeah. I'm assuming yes.
Probably, we're not there yet, quite honestly.
Any other questions?
And we do have an answer to the assessed value.
Yeah. Thanks to our property viewer, it's also a little bit self-serve, but for those who didn't have the advantage of doing that work in the background like us, each is assessed at just over 800,000. So at a proxy, you know, if the appraisal was roughly what they're currently assessed at, we could expect roughly, say, 1.6 million in their general capital reserve with this recommendation.
Great, thank you. Thank you, Ms. Given. All right, I don't see any other questions, so I will move the council direct administration to proceed with the sale of 474 and 478 Grotto Road in accordance with Land Transaction Policy EX-007. I'm very happy to see the full circle on this. It was very sad when those homes were lost. I think it was excellent that the town was able to step in and purchase them. Of course, they were not being able to be developed until we had the mitigation, so now the Cougar Creek debris retention structure is in place, and now we're back to where those can become homes again. And so I'm very happy that we can have this before us and get some families in there, hopefully, to fill that spot. Anyone else wishing to speak? Councillor McCallum.
Yeah, I was going to say something similar. Having been at the time, been on council when we purchased these lots, I thought at the time it was the kind and moral thing to do, and I felt really bad for those families. And it's nice to see that we finally got the mitigation completed, and now we can return them back to the market. So, and you know, for that approach, we are going to garner a few dollars off that. So I think that's really good for the municipality as a whole too, since we did invest a lot of money in our flood mitigation. Thank you.
Thank you, Councillor. Anyone else wishing to speak to this motion? Seeing none, I'll call the question. All those in favor? Carried unanimously. Okay, it's only been 34 minutes since our last break, so let's just keep going if that's all right. Oh, there's another, sorry. Oh, yes. Thank you for that catch. I move that council direct the proceeds from the sale of the lots to the general capital reserve. Anyone wishing to speak to that motion? Seeing none, I call the question. All those in favor? Carried unanimously. Thank you. Now we'll move to item H6. 2025 Engineering Design and Construction Guidelines, revised landscape design guidelines and specifications. Mr. Weldon, welcome to council, and whenever you're set up, the microphone is yours.
Thank you. Just give me a second here and okay. Just let me, actually I'm going to X out of here. I've got to start from the beginning. Give me a second. Oh, I swapped it out again. Okay, that's looking much better. Sorry about that. Okay, good afternoon. Good afternoon. Thank you, Mayor Cowsert and Council. I'm here to present to you the revisions and the results of our Engineering and Design and Construction Guidelines Landscape Development Review. You may recall in February of this year that the Engineering, Design and Construction Guidelines was presented to Council. However, the landscape section was not included in that review and in that presentation. That is the responsibility of the town's Parks Department, and I'm here to present that to you here today. So I'm just going to start with just a very brief overview and a reminder of what the EDCG is and how they're applied. So the EDCG guides the development, and in this case for landscape, which is our parks, open spaces, and trails, landscape elements on public lands. This is for all public lands. So what this includes is playgrounds, sports fields, trails, benches, things like off-leash dog parks, and our playgrounds as well. How they're applied in two ways. They're applied by the town ourselves through our capital projects. So when we do our own capital projects and improvements of our parks and open spaces, and they're also used by industry, by our development community when they are developing new communities within the town, and there's new public lands, public parks and open spaces as part of those new developments. Reasons for the update, very similar to the EDCG review. We wanted to make sure that the parks and landscape development section was reviewed concurrently with the overarching EDCG review. The establishment of my role as parks planner is relatively new as well. So we wanted to make sure that the changes as a result of my new role were also included into the EDCG. And also there's been a bit more of a focus on landscape design items as part of our planning process. It's been 5 years since our last review, and we wanted to make sure that these also reflected our community priorities, including climate emergency action and wildfire mitigation. This is going to be also a bit of a recap, but the town uses the following approach to provide direction and guidance for the development of all public lands and infrastructure, including parks. We rely on our provincial acts and our provincial regulations. We also rely on the City of Calgary design guidelines and specifications as a default. And our EDCG highlights other changes that we have from that specific document. So items not otherwise addressed. In our review, we looked at a number of different documents to help guide our review. Statutory documents such as the Municipal Development Plan, our Land Use Bylaw, our Area Structure Plans, other municipal bylaws such as our Parks Bylaw and Community Standards Bylaw, and a number of other guiding documents that have been adopted by the town. Specifically, our Open Space and Trails Plan, and one that I wanted to highlight here too, because you've already seen it here today, is we are implementing wildfire mitigation measures in our EDCG. So we're relying on Fire Smart Canada as well. There were a number of different internal and external interest holders. BODA, our engineering department, and our public works operations folks. So specifically, the town's engineering department and public works operations and maintenance departments, they were identified as key interest holders. Engineering was developing and leading the overarching EDCG review and is also responsible for directing the development of new town infrastructure, including the utilities and streets and roads. Our town public works operations and maintenance departments also, that also includes parks, waste and recycling, and streets and roads. They're responsible for maintaining the land and the infrastructure that is developed once it is constructed. So it was important to understand the operational impacts from their point of view as well. And as you know, BODA represents the developers and builders operating in Canmore and are a significant stakeholder and the primary users of the EDCG document. We did engage BODA and we followed a number of different steps. We did have BODA clarify and identify the issues and items and concerns with the landscape section in particular. We did draft revisions based on that input that we received. We did review it and have a workshop with BODA and came to final resolutions and final revisions. And I just, yeah, it was a really great process. And I think, yeah, it ended up having a really good final document. I'll just briefly go through some of the notable changes. I've already mentioned my role was established as Parks Planner. Previously, the EDCG had identified the engineering department as being the authority or responsibility for all items within the EDCG. However, because parks and landscaping is a bit unique and separate, and falls under my role and responsibility, so we needed to update that. So that has been updated accordingly. We did establish a variance process to allow for more flexibility and some changes within the document, and this is in alignment with what the engineering department had already integrated into the EDCG as well. We did comprehensively revise the landscape design guidelines. Some notable changes are we divided the section into two parts. We did this so that it was a lot more clear and easier to navigate. The first part deals with development design guidelines. So when someone is designing a new park or a new open space, that is where they will go to get that direction. And then the second part deals with, okay, now that you've designed that park or that open space, this is how you have to construct it, or this is how you have to, like all of the actual specifications for constructing a playground and trail and whatnot. We did update the min and maximum landscape requirements for parks, streets and roads, and public utility lots. That includes the number of trees and shrubs. We did establish wildfire mitigation guidelines, as I mentioned before, based on Fire Smart principles. That is new to the EDCG. And we also established off-leash dog park guidelines, which is also new. We didn't have those before, but are also very important for the community. And we updated our plant species list. So we expanded the species list for all areas. We consolidated all the plant species tables into one location so that it is easy to access. We added FireSmart notes into those tables for clarity, and we expanded the boulevard and median tree species. And we also specified trees for private land. There is a connection with our land use bylaw, where our land use bylaw does refer to the EDCG for plant species that are appropriate for private land. So that is the one private land, private land piece that is included here, where that plant list is also included. And the recommendation to council today is that council approve the 2025 engineering design and construction guidelines revisions as presented. And that concludes my presentation. I'm happy to answer any questions.
Thank you very much, Mr. Weldon. And I do want to add that myself and council have received a letter from Alexandra Piper, the executive director for BODA, and they have indicated support for the changes and appreciation for the process. So I just want to make sure that that's on the record. So thank you for facilitating all of that. Looking to council to see if there are any questions. And I see Councillor Ma has a question.
Thank you, Worship, and thank you, Mr. Weldon, for your great presentation. I really didn't have a full understanding of how large a scope of this project was. And so when I saw the report, I was like, wow, there's definitely a ton of work there. A question I've been getting from some members of the public and also kind of twigged my curiosity is why even allow coniferous trees and shrubs at all, given that we're in a situation where we're working so hard, expending so many resources trying to thin our forest level and allow the type of trees that are problematic?
Through Mayor Crosert to Councillor Ma. That's a really great question. The simple answer is to still allow for the variety of tree species to be planted within the town. They do have an environmental benefit, particularly for wildlife such as birds. We took great care to ensure that the direction for both the plant species, the types of species that we're allowing, and the FireSmart principles in terms of where those species, whether coniferous or deciduous, are planted, are still in alignment with our FireSmart principles. You can be rest assured that the new park spaces will be implementing the FireSmart principles and ensuring that coniferous trees are planted away from structures to decrease the wildfire risk to homes and structures within the community. But still, we are still allowing for that variety of species for these other environmental benefits.
And they would also have benefits of providing some diversity of the landscape and shade and such things as that.
Yeah.
Okay, thank you for that, Councillor. Any other questions? I don't see any. So thank you very much for that presentation. I am now going to move the council approve the proposed 2025 engineering design and construction guideline revisions as presented. I appreciate that these come to council for review and approval, and I also very much appreciate all of the work that goes into it and the collaboration. And it's nice to look to town administration and look to industry and see nodding heads and recommendations aligned together, and so that makes it very easy to support. Anyone else wishing to speak to the motion? Seeing none, I'll call the question. All those in favor? Carried unanimously. I will now call a break and we'll return at 3:20.
Possibly BC.
I was hoping, oh, there's Dr. Cottle right now. So let me know when we're streaming. Okay, we're back. And we are now moving on to item H7, third-party grant for wildfire risk reduction. Ms. Van Gaal, welcome to council, and whenever you're ready, the microphone is yours.
Good afternoon, Mayor and Council. My name is Caitlin Van Gaal, Supervisor of Environment Sustainability, and I am here to ask that to request that Council accept funding from a third-party funding source to allocate it to 2 projects aimed at reducing wildfire risk. So I'll quickly just go over what the funding source is. I'll talk about the projects we're hoping to allocate the funding for, share the recommendations, and the next steps. Is that better? Perfect. So administration in January applied for funding from a third-party funder focused on climate resiliency. In June, we were notified that we had been awarded the funding. We are referring to the third-party funder as a third-party funder for the purpose of this presentation, as they want to remain anonymous until we sign the funding agreement following this meeting. So the town was awarded $200,000, and administration hopes to split that funding between two projects. The first being Capital Project 7452, Utility Facility Fire Smarting, and the second one being a new community incentive program for roof replacements in order to reduce wildfire risk to homeowners. The first project we hope to allocate funding to is, as I mentioned, Project 7452, Utility Facility Fire Smarting. This project was approved as part of the 2025-2026 capital budget with the goal of replacing roofing material and wood siding at 3 lift stations and 1 pump house. The budget was originally approved for $450,000, funded by the Water Utility Reserve at $200,000 and the Wastewater Utility Reserve at $250,000. We were asking that council update the funding sources for this project to include $100,000 in grant funding, offsetting $50,000 from each of those reserves. The second project we hope to use the grant funding for is a new project titled the Community Wildfire Risk Reduction Roof Replacement Incentive. This will have a total budget of $100,000 with the goal of rolling it out for public application in early 2026. Following a lottery, if there's a lot of interest, the incentive will be awarded in the spring of 2026, with successful applicants having until the summer of 2027 to complete their roof replacements. The detailed incentive design will happen this fall, where we will strike up an internal working group and conduct interviews with roofing companies to determine rough costs and finalize what is the acceptable roof replacement materials are. Right now, we're anticipating the Class A Fire Smart rating. We will also define the incentive requirements, such as the applicant needing to have a Fire Smart home assessment completed that indicates that their roof should be replaced. Applicants would then be eligible for up to 50% of the cost, up to a certain dollar value, to be determined post interviews with roofing companies. And then all work must be completed by August 2027 so that we can meet the final grant requirements of September 2027. So following acceptance by council today, we will sign the funding agreement and then initiate Capital Project 7452 this summer with completion targeted for spring of 2026. And we'll begin the design of the Wildfire Risk Reduction Roof Replacement Incentive for launch in early 2026, with the final deadline, as I mentioned, of September 2027. So with that, we ask that council approve a revised budget for the Utility Facility Fire Smart Capital Project 7452 from $200,000 funded from the Water Utility Reserve and $250,000 funded from the Wastewater Utility Reserve to $150,000 funded from the Water Utility Reserve and $200,000 funded from the Wastewater Utility Reserve and $100,000 funded from a third-party grant. We also ask that council approve a new 2025 capital project for the development and delivery of a community wildfire risk reduction roof replacement incentive program funded in full by a third-party grant for $100,000. Thank you.
Great, thank you very much, Van Gaal. Looking to see if there are any questions. And I'll go through questions and then I'll go to you before we go to a motion. All right. Councillor Faubert.
Thank you, Your Worship. Thank you, Ms. Van Gaal, for your presentation. I'm just curious why the roof incentive program is a capital project and not a change to the operating budget.
Great question. It was just a one-time project with because we're receiving funding from a grant source, so we'd be offering the program.
Ms. Smithers wanting to speak to this?
I was going to say the exact same thing, but I didn't have to because Ms. Van Gaal is so excellent.
So it's because it's one time only.
Yes.
So then, if we were to be like, we want to continue doing this, then would that show up in the operating budget?
I would believe
In the
we'd have to bring
future?
it forward as a operational budget in a future budget cycle, and council could then decide if they wanted to put that into the operational
Likely it
budget.
would be for a term by term, which is still kind of one-offs, right? As opposed to a permanent forever and ever and always.
I guess I'm just trying to it's a one-off incentive program that comes from a third-party grant. I understand how that's appropriate for a capital project. And I'm just wondering if in the future, the councils of the future wanted to make it a permanent project, would it still be a capital project? But that's not even a good question for right now. So, sorry.
Okay, Dr. Cottle, did you?
I mean, my sense is no. It's appropriate for a capital project, I believe, because of the grant timelines, because it spans over multiple years, and our operating budget doesn't allow that to happen. So because of the grant program and the deadline of 2027, putting it in capital allows us to do this. We have to develop the program and do the intake. Once Ms. Van Gaal and the team she pulls together does the work to create the program, we'll have a better sense of what the interest in the community is and if it's something to be extended. And if the council of the day, they may then want to pilot it, and then once if it were to become a regular standing thing and we already have all the criteria and we can launch it every year, then it may just become part of the operating budget. But because it's new and it's a pilot and because of the grant timelines, the capital, to me, makes sense.
Ms. Smithers, did you have anything you wanted to add?
Yeah, I would just add to that it is in capital in part as well because it helps smooth the operating budget, so we don't have big peaks in the operating that we've got to back out in a subsequent year. Because that much variability can be kind of hard on our own planning, and it can also be challenging to work through the mill rate implications. So it is very much like a pilot project, similar to e-bikes, right? The first pilot of e-bikes was bundled up in a capital project. Council made the decision to operationalize it, so we moved it into operating. So it'd be something similar here.
And then the grant fund, did it come to us with this as the program they wanted? We went to them and said, we want to establish a new service level of doing a roof replacement incentive. We want grant funding for that.
Yes, that's correct. We went to them based on some of the recommendations from the Climate Emergency Action Plan.
Emergency Action Plan.
Great, thank you. Councillor Graham, you have a question?
I thought Councillor Hill was up.
He's
waiting. He's in queue.
You have a
Okay.
question as well? We'll save you for last, though.
Okay. I wonder if there was any consideration for affordability services structure like we did the e-bike program. Was there any consideration for that?
Since we just received notice that we have been awarded the funding, we haven't fully built out the design of what that incentive could look like right now. But when the team meets and there's a desire from council to see it targeted towards affordable services members, there is room to still put input into what the design of the program looks like.
To be determined.
Yeah.
I'll speak for myself, saying I'd like to see it start there for sure.
Okay, well, we'll see what gets recommended to us. Councillor Hillstad, you have a question?
Yes. With the Fire Smart assessments, how do they determine if a roof might need to actually be replaced?
Hello. When a Fire Smart home assessment is done, one of the very first questions is around the roof. And it's a conversation with the homeowner as to when the last time, how old is their roof? So it relies a lot on the homeowner's own knowledge of their roof. We can do a quick glance at the materials. Some are quite obvious in that they're not Fire Smart approved. Others not as much. If there's obvious wear and tear, that would be another indication. And then it's indicated on the Fire Smart home assessment that roof replacement would help increase their resilience against a wildfire.
Okay. So it's not just material type, it could be just age of the roof and other factors.
Yeah, age, is the roof in good repair? Is there obvious shingles missing? There's a number of factors that can go into that.
Thank you.
Okay, and I don't see any other questions, so thank you very much. Now, before I make a motion, Councillor Hillstad, you wanted to speak to this matter.
Yeah, so again, I'm a roofer, so I've reached out to our our town solicitor, just to make sure, there's no pecuniary interest and I can vote on this. And we both agree that there is no pecuniary interest because it's too remote, with it being a grant and everything, and the fact that, my company would still have to quote on the jobs. There's no guarantee of anything. Some possible potential with the new conflict of interest thing. My parents own a roofing company, which I'm employed by, and basically, even though that is the case, that's not a potential conflict in this situation, and basically the funds will indirectly flow into the roofing industry, of which there are many roofers in our valley and just in the surrounding area. So basically I will be participating in the vote later on.
Thank you, Councillor Hillstad, and I appreciate your turning your mind to the issue and speaking to it, so thank you very much. Okay, I'm actually going to move the motions in reverse order from what's on the screen in order to match what was the order in the published agenda. So I'm going to move, first of all, the council approve a new 2025 capital project for the development and delivery of a community wildfire risk reduction roof replacement incentive program funded in full by a third-party grant for $100,000. I am thrilled that there's a grant being made available so that we can take a look at this program, and I very much support this program being designed and launched for next year. Would anybody else like to speak to this motion? Councillor McCallum.
Thank you. I'll be happy to support both of these motions. Actually, a large chunk of our agenda really is about fire protection, which has been sort of the song that we've been singing for the last, I want to say 6 months. It seems like almost every, if not every other agenda has something to do with fire smarting, fire protection, fire granting. It's great. So firstly, thank you to whoever anonymously provided us with these dollars to do this work. And secondly, I think that it really shows the community and our neighboring municipalities, because they too are at risk based on our risk, that we are all rowing in the same direction. And so I'm grateful for administration for bringing this forward, and I look forward to seeing what the program will look like later. Thanks.
Thank you, Councillor. Anyone else wishing to speak to this motion? Seeing none, I'll call the question. All those in favor? Carried unanimously. I'll now move that council approve a revised budget for utility facility Fire Smart Cap 7452 from $200,000 funded from the Water Utility Reserve and $250,000 funded from the Wastewater Utility Reserve to $150,000 funded from the Water Utility Reserve, $200,000 funded from the Wastewater Utility Reserve, and $100,000 funded from a third-party grant. I love that this grant allows our reserves to go a little bit further, and so I will be supporting this motion with gratitude. Anyone else wishing to speak to this motion? Seeing none, I'll call the question. All those in favor? Carried unanimously. Okay, so now we will move to item H8, Community Event and Film Policy, AE-003. And Ms. McClett, welcome back to the microphone. Whenever you're ready, and don't feel rushed, but whenever you're ready, the microphone is yours.
Okay. Well, Mayor Crosser, members of council, Eleanor McClett, and outside of economic development, I also have the privilege of overseeing the arts and culture team. And Supervisor Jeannie McPherson was hoping to be here, but because of shifting of council timelines, she had a dentist appointment, and that takes precedence over presentations to council. Sorry. So I'm here today. I'm here today with the recommendation for council to approve the community event and film policy AE003 as presented. And just as a bit of a history in this space, council adopted the present policy, community event policy in 2008, establishing a cost recovery structure based on event and film production categories from not-for-profit to for-profit. Following learnings from some major film productions and ongoing community event permitting, this policy is recommended to be repealed and replaced with the community event and film policy AE003. The updated policy has been revised to enhance clarity on permitting processes and reflect best practices, administrative improvements, and the evolving community priorities. And so to that point, some key changes that have been outlined in the policy is clarification on community benefit. It used to just say mountain culture, but we are more, what is mountain culture is unclear, and it's hard to put clear parameters and metrics around when an event might not meet the community benefit to community. So we've updated that to reflect our values as a community in sustainability, in bringing people together, diversity, equity, and inclusion as outlined on the screen below, and I will save you from reading it all, but it is in the council report as well. So we've learned a thing or thing over the past 4 years, increased demand for both community and film permits, highlighted opportunity to improve our policy as presented to you. The proposed policy replacement is based on those learnings outside and clarity of renaming it as well to include film there. Some other key changes are in aligning with council-approved policies and strategies currently in place, one that was discussed just by the presenter ahead of me. Updating the appeal process as policies do not have the same requirements as bylaws on the Municipal Government Act. So a bylaw is appealed to council, whereas a policy does not have that. So appealing it to administration seems a better fit in that state, as well as scaling permitting requirements. If it's a simple flag raising, we don't need a waste management plan or a wildlife impact plan to be submitted. It can be a simplified permitting policy or process. And it also highlights, with the sheer number of event permits that we get in a year, that we can utilize our volunteers and staff time more effectively by dealing with larger community events that have a larger impact to community and need a bit more time to utilize those. So that's what we're proposing in this process. Something as simple as alphabetizing definitions so that they're easily findable, and changing stakeholders to interest holders as we have done in all of our policies. In film permitting, we've updated definitions, straightforward guidelines, and of course, how we calculate fees and remove some of the vague language in that space to better support the film industry and get clear in our when we provide them quotes of what it might cost based on the locations and the services that they are requesting from us. Now, no good policy update happens without engagement with stakeholder or interest holders, internal departments, and externals. So some of the things that were brought up were noise impact, so address it, but this is addressed through our community standards bylaw, event support, which we do through policies like the community grant, the major event grant, and through the support of the arts and culture team in and of itself. And then there was some comments about should we be separating the film and event policy. Now that option is definitely there. Currently we felt there wasn't enough distinction between the policies to warrant two separate policies and just keeping it there. That doesn't rule out the opportunity for them to, for the department to come back in the future with a separate policy, but that at this present time, it wasn't deemed to have enough distinction in order to warrant that separation. So that's what we heard in engagement. Overall, there was great support from our event producers for what is being proposed in the updates, but it was very red. And so the clerk's office said it's better to repeal and replace than try and update that. And now open to questions. Was that short enough, Councillor Graham?
Thank you. Thank you, Ms. McLeod. Looking to council to see if there are any questions. I don't see any. I think you've answered them all. So I will move that council approve the community event and film policy AE-003 as presented. In supporting this motion, I'd like to acknowledge the work done on this policy, and it's a continual process of learning with all policies, and especially as the town has been busier with various film applications and learning from past projects, it helps us refine our policies along the way. So thank you for that work. Looking to see if there's anyone else that wishes to speak to the motion. Seeing none, I'll call the question. All those in favor? Carried unanimously. We'll now move to item H9, Environmental Impact Statement, EIS, Policy PD-003 Amendment. And we're back to Ms. Van Gaal. Once again, welcome to the podium. Whenever you're ready, the
Perfect. Good afternoon again. Caitlin Van Gaal, Supervisor of Environment and Sustainability. And I'm here with Nathan Gravel, Senior Development Planner. I worked very closely with Harry Schneider on the development and the update of this EIS policy, and he unfortunately couldn't be here today, so Nathan is filling his shoes. So I'm here today to request that Council amend the Environmental Impact Statement Policy PD-003. The EIS policy was intended to provide direction for administration and the third-party reviewers on how to define the scope and undertake reviews of environmental impact statements that are submitted to the town. The review was initiated as part of a larger review of all council policies during their term. And the goal of this review was primarily housekeeping and to create clarity and efficiency within the policy. The proposed changes are intended to bring the policy in line with current practices exercised by administration and in other jurisdictions. And the original policy was adopted in 2018. So I'll first go over the key policy amendments that you will have noticed from the council report and in the redlined version. I'll talk about some of the potential impacts of those amendments, the engagement that took place in the development of those amendments, and then the recommendation and opening it to questions. So as stated, this review is part of Council's request to update and review all of Council's policies. The intent of this review is to provide clarity and consistency and to find efficiencies within the policy. As a result, most of the edits in the EIS policy are related to grammatical updates or sentence structure changes, with some edits being to update and provide clarity on the roles of the Planning and Development Department and to define the Development Authority and what a proposal is. Other edits are to better reflect the process that is currently taking place, such as the terms of reference development. This change moves the responsibility of the TOR development to the applicant. All TORs will then be reviewed and commented on by the third-party reviewer to ensure they align with this EIS policy. The policy also now provides clarity on who is responsible for the third-party review costs, which is the town. Some of the edits that are a bit broader than the initial scope of the review, but are designed to ensure that the due diligence on behalf of the town in completing environmental reviews and to create consistency with other municipalities in Alberta. The first being that the EIS policy now states that all EISs submitted to the town must be signed and stamped by a qualified environmental professional. This provides assurance to the town that the work completed is compliant with professional designations and scientific best practices. And we see similar practices in other environmental fields, such as the environmental site assessment field, engineering field, so this is not an uncommon practice. We also made changes to the content section of the EIS, which was updated to reflect recommendations from the third-party reviewer and a PhD biologist, with the goal of creating consistency across all sections and making it clear what is expected within an EIS, and ensuring that we are requesting the same contents in the evaluation of the existing site conditions as in the analysis of the impact section. These changes will help with the review process and align with recommended scientific approaches and ensure that changes in applicable provincial and federal legislation are captured. Changes were also made to the section which identified when subsequent reports are required. The goal of these changes is to ensure that the development authority is requesting the correct type of document under the right circumstances. There are already a couple clauses in the policy for this section indicating when an update is required. One of these existing clauses was stipulated at a higher level in the MDP, with the EIS policy providing additional guidance on when these updates would be required. Expanding on this, and in alignment with the practices seen in other jurisdictions, we added 2 new clauses. The first being, where an amount of time has passed since a prior EIS was submitted and accepted, such that the science supporting the assessment may have changed and or the impacts and or mitigations identified in the prior EIS may no longer be appropriate or valid, the Planning and Development Department may require the following: an update in writing be submitted by a qualified environmental professional to state that the contents of the original EIS are still relevant and meet the current standards of an update to the if an update to the EIS is required, and a new EIS or an addendum to the previous EIS be submitted to account for the changes in the assessment process, expired assessments, or identified impacts and mitigations. The intent of this change, while at the discretion of the Planning and Development Department, is to ensure the various assessments and field data that feed an EIS haven't expired and are still relevant, meaning the mitigation measures still apply and need to be updated. The intent is not that this applies to developments that are actively working on their site and doing ongoing environmental monitoring and reporting. It is designed for developments where the EIS is completed as part of the ASP, but no work on the land is initiated for another 20 years. Having this clause in the EIS policy allows the municipality to request that an EIS be reviewed to ensure the assessments are still relevant and the proposed mitigation measures still apply. Items such as wetland assessments expire, species at risk may change over time, which may impact some of the assumptions that went into the original EIS. The other addition was where there has been change to the landscape and or site conditions adjacent to or within the development footprint, or the Planning and Development Department may require that a new EIS be submitted which addresses the landscape changes, or an addendum to the previous EIS be submitted which incorporates the proposed changes, or an update in writing from a qualified environmental professional stating that the contents of the originally submitted and accepted EIS are still relevant and applicable. So this is meant to capture situations where there may have been broad substantial changes to the landscape, such as a wildfire event or a flood event, or if there's a change of provincial policy of how you can use certain crown land pieces of land. And so while some of these circumstances may alter the landscape to the part where the proposal needs to be updated, which would have triggered an EIS update anyways, as stated in the MDP in the original EIS, there are situations where these landscape changes may be substantial enough without changing the proposal, but may impact some of the assumptions that went into the mitigation measures. And we just want to make sure that those assumptions are being reviewed and confirmed to be still relevant. And finally, the last key change is to the exceptions section, which is to delegate the town's corporate strategic team as the body to allow for exceptions to the EIS policy as long as they conform with the MDP. This is to allow for operational changes to be addressed at the administration level instead of having to be presented to council. Hopefully this will help streamline the process and reduce the timeline requirements for any exceptions. So, as previously stated, most of these edits are to create clarity, consistency, and efficiency in the policy and should have a net positive impact for the applicants. Changes such as the TOR development falling to the applicant may have some increased costs when it comes to the actual TOR development. However, we have received feedback that when the TOR is completed by the town, it can be quite a lengthy process and result in cost implications and impact development timelines. Allowing the applicant to complete the TOR will hopefully reduce these development timeline impacts. This update also reflects what is currently occurring in some situations and will ultimately provide consistency across the entire process. And while the EIS has always defined when subsequent EISs are required, some of which were stated in the MDP and one clause that was not, the addition of the 2 new clauses may have some impact on applicants to provide updates due to the changes in the scientific assessment process, expired assessments, or changes in mitigation measures. However, as some of these assessments are part of provincial processes, for example, anything related to the Water Act, these updates may be required anyways. In these situations, the impacts of these clauses should be minimal, as we will only ask for a letter update of how these new wetland assessments or field data impacts the originally submitted EIS and mitigation measures. There was also a bit more flexibility built in when these clauses were inserted that would allow for the ability to submit a written letter when minor updates may be required, which should alleviate the cost needing to do a complete full EIS or amend the EIS. So while there may be some cost implications, the overall goal is to ensure environmental protection over the years. And finally, or I shouldn't say finally, the next thing I want to talk about, engagement. Administration engaged a recent grad through the Biosphere Institute of the Bow Valley to perform a gap analysis and best practice review of other municipalities in Alberta. Through this process, we interviewed the town of Banff, Parkland County, the city of Edmonton, and Banff National Park, and reviewed the environmental processes for the town of Cochran, the city of Airdrie, Strathcona County, and the city of Calgary. And the results of this review had been incorporated into the EIS amendments. Additionally, a draft of the amended EIS policy was circulated twice to Boda and Three Sisters Mountain Village, and once to the town's EIS third-party reviewer, who all provided feedback to administration. The draft amended EIS policy that's before you reflects the comments provided by Boda, TSMV, and the town's third-party reviewer during the engagement process. Additionally, from this engagement and the gap analysis, it was identified that a more fulsome review could be beneficial of the EIS policy, and a build-out of supporting documentation such as procedures, templates, a tiered framework, and staff resources may be required. Administration intends to build this out a bit more and to submit it as a budget request in a future budget cycle for council consideration. So although administration's recommendation is to approve the amended EIS as presented, in light of some recent feedback received from the development community this weekend, administration wanted to address the main concern heard in that feedback, provide council with an alternative motion, even though it was not included in the staff report. So council, if they choose, may wish to amend the amended EIS policy to remove section 10.c as seen on the screen, and this is the requirement for a subsequent EIS with the passage of time. This may alleviate some of the development community's concerns while we work towards a larger review. However, the reasons for putting the clause in initially still stand. And finally, administration asks that council approve the environmental impact statement policy PD 003 amended as presented. Thank you.
Thank you, Ms. Van Gaal. So removing, if an amendment is moved to remove 10C, using that alternative motion that you put out there, that would deal with, just looking here, looking at the red line, it's not 10C for that one.
Yeah, the numbering was altered. I think it's
I think it's
6C.
7C.
Yeah.
Yeah.
7C in the red line version.
But it's still, there would still be a requirement where a prior EIS does not address details or issues pertinent to land use and development impacts. An addendum to the original EIS will be required. So that's a project could be underway, and then an additional EIS would be required. Is that?
And that clause was in the original EIS policy.
Okay. So that's the current practice.
Yeah.
Okay. I'm looking at the red line, page 481 of 547. So even though it's redlined here,
The way it was worded originally, and if you looked up and read through
okay,
those.
so I see it up there. It's struck out from 3, and now it becomes
Yeah,
B.
it was worded a bit confusing, so we tried to pull them out so they were obviously certain.
So different wording, but the same concept was already existing in,
Yes.
in the current policy. Okay. Okay. There was also, in the concerns raised by the Boda sent a letter, and their major concerns were around the requiring the ambiguity around requiring an EIS, a new EIS over the passage of time. Also about projects that are currently underway, but if that's already that was existing, then that's answers that. But they also talked about the terms of reference, and maybe it should be some sort of a checklist approach rather than having their consultants create something that may then have to be revised, like I think a little bit more guidance. Did you have any thoughts around that?
No, yep, and I spoke with Boda about this, and I think that's part of what we would hope to capture in a larger, more detailed, fulsome review, is building out those supporting documents. So when we looked at a lot of other jurisdictions, they had booklets to explain how to go through their BIA process, their EIA process, with templates, checklists, forms, and a tiered framework depending on the scale of the development. So something minor might be a form, something larger would be a full EIA. And so I do agree that that is needed and that would be valuable, and I think that is what we hope to take away and then present as part of a fuller project review and allocate staff time and resources to it.
What's your thoughts with regards to the suggestion of not approving this at this time and just get on with the full review, you know, obviously subject to budget and whatnot?
Yeah, I think, I mean, that is an option. Ultimately, it depends on the timeline to do that more fulsome review and how long we would be operating under the previously accepted EIS policy. I think there's still, with the exception of those few points that seem to raise some issues with Boda and the development community, I think there's a lot of valuable updates that were done in the EIS to create consistency.
I agree, there's some very
and
good
clarity.
changes here.
So I would hate to lose all of those, but ultimately,
Okay.
up to council.
Great. I'm looking to the rest of council. Any questions? Councillor Faubert?
I just, from your, thank you, Ms. Van Gaal, and thank you, Your Worship. With 10B, right, subsequent studies, where the prior ES does not address details or issues pertinent to land use and development impacts, can you not consider the details or issues that could arise as things that would occur over the passage of time?
Potentially. So that clause was really designed, I think, and that was part of, in the original EIS, and so I was not here when that was developed, but I think that was meant to, if you have and maybe Mr. Gravel could step in if he has any corrections for me, but if you do an EIS as part of the area structure plan, and then as you move down through subdivision and development applications, if the EIS that was accepted at the area structure plan wasn't detailed enough to capture the implications of a wetland in one area where you want to do subdivision, then subsequent or amended reports may be required for that. I think that, I mean, passage of time could fall under that, but it doesn't necessarily capture every situation in which over time you did an ASP, and it could have been very detailed at the time, but then the science has changed, or you didn't act on it for 20 years. And so we just need to go back and revisit to make sure.
And that's where, like, the thing is, like, B addresses things that get identified. C, without a better term, is a fishing expedition. Let's see if there's something we can find. Something might have changed. Time has passed.
Mm-hmm.
Science might be different. We don't know. We should look.
Mm-hmm.
Whereas B says if we have an issue, an actual issue that we have identified, we can change the EIS. I think that that is better suited than C for the purposes of, so B existed before, but did you ever consider it in that way?
I think where this idea for this clause initially came from was in conversations with other municipalities, and when they were saying our assessments need to be updated every 5 years. And so we were looking at it, your wetland assessment, for example, is only valid for 3 years. And so we were looking at that lens, not necessarily that you didn't address all the details at the area structure plan, and you may have missed some when you get down to subdivision. I don't want to say missed some, but you didn't look at it at the same scale. It's more that you may have done the appropriate assessment, but it is just expired and needs to be updated. And if you're going to do your Water Act approvals and your wetland and your wares, then you need to update those assessments. And the thought would be that when those updates and assessments are happening under the provincial processes, if it impacts any of the mitigation measures that were recommended in your EIS policy, please update or submit a letter by a professional designation to indicate any changes that may have happened.
Yeah.
That was the intent behind it.
Yeah. No, I think that's really good, and that captures, I think, what the goal is that what we're doing is the most up-to-date science, so that we are responsive to our environment. But it's tough because the EISs lead to council decisions.
Mm-hmm.
And just because time goes by doesn't mean our council decisions based on that EIS go away either, right? So one of my, I guess, like, I don't have a question, and I'm going to switch into stopping talking and wait for debate. Thank you.
Okay.
Thank you, Councillor. Ms. Van Gaal, in that same section, so I guess it would be 10D, can you talk about, was this existing before where there's been a change to the landscape and or site conditions adjacent to or within the development footprint, the Planning and Development Department may require either, and then a new EIS, an addendum, or an update?
That is a new addition.
What was the thoughts behind that? What sort of changes in landscape and or site conditions were the driving force behind that?
I wish I could speak better to this specific point. This was brought forward from the planning perspective with Harry in conversation. But the idea and the thought, as I understand, is there could be large, and I spoke to, like a wildfire event or flooding event, something that could substantially change the landscape.
Right.
And so the mitigation measures originally stated may no longer be valid. I also think, and I don't know how this might necessarily apply, I haven't looked at it in Canmore, but with the all-season resorts. So some of our natural areas that are crown land could become all-season resorts. I don't fully understand, but that's just an example of a change in legislation. And so then if you put mitigation measures in place, assuming that this area beside you will remain naturalized, and it doesn't, then maybe this is more beneficial for you because the mitigation measures won't apply and aren't required.
Okay, all right. So it's something external that triggers, something has happened that triggers the need for another
It's not
EIS or an addendum or an update.
Yeah, it's not meant to be that the land beside your land was zoned as residential, commercial always, but nobody had developed it yet, and now they develop it, so now you have to redo your EIS. That's not the intent, because it was always zoned to be residential or developable. It's if something substantial changes to the landscape.
Great, thanks. Councillor Faubert.
A follow-up to that question. Would not a substantial change then lead to a new DP? And then a new TP just triggers the need for the EIS?
Yeah, so I think, and I thought I tried to speak to that, is I foresee that clause if there's a substantial landscape change, there may be a change in the proposal that's being presented as well. And so then they would have to follow the process and there'd be a new EIS because the proposal has changed.
Yeah.
But it doesn't always necessarily mean the proposal will change, I suppose. Like everything else could stay the same just because the land adjacent to you is no longer naturalized.
Yeah.
We were trying to capture situations so that we ensure that we were making decisions based on the best science to ensure the environmental protection. And if council chooses a different direction, that's fine, but that was the intent behind it.
Okay. Any other questions? No. Any other questions? Councillor Ma.
Thank you, Worship, and thank you, Ms. Van Gaal, for the presentation. Science changes by leaps and bounds. That's how it works a lot of times. And I was curious, could you speak a little bit towards this under the framework of, say, cumulative impact? So I wonder if that's sort of a little bit of what we're dancing around.
I guess maybe can you reframe the question?
Well, like I know, like reading through like the prior report, there was talk about how cumulative impacts is a potential thing, and how does that fit within this whole entire EIS rejigging of the policy?
The EIS policy has always stated the need to assess the cumulative impacts. We haven't added or removed that requirement, so that still stands. Is that your question?
I think that confirms that one piece. And then when it comes to terms of reference, this is probably more just like kind of closing the loop for some of the questions I've heard from the public. If the applicant's terms of reference are not satisfactory, say, for the town or our third-party reviewer, what is the process from there?
I think the process would be similar to what is already in place. The terms of reference is developed. It is assessed by the third-party reviewer. If there's comments, we go back. The terms of reference is updated to ensure that it meets the town's requirements and then approved and moved forward.
Thank you.
Thank you, Councillor. Looking to see if there are any other questions. Seeing none, thank you very much. Councillor Graham?
Request a 5-minute break.
All right, before I make the motion, we'll take a 5-minute break. Return at 4:15. Okay. I'll look for Mr. Stiver to advise. All right. Okay, we're back. I will now move, excuse me, if we could have order, please. I'll now move the council approve the environmental impact statement, the EIS policy PD-003, amended as presented. But I'm going to move the alternate motion that was put up there to delete section D-C. This is the section, in speaking to the motion, this is the section that deals with the passage of time. I don't believe that that actually complies with our municipal development plan. And I also think that it's rather ambiguous. So at the very least, I think that that needs to be removed. I think there's some excellent changes within the EIS, but I'd be seeking your support for having that section removed. And then, yeah, well, I'll open up to members of council to speak to my amending motion. Councillor Faubert.
Thank you, Your Worship, and thank you for putting the amending motion forward. I think that the passage of time is insufficient to trigger a new EIS. Other things have to happen, and in which case they do, they would become issues or details that are pertinent to an application and then would trigger an EIS anyways. So I support this because I think it creates uncertainty and potential challenge of it. I don't know what that is. Like, it's not clear to me how, like in terms of processes, that this creates an environment that contributes towards the people who are coming forward and making applications and investing in developing projects in our community. This creates a level of uncertainty that I think gets in the way of collaboration. So to me, section B of the EIS under subsequent studies is enough to make me have confidence that should something significant occur, there would be an EIS change anyways. Thank you.
Thank you, Councillor. And thank you, I should note that to Ms. Van Gaal and Mr. Stiver to put the motion up on the screen. And so it's right there. Anyone else wishing to speak to this amending motion? Seeing none, I'll call the question. All those in favor? Opposed? The amending motion is carried with Councillors Graham, McCallum, and Ma opposed. So now we have an amended policy. Would anybody wish to speak to the policy as now amended? I can say that I had pause when industry, who is very much affected by these changes, expressed some concerns. I think the amendment we made goes a long ways to addressing the most important of those concerns. I do hear their support for the intent of the policies and their encouragement to move towards the larger change. And so I guess if I am to support these changes, and there's some very good things in here, and it updates things. I would be very much encouraging of the larger update to happen sooner than later, so that we, and I know that that involves a scan with other policies, make sure there's consistency, et cetera. I would encourage that work because it seems like the industry is interested in participating in that as well. And I think that that's important work to be done. Councillor Faubert, you wish to speak to the policy as it's now
Yes.
presented?
Thank you, Your Worship. I am also in favor. I know that there were some other concerns, but that's part of the process. We review this policy every term of council, and this is the review for this term of council. And there are changes that I think are improvements, and we should move forward with them. The areas that are still remaining and that have been flagged by BODA, specifically like the terms of reference, that's work that can continue and doesn't need, we don't need to stop this policy version at this point in time in order to do that work at all. All of that can continue hand in hand, and I'm also really supportive of the continued project, the larger project, to look at how these are done in other jurisdictions. Thank you.
Thank you, Councillor Ma. Oh, wait, we can't hear you all of a sudden. I think you're mute, accidentally.
Thank you, Your Worship. Would it be possible to update the camera that shows all of you on the dais? You're frozen, so it's a little tricky for me to follow what's going on for the meeting.
Okay.
You guys are frozen.
If I can just understand, what is it that's frozen for you?
The group view that has all of you on it. I can see the occasion view where you're speaking, Mayor Krauser, but the group view, okay, that's better. Okay, I can see everyone now. Thank you.
Great, thank you. And did you wish to speak to the motion?
I feel there has been some good work that's been done on this policy, and I do feel flagging the need for more work, as noted, would be great to be done in an expedient manner when possible. Thank you.
Thank you, Councillor. Looking to see if anyone else wishes to speak to this motion. Okay, so then the revised motion is that Council approve Environmental Impact Statement EIS Policy PD-003 amended as amended. And I repeated that just because I wanted to say that. I will call the vote then. All those in favor? Carried unanimously. Thank you. Okay, so we are now into our last presentation. Thank you, everyone, for that work there. Items 10, 11, and 12, H10, 11, and 12 will all be presented at the same time here by Ms. Gibbons. Ms. Gibbons, welcome to the podium, and take your time. Whenever you're ready, the microphone is yours.
Trying to be as tall as Ms. Van Gaal. So for the sake of efficiency here, especially as we're at the end of a very busy day, this is a bit of a 3-for-1, and I'll be presenting all 3 of the policy amendments with respect to the finance policies in one presentation. The motions before Council for these 3 final agenda items are as follows. The Council approved Purchasing Policy FIN 006, amended as presented. The Council approved Debt Management Policy FIN 003, amended as presented. And the Council approved Tangible Capital Asset FIN 008 Policy, amended as presented. And also just kind of the order of these is, I'll go through them in this order. It also kind of approximates the magnitude of the relative changes, if I could, from my perception. The first one with the most significant amendments, I would say, is the purchasing policy. Some of the key amendments I wish to draw attention to is our inclusion of the Comprehensive Economic and Trade Agreement, or CETA, as part of the relevant international trade landscape. We've added a definition for emergency to provide clarity for the related provisions. We've specifically clarified that emergency purchases may bypass standard procedures with CAO approval. We've also added a new section and related definitions for considerations with respect to sustainable procurement and alignment with the Climate Emergency Action Plan, and that includes even a consideration of if the purchasing is in fact required. We've clarified roles and responsibility as there is some overlap but also distinctiveness between what are the roles specified in this policy versus what's specified in the designated officer's bylaw. We've added that exceptions must be documented with justification and that language in alignment with our current practice. And we've also added a new section specifying that vendors engaging in bribery, coercion, or unethical practices will be disqualified from current and future procurement opportunities. One of the other key amendments is actually looking to increase some of the thresholds within the policy. So these are our current purchasing policy thresholds. And I'll try to toggle back and forth a little bit between the two so you can see the key changes. On the goods and services side, we've moved that middle band from when an RFP is required from $25,000 up to $50,000. On the construction side, we've added a lower threshold where under $25,000, no competitive quote is required, more in alignment with what we had on the goods and services side. And then we've upped that middle band to $100,000, again, where that RFP is required. Again, the intent of purchasing these thresholds being increased is to encourage more bids and to increase efficiencies on our administrative side by simplifying the time we have and hopefully reducing the number of exceptions that we're currently experiencing where we don't receive the minimum number of bids. Moving on from the purchasing policy, bless you, to the debt management policy. We've cleaned up some numbering in the definitions section. We've clarified distinctions between the definitions for self-supported and tax-supported. We've also softened some language around retiring debt to honor the intent of the previous policy, but remove statements that things will happen. There were calculated thresholds in there. We want to honor the intent, but not specify that certain actions will be taken since dollar values can change over time. And we've also corrected some references to limits that were actually outdated and missed with the last update. Finally, for the tangible capital assets policy, we've done some general wording, punctuation, and section cleanup to provide greater clarity and enhance the readability of that policy. We adjusted the parameters for machinery and equipment to align with the description from the TCA toolkit from Alberta Municipal Affairs that we believe was the source of the original definitions. We've added some deemed disposal language for where we have grouped or pooled assets to clarify where it's impractical to keep an actual detailed listing. At the end of their useful life, we might take a deemed disposal approach. And in the appendix, we've grouped some water system asset classes, again, just for clarity and presentation purposes, really just some cleanup there. Those are the key amendments I wanted to cover, but I'm also happy to address any questions on anything else within those policies.
Thank you, Ms. Gibbons, for that presentation, for giving the review of all of these updates. Opening it up to any questions from council. I don't see any. Thank you very much. Okay, so for item H10, the purchasing policy, I will move that council approve purchasing policy FIN-006 amended as presented. Would anyone like to speak to that motion? Seeing none, I'll call a question. All those in favor? Carried unanimously. H11, debt management policy. I move that council approve the debt management policy FIN-003 amended as presented. Would anybody like to speak to this motion? Seeing none, I'll call the question. All those in favor? Carried unanimously. H12, tangible capital assets policy. I will move that council approve the tangible capital assets FIN-008 policy amended as presented. Would anybody like to speak to the motion? Seeing none, I'll call the question. All those in favor? Carried unanimously. I will now move that we adjourn. All in favor? Carried unanimously. Councillor Ma, thank you for joining us from afar, and enjoy the rest of your time. I expect it's